Section 16 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 4, Chapter 10b. Proposed Administration of Immigration and Naturalization. Nature of Functions. As conceived by the Commission, there are three major functions to be performed by administrative officials of the government in the field of immigration and naturalization. 1. Enforcement. This includes visa issuance, inspection and exclusion at ports of entry, policing, investigation, deportation, administrative prosecution, and the administration of the naturalization laws. 2. Adjudication. This includes the determination of cases and of their appeals within the administrative process. 3. Policy determination. This includes overall policy formulation, the issuance of regulations for allocation of visas within the statutory ceiling, subject to change by the President and disapproval by the Congress, and making reports and recommendations to the President and Congress. Another aspect of this problem relates more to attitude than to specific functions. The Commission is impressed by the suggestions it received that the administration of immigration laws should be such as to develop and maintain an atmosphere and spirit of friendship for immigrants. Whatever the cause, and often it is beyond the control of the administrative officials, the fact seems to be that the administrative procedures are unsatisfactory and are productive of unnecessary and wasteful delays and embarrassments at home and abroad. This factor is an important consideration in the development of any administrative structure in the field of immigration and naturalization. Location of functions. Throughout the course of federal immigration administration, there has been no certainty as to the proper place of immigration functions. Originally, immigration enforcement was assigned to the Treasury Department. In 1903, it was transferred to the Department of Commerce and Labor. It was moved to the Department of Labor in 1913, and in 1940 it was shifted to the Department of Justice. Through the years, immigration and naturalization functions have been handled either by two bureaus or by a single bureau. The review process was non-existent, then advisory, later part of the Immigration and Naturalization Service, and finally directly under the head of the department. Additional proposals to shift immigration and naturalization functions from the Department of Justice to another agency have been made from time to time. During the Commission's hearings, there was a diversity of sentiment on this subject. Some proposed that the Immigration and Naturalization Service be returned to the Department of Labor. Others suggested that a new agency be created. Still others urged that the matter be let alone. The Commission's recommendations introduce a new function, not now vested in either of the two departments. This new element, the allocation of visas, requires reconsideration of the entire matter, since it is no longer a question of old functions remaining in Justice or State Department, but rather where new and consolidated immigration functions are to be placed. The Commission has already expressed agreement with the Hoover Commission that it is inappropriate to put these functions in the Department of State. In its recommendation that they be assigned to the Department of Justice, the Hoover Commission naturally did not consider the proposed new functions of visa allocation. It may be argued that these combined functions should be vested in the Department of Justice because the immigration law involves responsibilities related to the national security and that these logically fit into the Justice Department's sphere of activity. The Commission believes, however, that the arguments to the contrary are more persuasive. Presumably, the primary security tie to the Department of Justice would be the necessity of close relationship with the Federal Bureau of Investigation. Actual practice, however, does not justify such an argument. The Immigration and Naturalization Service conducts its security functions through its own investigative unit, which is completely separate from the Federal Bureau of Investigation. Its liaison with the Federal Bureau of Investigation could be just as close if the two investigative units were in different agencies. Furthermore, security functions concerning immigration were performed effectively by the Displaced Persons Commission and were closely related to the Federal Bureau of Investigation, the Central Intelligence Agency, and the Immigration and Naturalization Service, although the Displaced Persons Commission was an independent agency. The Department of Justice is primarily a litigating and prosecuting agency. It includes the Federal Bureau of Investigation and the administration of federal prisons, but these are natural arms of its prosecuting functions. There seems to be no good reason why the Department of Justice should be concerned with such matters as the allocation of visas to such preferential groups as may be authorized by Congress, with the issuance of visas to individual applicants abroad, and the subsequent operations at ports of entry, or with citizenship education. None of these matters has any real relationship to the normal operations of the Department of Justice. The added responsibilities proposed by this commission remove it further from such relationships. On the other hand, there is every reason why many determinations made under immigration and naturalization laws should be removed from control by the Department of Justice. The Immigration and Naturalization Service has its own legal staff, separate from the various divisions of the Department of Justice, and conducts such matters in the same manner and to the same extent as do other departments of the federal government. If the existing and proposed new functions were combined in an independent agency, the Department of Justice would continue to handle at higher levels litigation originated in or with the independent agency in the same manner as is now done for other departments and agencies. There are those who believe that one of the present causes of criticism of the immigration laws stems from the fact that the administration of those laws is centered in a prosecuting and litigating agency. No sound argument has been advanced for keeping it where it is. The new and combined functions do not properly fit in the Department of Justice. Nor is the Commission convinced by those who urge returning the immigration authority to the Department of Labor. This is not to say that the Department of Labor has no interest in the subject, but the major aspects of immigration and naturalization policy and administration are largely unrelated to the responsibilities of the Department of Labor. Furthermore, the immigration policy of the United States cannot be based solely upon manpower or labor considerations, although such factors are undeniably important. Another suggestion is that immigration and naturalization functions should be located in the Federal Security Agency. That agency already plays a role in the immigration process through the medical examinations of immigrants by the Public Health Service, and because of the requirement of the Act of 1952 for reports on Social Security information for the Immigration and Naturalization Service. It is argued that such a change would be desirable in the light of the Federal Security Agency's interest in people as such, whether aliens or natives. The fact is, however, that the administration of the consolidated immigration and naturalization functions, coupled with the new responsibility for visa allocations, does not properly belong in any existing department or agency. It touches upon many, must work closely with some, but really has no basic connection to the primary responsibilities discharged by any of the other departments and agencies. The result is that the problems relating to immigration and naturalization do not command adequate thought and attention of the cabinet officers under whom either the Immigration and Naturalization Service or the Visa Division have been placed. Independent agency. This leaves only one other alternative, an independent agency. As a general proposition, the Commission recognizes government administration should be organized within departments under the supervision of cabinet officers. But this administrative design gives way to the principle that in a democracy, content should prevail over form. And so the Congress has established the Interstate Commerce Commission, the Federal Power Commission, and the Federal Communications Commission, among others which are not within cabinet departments. These agencies, as with the proposed Consolidated Immigration Agency, exercise legislative, quasi-judicial, and administrative functions. Everyone will agree that the interests of the people are best served by that form of governmental administration which most effectively accomplishes the governmental purpose, and not that which is motivated purely by administrative expediency. The Commission believes that the major immigration functions described in this report can be performed most effectively through an independent agency. The duties are so important, particularly in connection with the visa allocation authority, that the public interest requires a definite pinpointing of responsibility, as well as the full-time attention which a cabinet officer cannot give. The Commission believes that the creation by Congress of a new and independent immigration agency will assure the development of that fresh approach needed to change our immigration policy from a negative to a positive force. The expert study, knowledge, and experience required for visa allocation decisions and for reports to the President and Congress, coupled with other proposed new and highly important administrative and appellate duties and powers, make it advisable, if not mandatory, that such authority be exercised by an independent agency headed by a commission. Commission on Immigration and Naturalization. The Commission recommends the establishment of a new and permanent Commission on Immigration and Naturalization to have control and supervision over the entire field of immigration and naturalization. This proposed commission would be composed of 3, 5, or 7 members, as Congress may determine. They should be appointed by the President, subject to Senate confirmation. Under this proposed commission, there would be an administrator of immigration and naturalization, appointed by and responsible to that commission, and who would be charged with all phases of administration and enforcement. Completely separate from the administrator, but also appointed by and responsible to the proposed commission, would be a Board of Immigration and Visa Appeals. That board would have final authority to make necessary administrative adjudications in exclusion and deportation cases, subject only to a limited appeal to the proposed commission in cases involving the exercise of discretion, but not on questions of law or fact, whenever that commission agrees to accept such appeals. In addition to exclusion and deportation cases, the board would hear appeals in visa cases and would also determine whether an alien may be excluded without a hearing in security cases in the manner described in Chapter 15. The Commission believes that such a plan would mark an important advance from the existing scheme of organization. It would produce much more effective and coordinated administration and would assure the required high-level consideration of allocations to be made within the unified quota system. It would bring the immigration process into line with the separation of functions contemplated by the Administrative Procedure Act, generally recognized as the norm of fair administrative organization. If this Commission's recommendation for the creation of an independent Commission on Immigration and Naturalization is adopted, provision should be made for the personnel now employed by the Immigration and Naturalization Service and by the Visa Division, performing functions affecting immigration in Washington and in the consular offices overseas. The present employees of the Immigration and Naturalization Service should be transferred to the proposed commission and assigned duties under the proposed Administrator of Immigration and Naturalization. Present staff of the Board of Immigration Appeals and hearing examiners of the Immigration and Naturalization Service should also be transferred to the new Commission and assigned to duties under the proposed Board of Immigration and Visa Appeals. The transfer of personnel working on visa matters in the Department of State and exercising the visa function abroad likewise should present no serious difficulty. It should be ascertained which employees in the Bureau of Security and Consular Affairs and which of our consular officers in foreign countries are engaged primarily in visa activities. Such employees should be transferred to the new Commission. Moreover, any transfer of personnel from the Department of State and the Department of Justice to the new Commission should be made without prejudicing any status, rights, or privileges of such employees. All pertinent records and files should be transferred to the proposed Commission, along with the transfer of functions and staff now vested in other agencies. Chart 2 portrays the plan of organization suggested by the Commission. Chart 2. Proposed Administrative Agency. Commission on Immigration and Naturalization. 1. Makes visa allocations subject to review by President and Congress. 2. Makes study of all phases of immigration and naturalization and sets policy. 3. Reports periodically to the President and Congress on immigration and related matters. 4. Supervises the Administrator of Immigration and Naturalization. 5. Reviews decisions of the Board of Appeals on questions involving exercise of discretion in cases in which it agrees to accept such appeals. Administrator of Immigration and Naturalization. In charge of all activities relating to the administration and enforcement of the immigration and naturalization laws, including 1. Visa issuance overseas, 2. Preliminary inspection at port of entry, 3. Investigations, 4. Physical detention and deportation, 5. Border patrol, 6. Administration of naturalization process, 7. Citizenship education, 8. Preparation and presentation of evidence before hearing officer and board, 9. Routine determinations in cases not requiring hearings, 10. Preparation of materials for Commission's use in making visa allocations. Board of Immigration and Visa Appeals. 1. All appeals from hearing officers. 2. All appeals in visa cases. 3. All final determinations that hearing on exclusion is to be denied on confidential information. 4. Such questions as are referred to the Board by the Commission for advanced determination. Hearing officers. Conduct administrative hearings and make determinations in exclusion and deportation cases and in all quasi-judicial matters arising under immigration and naturalization laws. End of Section 16. Recording by Maria Kasper. Section 17 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 4, Chapter 11A. Fair Hearing and Procedure. Americans treasure a person's privilege to fair consideration in proceedings conducted by a government official. The concept of fair dealing is enshrined in the Bill of Rights, which guarantees that no man shall be deprived of his liberty without due process of law. It is rooted in centuries of solid experience in Anglo-Saxon law. Testimony given at the Commission's hearings contains complaints by reliable witnesses to the effect that important aspects of our procedure for the consideration of applications by aliens to come into and of their right to remain in the United States are not fair. There are several problems which arise in this connection. First, the present lack of any formal review of a consular denial of a visa. Second, the adequacy of the procedure for review of exclusion and deportation orders. And third, the nature of court review of administrative decisions. Each of these problems involves the fairness of consideration given to an alien. The Commission recommends review of consular decisions, that the denial of a visa to enter the United States should be subject to review by a Board of Immigration and Visa Appeals. Fair hearing and procedure in exclusion and deportation, that a Board of Immigration and Visa Appeals be established by statute to be concerned exclusively with the adjudication of cases arising under the immigration laws, that hearing examiners in exclusion and deportation cases be separated from enforcement functions and placed under the supervision of the Board of Immigration and Visa Appeals, that deportation hearings be conducted in conformity with the Administrative Procedure Act, that the caliber of hearing examiners be improved. Judicial review, that an exclusive statutory form of judicial review be established in deportation cases, that habeas corpus continue to be the form of judicial review in exclusion cases, that there be no judicial review of actions denying a visa, that the courts be specifically authorized to decide whether denials of bail pending determination of deportability are arbitrary or illegal. Review of consular decisions. The preponderance of the testimony before the Commission is to the effect that in giving complete and unreviewable authority to consular officers, the law and practice fail to conform with traditional American reliance upon fair hearings as a safeguard against abuse of power. Present system. Under the present system, the consul occupies a unique position in American law and practice. By express provision of law, no one can review his decision on a visa application. The Secretary of State is charged with the general administration of the statutory provisions relating to the duties and functions of diplomatic and consular officers of the United States. However, the Secretary of State has no power to control or direct the consuls in certain visa activities. The Act of 1952 made crystal clear the finality of the consular officer's power in visa issuance by specifying that the Secretary of State could control all consular activities except those powers, duties, and functions conferred upon the consular officers relating to the granting or refusal of visas. It was repeatedly testified at the Commission's hearings that such administrative absolutism was unparalleled in the whole range of American law. In the Senate Judiciary Committee's study, the chief purpose for vesting such complete authority in a subordinate official doubtless was the committee's desire to place additional barriers in the way of undesirable aliens, additional fences of protection which the alien must surmount. The committee evidently was unconcerned with the desirable aliens whose application might be improperly or unfairly denied if the consul's decisions were not reviewed. The committee stated, "The subcommittee concludes, however, that to allow an appeal from a consul's denial of a visa would be to make a judicial determination of a right, when, in fact, a right does not exist. An alien has no right to come to the United States, and the refusal of a visa is not an invasion of his rights. Permitting a review of visa decisions would permit an alien to get his case into United States courts, causing a great deal of difficulty in the administration of the immigration laws." Every witness before the Commission who discussed the consul's absolute authority criticized it without reservation. The chairman of the Committee on Immigration and Naturalization of the Administrative Law Section of the American Bar Association said, "It has become a fundamental premise of our jurisprudence that the decision of weighty matters should almost never be placed in the power of a single individual free from the control of a superior reviewing body. We search in vain for any parallel in our institutions for this despotic consular absolutism. Relatively few decisions, even of federal judges, are free from the possibility of appellate revision. But the consul is not only immune from review, but from any other kind of check, even of publicity. If there is such a thing as an axiom of law, it is that where there is power, there must be safeguards against the abuse of power. We have no doubt that consuls, as a group, are as conscientious and honorable as any other group of government officials. We may even assume that they are much more so. Still, it is indefensible to give any man, acting in secret in a remote land, autocratic power to grant or withhold a privilege of such enormous value as that of entrance to this country. Issuance or denial of a visa frequently involves complicated legal problems of eligibility and determinations of foreign law, such as whether a crime has been committed. Yet, as stated elsewhere, only 3% of consular officials are attorneys. Consular officials are required to decide whether a prospective immigrant is likely to become a public charge, medical questions, complicated security issues, occasionally involving knowledge of foreign political, economic, and social movements, and a host of other issues involving technical knowledge and the wise exercise of discretion. And yet, the visa-issuing consular officers are generally junior and subordinate officers in our consulates. An assignment to visa-issuing duties is not always regarded as a desirable post within the Foreign Service. The Commission finds no persuasive reason why the determinations of a consular officer in visa cases should not be reviewed. The Commission assumes that all consular officers are loyal, disinterested public servants, but human beings do err in interpreting law and assessing facts. It is undesirable to permit the possibility of control of human destinies by caprice, prejudice, or mistake, subject to no regulation or review. The Commission is informed that existing practices permit some opportunities for informal reconsideration. However, such reconsideration, which is generally limited to aliens who are able to interest sponsors, attorneys, or members of Congress in their case, is palpably inadequate. The Commission recommends that a formal appeal procedure be established by statute, giving opportunity for appeal on the denial of a visa. Precedents for review of consular action. The Commission has sought advice from those urging such review as to the methods by which it should be established. The Commission is convinced that there are no substantial practical difficulties to be encountered in establishing such a review procedure, which cannot be easily overcome. As a matter of fact, procedures have been established in comparable situations which are precedents for the Commission's recommendations. World War II Visa Review Procedures. Elaborate procedures to review applications for visas were in effect during World War II. Under such procedures, with few exceptions, all visa applications of aliens seeking to enter the United States, whether for temporary or permanent stay, had to be submitted in advance for central clearance in the Department of State. Such consideration was limited to security factors, and the determination was only as to whether the entry of the applicant would be prejudicial to the safety of the United States. The procedure for such review of prospective visa action required the alien to submit detailed information in writing. In addition, the review agencies had a complete record which included such items as recommendations from the consular officer handling the case abroad, intelligence reports bearing upon the alien concerned, statements and affidavits from the sponsor and others, and miscellaneous information regarding the alien and his sponsors. 3 distinct visa review bodies were set up in this wartime procedure. The first was composed of interdepartmental committees comprising one representative from the Departments of State, War, and Navy, from the Federal Bureau of Investigation, and the Immigration and Naturalization Service. These committees made recommendations to the Secretary of State. If accepted, they were sent on to the visa-issuing officers as advisory opinions. If rejected, the cases went on to the second link in the chain of review procedures, the Interdepartmental Visa Review Committees, composed of representatives of the same government agencies involved in the first committees. Here, oral argument and representation by attorneys was allowed. If the committee's opinion in any case was accepted by the Secretary of State, it became the department's advisory opinion. If not, the matter was referred to the third and last stage, the Board of Appeals on visa cases, which considered the whole file. The Board of Appeals was composed of 2 persons appointed by the President with an alternate. It held no hearings, and cases were decided on the basis of the written records, including statements and other materials available to the other review committees. The Board of Appeals operated for about 3.5 years, from November 1941 to June 1945, and made definitive recommendations in 22,622 cases. In only 1 case did the Secretary of State not follow its recommendation. In over 73% of the cases, the Board of Appeals affirmed the Interdepartmental Visa Review Committees. In 26% of the cases, it recommended in favor of the visa applicant after the review committee had recommended otherwise. Present visa review procedures. Information supplied by the Chief of the Visa Division in the Department of State indicates that there is now in existence an informal procedure to review determinations in visa cases, both in advance of such determinations and after they are made. One entails a review by the Visa Division of the Department of State of visa cases still in the course of processing at a consular post abroad prior to final action by the visa officer. In certain categories of cases, such a review is mandatory. The other entails a review by the division after final action has been taken by a visa officer in issuing, or much more often in refusing issuance of a visa. Any visa case still under active consideration and before final consular action has been taken is reviewable either by the visa officer concerned or his superiors in the field, or by the visa division upon request of the applicant or persons interested in his behalf, upon presentation of good and sufficient reason. However, it is comparatively rare that such a request will be made by the applicant or other interested parties while the case is in progress. Although in theory there is a review of consular action prior to final determination, in practice this is a reconsideration requested either by the consul or his superior in the nature of purely administrative supervision, and not a review requested by the applicant immigrant. The Chief of the Visa Division of the Department of State also advised the Commission of the procedures in effect concerning cases in which action has already been taken on a visa application. In cases of refusal, where there is more than one consular officer at a post, the refusals may be reviewed by such second officer, as well as by the supervisor. All refusals of visas are reported to the department with explanatory information. In addition, upon request by members of Congress, attorneys, or other individuals on behalf of an alien, the case may be reconsidered in the Visa Division. However, there is no established or published procedure for the reconsideration of final consular action denying visas, nor any power to reverse the original decision. Occasionally, the file is sent for, and then each case is handled as a specific problem. But in any event, this review process is inadequate, because at most it can only result in an advisory opinion, and the issuing consul cannot be directed to reverse his determination. These two so-called review practices are not in any sense appellate reviews. Rather, they partake largely of the nature of management or administrative, supervisory, and reporting devices. Neither procedure meets the normal requirements for fair administrative review of decisions, for the following reasons. 1. The alien is not given a right of review in his case. 2. There is no definite review or appellate procedure. No specific review panels, appeal boards, or other similar formally established bodies function. If there is any review at all, it may be made individually by an officer of the division, or by the chief of the division, or by an ad hoc panel of several division officers, depending upon the importance or complexity of the case. 3. There is no published information on the opportunity for such review or the steps to be taken to obtain it. The procedure is based on unpublished departmental instructions to its staff. 4. The consul is not bound by the advisory opinion. If the existence of these generally unknown and diverse methods of review have any value in this connection, it would seem that they are precedents for the creation of a more formal and improved review, one that would meet the test of fairness. One of the administrative problems to be solved in establishing a formal review procedure is the nature of the record upon which such review can be had. This problem apparently has been satisfactorily solved in the existing procedure for reconsideration of consular action. In such instances, the record of a case submitted for reconsideration consists for the most part of the applicant's dossier. This includes the data relating to him personally, biographical information and background data, together with statements offered in his behalf by interested parties, recommendations by the visa officer abroad, and in general all material which bears directly upon the issue which enables the reviewing authority to formulate a reasoned advisory opinion. If the case is being reviewed on security grounds, the record must contain all data obtainable which relates to the applicant's status as a possible security threat, including intelligence agency reports and results of other investigatory bodies' inquiries. If the financial responsibility of the sponsor is in doubt, then the record will include all possible available data relating to his financial status, so that the reviewing authority may decide if sufficient financial ability and responsibility is indicated. Review of cases involving claims to American citizenship. In addition to the precedents and procedure for reconsideration of consular visa actions, there also are procedures to review consular actions in connection with passports. 1. Board of Review. Since 1941, procedures have been available in the Department of State permitting review of consular decisions denying passports. A Board of Review in the Passport Division was then established to consider appeals which deny an American passport to a person abroad claiming United States citizenship. The Board of Review has adopted no formal rules of procedure. The persons concerned may have their cases considered upon the basis of the material constituting the existing record, plus any additional evidence they may desire to submit, or they may request a formal hearing at which witnesses may appear and the interested person may be represented by an attorney. The Commission is informed that the facts in the Department's possession are disclosed in such hearings, and that the person concerned is given full opportunity to present his case. 2. Board of Passport Appeals. As a result of considerable public criticism of the procedures of the Department of State in denying passports for security reasons, echoes of which appeared in the testimony before the Commission by some of our outstanding scientists, a Board of Passport Appeals was established by the Department of State in August of 1952. Provision is made for tentative disapprovals of passport applications, accompanied by notice in writing of the tentative refusal and of the reasons on which it is based, as specifically as in the judgment of the Department of State secrecy considerations permit. The applicant is entitled to appeal to a hearing officer of the Passport Division, to be represented by counsel, and to submit affidavits and other evidence. If the decision of the Passport Division is adverse, the applicant is informed of such action and of his right to appeal to the Board of Passport Appeals. The Board is authorized to publish its rules of procedure and accords the applicant the right to a hearing and to representation by counsel. This Board's jurisdiction includes appeal from actions by consular officers in denying passports for reasons of national security. The Board of Review has jurisdiction to review actions by consular officers denying passports because of doubts as to American citizenship. 3. Denials of certificates of identity. The law provides for the issuance of a certificate of identity to a person in a foreign country whose claim to United States citizenship is rejected and who desires to proceed to the United States in order to attempt to obtain a judicial declaration confirming his claim to American citizenship. The statute specifically provides that such an individual is entitled to appeal to the Secretary of State from a decision of a consular officer denying a certificate of identity. Where a consular officer refuses a certificate of identity and an appeal is taken to the Secretary of State, the case is reviewed in its entirety by the Passport Division. These precedents indicate the feasibility of procedures for reviewing consular actions on visa applications. Recommendations. The Commission is convinced that there is no substantial reason for continuing the present system under which the consular officer's determinations in visa cases are final and not reviewable as of right. The Board of Immigration and Visa Appeals, the creation of which is proposed by this Commission, should have the statutory authority to review all denials of visas, with full authority to reverse such actions and direct issuance of visas. Where a visa is denied, either formally or informally, the alien should be informed in writing of the basis for such denial and of his right to have the matter reviewed by the proposed Board of Immigration and Visa Appeals. Upon the filing of such an appeal by an alien with a visa-issuing officer, the latter should be required to forward to the Board a written report accompanied by any pertinent affidavits or documents describing the facts and the basis for his action. There should be no requirement of a formal hearing before the visa-issuing officer. The alien should not be authorized to come to the United States merely for the purpose of presenting his appeal. The alien should be entitled to know the grounds for refusal, except such as are determined by the Board to be unavailable for security reasons. The alien should be entitled to representation by counsel before the Board. End of Section 17. Recording by Maria Kasper. Section 18 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 4, Chapter 11b. Fair Hearing and Procedure in Exclusion and Deportation. Consular decisions concerning a visa take place outside of the United States and before an alien has severed his ties abroad. Immigration authority decisions on exclusion take place when the alien reaches the shores or borders of this country. Orders of deportation affect aliens already resident in the United States. Current hearing procedures. Exclusion. Examination upon arrival. No alien may legally enter the United States unless he undergoes examination and inspection by the Immigration and Naturalization Service acting for the Attorney General. Since 1893, Congress has provided for administrative hearings in cases of arriving aliens whose admissibility to the United States is questioned. The courts have declared that such hearings, whenever provided, must be fairly conducted and that exclusion can be ordered only on statutory grounds. Each such hearing is conducted by a special inquiry officer. Previous to December 24, 1952, the effective date of the Act of 1952, the hearings were conducted by 3-member boards of special inquiry stationed throughout the United States. The procedure on the alien's arrival is set out in considerable detail in the statute. If the alien's right of entry is in doubt, the immigration officer may order his temporary removal for detention at a designated place, but such removal is not considered a landing in the United States. If the immigration officer questions the applicant's right to enter, he must refer the case to a special inquiry officer for a hearing. Proceedings before the special inquiry officer are conducted under oath, and his determination must be based solely on the evidence produced at the inquiry. At such hearing, the alien may be represented by counsel. A complete record is made of the proceedings and of all evidence produced by the government and by the alien. The alien has a right to appeal to the Board of Immigration Appeals in the Department of Justice from the exclusion order of the Special Inquiry Officer. The filing of an appeal stays the execution of the exclusion order until a final decision is rendered. The decision on appeal must rest solely on the evidence adduced before the Special Inquiry Officer. Decisions of the Board of Immigration Appeals may be certified to the Attorney General for further review in exceptional cases upon request of the Attorney General, the Board, or the Commissioner of Immigration and Naturalization. Simultaneously with the inspection by immigration officers, persons seeking to enter the United States are required to undergo a physical and mental examination by medical officers of the United States Public Health Service. Generally, the determinations of medical officers are subject to review only by a board of medical officers of the Public Health Service. Aliens whose exclusion is finally ordered by immigration or medical officers must be deported immediately to the country whence they came, at the expense of the transportation line which brought them. Deportation. Although some form of hearing has always been available to persons subject to deportation, no express provision existed in the statute until 1952. Nevertheless, the Supreme Court has held that a requirement for a fair hearing necessarily was implicit in the immigration law relating to deportation. The Court has held that the provision of the Fifth Amendment, that no person shall be deprived of his liberty without due process of law, applies to all persons in the United States, citizens and aliens alike. This guarantees to each alien in the United States, whether he be lawfully or unlawfully here, a fair hearing before his deportation can be ordered. Deportation is not regarded as criminal punishment. However, it often entails great hardship. Consequently, the courts have insisted that deportation hearings must conform most scrupulously to the highest standards of fair play. Under the 1952 statute, when a preliminary investigation indicates that an alien may be subject to deportation, an application is made for the issuance of a warrant of arrest. Such warrants of arrest are issued only upon a determination that probable cause for deportation exists. When the alien is arrested, he is furnished with a copy of the warrant of arrest and notified of his right to counsel and release under bond. In virtually every case, the alien is released under bond. The hearing takes place before the Special Inquiry Officer, who is authorized to administer oaths, present and receive evidence, interrogate, examine, and cross-examine the alien or witnesses, and to make a determination as to the alien's deportability. In any case or class of cases designated by the Attorney General, An additional immigration officer may be assigned to present the evidence on behalf of the United States before the Special Inquiry Officer. The statute directs that the alien shall be given reasonable notice of the charges against him, that he shall have the privilege of being represented by counsel, as well as a reasonable opportunity to examine the evidence against him, to present evidence in his own behalf, and to cross-examine the government witnesses. No order of deportation is valid unless it is based upon substantial evidence in the record of the hearing. The alien is entitled to appeal to the Board of Immigration Appeals from an adverse decision of the Special Inquiry Officer. A decision of the Board of Immigration Appeals is subject to review by the Attorney General only when such review is requested by the Attorney General, by the Board, or by the Commissioner of Immigration and Naturalization. If the alien's deportation eventually is ordered, he is taken into custody under a warrant of deportation, if not already in custody, and deported. The issues. The ordinary test applied to a law or to a procedure is not what is done under it, but what may be done. Only in that way is it possible to determine whether it is open to abuse. Authorities in legal fields have long condemned procedures under which the same officials, or officials acting under the same administration, appear as complainants, as witnesses on their own complaints, and finally as judges to determine the result. The main issue here is whether reviews or appeals from the initial findings should be decided by officers not directly connected with those responsible for such findings. The issue here involves proposals for an independent appeals board, the separation of prosecuting and judicial functions, and provision for independent hearing examiners. Past studies of immigration procedures. During the last 40 years, there have been at least 8 appraisals of this issue by various individuals and groups. In general, they have dealt with the separation of judicial and enforcement functions and with the caliber of the hearing officials. The Hoover Commission on Law Observance and Enforcement. A major study of immigration procedures was prepared by the so-called Wickersham Commission in 1931, the enforcement of the deportation laws of the United States. One of the principal criticisms in the Wickersham report was addressed to the practice of having the immigrant inspector perform the combined duties of investigator, prosecutor, judge, and enforcement officer. The report was critical of the Board of Review, since reorganized as the Board of Immigration Appeals, on the ground that it was not a statutory board and was the creature of the Secretary of Labor, who was authorized also to enforce and administer the immigration laws. It observed, additionally, that the board lacked necessary discretionary power to alleviate hardships. In its conclusions and recommendations, the report sharply criticized the system of administration under which one agency of the United States government acts as investigator, prosecutor, and judge with despotic powers. It recommended that a. The Department of Labor should be charged only with the duties of investigation and prosecution of aliens unlawfully in this country and of execution of warrants of deportation when issued. D. An independent board with some name such as the Board of Alien Appeals should be created, composed of men of judicial caliber, to be appointed by the President. This board should be charged with the duties of issuing warrants of arrest, of conducting hearings on the warrants, and of deciding when warrants of deportation should be issued. Its findings should be published. E. The Board of Alien Appeals should have discretion to allow even deportable aliens to remain in this country, where deportation would result in unnecessary hardship to American families, or is otherwise found to be inadvisable. Discretion should also be given to admit aliens previously deported. F. This board should have broad powers in effecting its own organization. It should have the right to appoint subordinate officials, such as masters or examining attorneys. These appointees would act as officers of the board in the different localities and would be under its sole jurisdiction. Van Vleck Study. This study, The Administrative Control of Aliens, published in 1932 under the auspices of the Commonwealth Fund, was made by Dean William C. Van Vleck of George Washington University Law School. It criticized various exclusion and deportation procedures. It strongly objected to the combination in the immigration hearing officers of the functions of investigation, prosecution, and adjudication. It pointed out that few of the inspectors had legal training. It recommended that the personnel of boards of special inquiry be improved, that the Board of Review be given statutory authority, and that deportation be made a judicial rather than an administrative process. President's Committee on Administrative Management. This group made the next major study of administrative procedure. While its scrutiny was not aimed directly at the immigration process, its report criticized the mixture of administrative and adjudicative functions in government agencies. It observed that such mixed duties constitute an unwholesome atmosphere in which to adjudicate private rights. The committee also pointed out that the same men are obliged to serve both as prosecutor and as judge. This not only undermines judicial fairness, it weakens public confidence in that fairness. The Dimmock Committee. Probably the most comprehensive analysis and criticism of immigration procedures was that made by the Secretary of Labor's Committee on Administrative Procedure, the so-called Dimmock Committee, which was appointed in 1938 and made its report May 17, 1940. The report pointed out that the serious problem in deportation administration is bias or suppression of bias resulting from confusion of function, which was a consequence of imposing upon the same inspector not only the duty of presiding over the hearing, but of actually prosecuting it. The committee also spoke of the need for a public guarantee of real insulation and independence of the inspectors who sit as trial examiners, and remarked, "To assure to every alien in a contested proceeding a fresh hearing before an official with the special experience, standing, and point of view of an administrative judge would do much to minimize the dangers of abuse." The committee said, "We recommend that the presiding inspectors be relieved of their present duties of presenting the case against aliens and be confirmed entirely to the duties customary for a judge. This, of course, would require the assignment of another officer to perform the task of prosecuting attorney. A genuinely impartial hearing, conducted with critical detachment, is psychologically improbable, if not impossible, when the presiding officer has at once the responsibility of appraising the strength of the case and of seeking to make it as strong as possible. Nor is complete divorce between investigation and hearing possible so long as the presiding inspector has the duty himself of assembling and presenting the results of the investigation. Considerations such as these have led the overwhelming majority of other federal administrative agencies to adoption of the practice here proposed. Finally, the report urged the need to attract personnel who have the fresh outside viewpoint which this ingrowing immigration and naturalization service so badly needs. Attorney General's Committee on Administrative Procedure. This committee made a comprehensive study of all government processes, not limited to procedures in immigration cases. Its final report, submitted in 1941, stated that it had not undertaken a study of the Immigration and Naturalization Service because the Secretary of Labor's committee had just completed an exhaustive analysis. However, the Attorney General's Committee likewise criticized the practice of combining the prosecuting and adjudicating functions in government agencies and stated, A man who has buried himself in one side of an issue is disabled from bringing to its decision that dispassionate judgment which Anglo-American tradition demands of officials who decide questions. Clearly, the advocate's view ought to be presented publicly and not privately to those who decide. These types of commingling of functions of investigation or advocacy with the function of deciding are thus plainly undesirable, but they are also avoidable and should be avoided by appropriate internal division of labor. For the disqualifications produced by investigation or advocacy are personal psychological ones which result from engaging in those types of activity, and the problem is simply one of isolating those who engage in the activity. Creation of independent hearing commissioners insulated from all phases of a case other than hearing and deciding will, the committee believes, go far toward solving this problem at the level of the initial hearing, provided the proper safeguards are established to assure the insulation. A similar result can be achieved at the level of final decision on review by the agency heads by permitting the views of the investigators and advocates to be presented only in open hearings, where they can be known and met by those who may be adversely affected by them. The committee also considered the advisability of completely severing adjudication from prosecution by creating separate agencies to handle each. It concluded that this would be too costly and cumbersome, and that the most feasible arrangement would be the severance of prosecuting from adjudicating functions within the agency itself. The Senate Judiciary Committee study. The inquiry of the Senate Judiciary Committee, which preceded enactment of the Immigration and Nationality Act of 1952, was intended as a full and complete investigation of our entire immigration system. However, in the voluminous report issued by the Senate Judiciary Committee at the completion of its inquiry, the committee merely described the prevailing exclusion and deportation processes. It submitted no recommendation for change in the deportation procedures. In regard to the exclusion process, it recommended merely that the three-man Board of Special Inquiry be reduced to one officer. Several studies also dealt with the problem of the caliber of hearing officers. The Immigration Commission of 1907 submitted its report in 1911. Its recommendations included one to strengthen the certainty of just and humane decisions in doubtful cases at ports of entry. This it sought to accomplish by urging that the boards of special inquiry should be composed of unprejudiced men of ability, training, and good judgment. The character of these boards should be improved. The Jane Perry Clark study of 1931, Deportation of Aliens from the United States to Europe, urged statutory recognition for the Board of Review and that its members and personnel be required to have legal training and higher qualifications. The Administrative Procedure Act. A dominant note in many of these inquiries is their criticism of the failure to establish a clear division between the prosecuting and adjudicating functions of immigration officers. Such a severance has never been completely accomplished. Consequently, it is significant that a major zone of controversy in immigration matters during recent years has been the issue as to whether the procedural requirements of the Administrative Procedure Act should apply to immigration proceedings. The Administrative Procedure Act was enacted in 1946. It resulted from many years of debate and study concerning the need for improvements in federal administrative justice. At the heart of this legislation, intended as a broad charter to govern the procedure of all federal agencies, were its provisions for safeguarding the independence of hearing examiners. It provided that such examiners should be appointed for each agency only by the Civil Service Commission, that such examiners should perform no duties inconsistent with their duties as examiners, that their compensation should be prescribed by the Civil Service Commission independently of agency ratings or recommendations, and that they should be removable only for cause upon the determination of the Civil Service Commission. Moreover, the statute prohibited private consultation by examiners with agency officers, forbade officers engaged in investigative and prosecuting functions in a case from engaging in the decision of that case, and directed that no hearing officer should be responsible to any other officer engaged in prosecuting or investigating functions. These latter provisions are not applicable to the agency itself or members of the body comprising it. Recognizing the widespread mixture of prosecuting and adjudicating functions found in many federal agencies, the Administrative Procedure Act sought to achieve a limited separation of these functions within the framework of agency operations, and a substantial degree of independence in each agency's hearing examiners. According to the Supreme Court, the major purpose of the Administrative Procedure Act was to curtail and change the practice of embodying in one person and agency the duties of prosecutor and judge. The statute did not effect a complete divorce of prosecuting and adjudicating functions, but its directives were intended, no doubt, as a long step in the direction of that goal. The Department of Justice took the position that the requirements of the Administrative Procedure Act were not intended to govern immigration proceedings. This resulted in litigation, which eventually culminated in the Wong Yang Sung case, where the Supreme Court concluded that deportation hearings were amenable to the Administrative Procedure Act. In its opinion, the court declared, "The Administrative Procedure Act did not go so far as to require a complete separation of investigating and prosecuting functions from adjudicating functions, but that the safeguards it did set up were intended to ameliorate the evils from the commingling of these functions as exemplified here is beyond doubt. And this commingling, if objectionable anywhere, would seem to be particularly so in the deportation proceeding, where we frequently meet with a voteless class of litigants who not only lack the influence of citizens, but who are strangers to the laws and customs in which they find themselves involved, and who often do not even understand the tongue in which they are accused. Nothing in the nature of the parties or proceedings suggests that we should strain to exempt deportation proceedings from reforms in administrative procedure applicable generally to all federal agencies. The Supreme Court decision dealt only with deportation hearings. The Supreme Court has not yet passed upon the applicability of the Administrative Procedure Act to exclusion hearings. However, the lower federal courts found the requirements of that statute inapplicable to such exclusion hearings. However, the Congress, in a rider to an Appropriation Act enacted on September 27, 1950, negated this Supreme Court decision by a statutory exemption of exclusion or expulsion of aliens from the provisions of the Administrative Procedure Act. The Immigration and Nationality Act of 1952 does not deal directly with the Administrative Procedure Act. It repeals the Appropriation Act rider, which specifically exempted immigration procedures. However, other directives of the statute forge a pattern which reveals an unmistakable purpose to exempt immigration hearings from the procedural requirements of the Administrative Procedure Act. Thus, Sections 236 and 242 specify that exclusion and deportation hearings are to be conducted before special inquiry officers, and that the procedure described in the statute shall be the sole and exclusive procedure for determining an alien's right to enter or remain in the United States. Moreover, Section 101(b)(4) defines a special inquiry officer as any immigration officer who the Attorney General deems specially qualified to conduct specified classes of proceedings required by this Act to be conducted by or before a special inquiry officer, and who is designated and selected by the Attorney General, individually or by regulation, to conduct such proceedings. Such special inquiry officer shall be subject to such supervision and shall perform such duties not inconsistent with this Act as the Attorney General shall prescribe. The apparent purpose of these provisions was to establish an exemption from the procedural requirements of the Administrative Procedure Act without specifically mentioning that statute. The regulations recently promulgated by the Immigration and Naturalization Service under the 1952 Act have adopted that interpretation. End of Section 18. Recording by Maria Kasper. Section 19 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 4, Chapter 11C. The Issues Reconsidered. The deportation process has come a long way since 1893, when a Chinese alien could be expelled from the United States unless the legality of his stay was attested by one white witness, or even since the 1920s with the shocking spectacle of flying squadrons of inspectors moving about the country, a single official regularly making the investigation, holding the hearing, and recommending a decision. Indeed, with some conspicuous exceptions, both admission and expulsion procedures have advanced steadily toward the achievement of greater fairness. The Commission observes these advances, but notes that some of the shortcomings that repeatedly have been subjected to heaviest assault by responsible and informed observers are still unremedied. 1. Uncertain status of Board of Immigration Appeals. To the Commission, it seems inexplicable that the Board of Immigration Appeals is not specifically sanctioned by statute and owes its existence only to a regulation of the Attorney General. Several studies of the immigration process and very considerable testimony before the Commission have condemned this situation and have urged that such board be given statutory recognition. A proposal to give such status to the board was passed by the House of Representatives in the course of its consideration of the 1952 Act, but was eliminated by the Senate. The tenuous status of the Board of Immigration Appeals, underlined by repeated changes in its allotted jurisdiction, is clearly undesirable. A quasi-judicial agency that exercises virtual life-and-death authority over thousands of human lives should be free to exercise its responsibilities in an atmosphere of stability and protection from pressures. In its proposals for organization of immigration functions, Chapter 10, the Commission recommends a statutory Board of Immigration and Visa Appeals with specific legislative authorization to make final administrative decisions in a wide variety of cases. The adoption of this proposal would be a step toward assuring fair hearings for aliens. Aliens should be entitled to bring appeal to the Board of Immigration and Visa Appeals without the payment of fees. 2. Commingled judicial and prosecuting functions. A striking phenomenon in the jurisprudence of our day has been the crystallization of concepts for fair dealing in the administrative process. These concepts have been formulated by scholars, by the legal profession, by official studies, by the courts, and in the legislatures. They have included a universal condemnation of the situation in which one official or group of officials acts as investigator, prosecutor, and judge. This practice has been characterized as obnoxious to elementary standards of fair procedure. Those who have appraised the immigration process likewise have condemned its mixture of prosecuting and adjudicative functions. They have described it as a roadblock to impartial consideration. The Supreme Court said recently that the administrative deportation hearing is a perfect exemplification of the practices so universally condemned. But the attainment of insulation between prosecution and adjudication has been resisted and is today not yet a reality. The deportation process, although it touches countless human lives, thus has lagged behind other aspects of administrative justice. The major burden of the testimony of the American Bar Association was to urge the application of the Administrative Procedure Act to deportation proceedings. The current hearing procedures should be examined in the light of the mandates of the Administrative Procedure Act. First is the need for restricting hearing officials to adjudicative functions, so that they will not be committed to the attitudes or aims of investigation and prosecution. In this connection, the Administrative Procedure Act provides 1. That hearing officers shall perform no duties inconsistent with their duties and responsibilities as hearing examiners. 2. That investigative and prosecuting officers shall not participate in any decisions. From these requirements, it would necessarily follow 3. That separate officers shall prosecute and preside at hearings. Present practice conforms only partially with this first objective. Of 119 full-time hearing officers in the Immigration and Naturalization Service on October 1, 1952, only 2 performed extraneous duties. However, several hundred other officers, principally immigrant inspectors, are assigned part-time to conduct hearings in exclusion cases. With regard to the above item 2, the immigration statute now provides, like the Administrative Procedure Act, that special inquiry officers shall not conduct proceedings in those cases in which they have participated in investigating or prosecuting functions. In regard to the above item 3, the departure from Administrative Procedure Act is even more complete than under item 1. The Act of 1952 provides that a special inquiry officer shall have complete authority to prosecute, hear, and decide exclusion and deportation cases, except that in some special classes of cases, fixed specifically or by regulation, an additional immigration officer may be assigned to present the evidence on behalf of the United States. The regulation does not require the assignment of an additional officer in any specific category of cases, but leaves the assignment to the discretion of the officer in charge of the district. In practice, an examining officer was seldom designated, and the vast majority of deportation hearings were conducted entirely by a hearing officer prior to the Act of 1952. The present hearing procedure in deportation and exclusion cases fails to conform to the now generally accepted standards for fair hearings. The normal practice in both exclusion and deportation cases under the Act of 1952 is to have the entire proceeding conducted by a special inquiry officer who acts as both prosecutor and judge. Furthermore, officers normally performing investigating and prosecuting duties are authorized to conduct immigration hearings. Another major facet of the Administrative Procedure Act is the removal of hearing examiners from the supervision of officers performing prosecuting and investigative functions. This goal, likewise, is not fully met by current immigration practices. Even full-time hearing officers are subject to the immediate supervision of the District Director of the Immigration and Naturalization Service in administrative arrangements at the local level, and to overall policy supervision of the Assistant Commissioner in charge of the Inspections and Examinations Division. Both of these officials are concerned with enforcement. Under such an arrangement, the hearing officer inevitably will tend to tailor his determinations to the wishes of his superior officers, whose sphere of action encompasses enforcement duties. Indeed, the 1952 Act explicitly declares that special inquiry officers shall be subject to such supervision and shall perform such duties not inconsistent with this Act as the Attorney General shall prescribe. 3. Independence and competence of hearing officers. Another major objective of the Administrative Procedure Act is to assure to hearing officers a measure of independence. This is done, in addition to the methods already discussed, by placing their appointment, ratings, compensation, and removal within the domain of the Civil Service Commission, independent of control in the agency in which they serve. None of these objectives is reached by current immigration policies. Hearing officers enjoy no such independence of status. They are civil service officers and are subject to the normal powers of the Attorney General as head of the Department of Justice to appoint, compensate, rate, promote, and remove them. The sponsors of the Administrative Procedure Act contemplated that the hearing examiner would be an officer with a high level of competence, and that the scale of his compensation would be adequate to attract outstanding individuals. Current immigration administration falls short of these objectives. In the previous studies of the Immigration and Naturalization Service, there has been a recurring recommendation for improvement in the caliber of hearing officials. Through the years, there undoubtedly have been marked improvements in personnel, but many have said that such improvements have not progressed far or fast enough. The present complaint seems to be directed far more to the low concept of the role and function of such officers than to the officers themselves, some of whom are recognized as meeting the generally accepted standards for such important positions. The Dimmock Committee reached the conclusion in 1940 that it was a mistake to recruit all hearing officers, as was done in 1940 and is still being done in 1952, through promotion from within the service. Of the 119 hearing officers now employed by the service, 74 formerly were immigrant inspectors, 18 were investigators, and 27 occupied miscellaneous positions such as naturalization examiner, patrol inspector, and officer in charge. Only 16 hearing officers are members of the bar, and 5 possess law degrees but are not admitted to the bar. Thus, less than 18% of the hearing officers have legal training. 32 hearing officers possess college degrees. This means that approximately 60% of the hearing officers do not have college degrees or legal training. The Commission is in accord with the conclusions of previous studies that it is of the utmost importance that hearing officers be possessed of adequate training and experience properly to discharge the duties assigned to them, requiring knowledge of intricate laws, regulations, and court decisions, and the capacity to deal justly with human rights and aspirations. Closely related to the independence and qualifications of hearing examiners is their compensation. Manifestly, officers of high caliber cannot be attracted to these positions unless they are offered reasonable compensation commensurate with their responsibilities. The compensation scales of immigration hearing officers during recent years have never attained the reasonable levels fixed in most other agencies. Recommendations. The deficiencies in the immigration hearing process seem clear. In large measure, they result from a commingling of prosecuting and investigating functions, from the absence of real independence in the officers who hear and decide cases, and from what is said to be the inadequate qualifications of some of the hearing officers. The Commission believes it imperative not only that immigration hearings accord a maximum of fairness, but also that they give others confidence of fairness. In order to improve immigration administration, to ensure greater impartiality in rendering judgments, and to bring to the decision of these cases under immigration laws a fresh and more humane point of view, the Commission makes the following recommendations. Separation of organization. In the recommendation for a Commission on Immigration and Naturalization, Chapter 10, provision is made for a division of organizational responsibility between an Administrator of Immigration and Naturalization and a Board of Immigration and Visa Appeals. The Board of Immigration and Visa Appeals would be a statutory board whose members would be appointed by the Commission. The board would be concerned exclusively with the adjudication of cases arising under the immigration laws. The entire process of adjudication would be concentrated in the board, which would be independent in deciding cases. Its decisions would be administratively final on all issues of law and fact, and would be subject to review by the new proposed Commission only in regard to the exercise of discretionary authority. Separation of the hearing function. The Commission recommends that the examiners who hear and decide exclusion and deportation cases be separated from any enforcement functions. This would be accomplished principally by placing such examiners under the supervision of the Board of Immigration and Visa Appeals and removing them from the control and direction of any enforcement officials. Such examiners would be prohibited from performing any duties outside of their responsibilities as hearing officers. A number of witnesses have urged also that the procedural requirements of the Administrative Procedure Act be applied to immigration hearings. The spearhead of this proposal is the American Bar Association, whose representative testified at the hearing in part as follows. We do not doubt the good faith of the service, nor its disposition to give fair hearings. We do not deny that the Act is an improvement on the rider of 1951. But we return to the fundamental proposition that the provisions of the APA, taken in their entirety, represent a careful, well-considered view of the minimal procedural protection needed in a trial involving accusatory elements. This is not less, but indeed more true of deportation proceedings than of other proceedings to which the APA is applicable. The interest of a person about to be deported and of his relatives and close friends is among the weightiest and most significant that can be imagined. The need for invoking the purely procedural directives of the Administrative Procedure Act doubtless will be lessened by the adoption of the Commission's proposal for the separation of adjudicative functions from enforcement, subject only to a limited right of appeal. It may perhaps be urged that there is still a possibility that immigration hearing officers, lacking the relative independence of examiners chosen in accordance with the Administrative Procedure Act, may ultimately come under the influence of enforcement officials. To minimize this possibility, to remove a constant source of needless controversy and litigation, and to bring the deportation process in line with the uniform administrative procedures established by the Administrative Procedure Act, the Commission recommends that deportation hearings be conducted in conformity with the procedural requirements of the Administrative Procedure Act. All this would entail, in addition to the division of functions and organization recommended, is that a prosecuting officer be assigned to assemble and present evidence before the deportation examiner. There can be no substantial objections to making this a routine rather than the exceptional requirement it is under the 1952 Act. The practical difficulties would be negligible and the added costs inconsiderable. In reaching the conclusion that the added costs will be inconsiderable, the Commission has not lost sight of the estimates given to the Congress by the Immigration and Naturalization Service. that the increased cost for that particular year would be almost $4 million, and that if all aliens charged in deportation cases demanded hearings, the extra annual expense might reach $25 or $30 million. These calculations were on the theory that in the case of every alien apprehended because illegally in the United States, a hearing would have to be given him by an independent hearing officer with the aid of a prosecuting officer. For the last fiscal year, the Immigration and Naturalization Service completed 42,252 deportation hearings. At the same time, voluntary departure without a hearing was allowed in 694,200 cases. If hearings were conducted under the Administrative Procedure Act, it would still be permissible for the service to permit voluntary departure without bringing the case to a hearing, as is the practice today. No factual basis whatever has been offered to support the conclusion that every alien apprehended because illegally here, or any number of aliens greater than those now accorded hearings, would demand a hearing if operating under the Administrative Procedure Act. Actually, every alien charged in deportation proceedings at present has a right under the United States Constitution to demand a fair hearing, so that the opportunity for delay exists even now for those disposed to resort to dilatory tactics. It has been suggested that a deportation hearing under the Administrative Procedure Act would be more time-consuming, and therefore more aliens would demand a hearing in order to remain in the United States longer. It is difficult to perceive the validity of such an assumption. In fact, it would seem that as a hearing officer under the Administrative Procedure Act would be relieved of the duty of studying a case in order adequately to act as a prosecuting officer, with that function being placed in another official, hearings should be less time-consuming than is now the case. Clearly, applying the Administrative Procedure Act to deportation proceedings will be somewhat more costly than is true under existing law and regulations. That cost, however, should be limited to the expense involved in hiring additional personnel to act as prosecuting officers. Judging this added cost against the benefits of a completely impartial and objective hearing, the Commission is of the opinion that fiscal considerations should not operate against the adoption of the Administrative Procedure Act in deportation proceedings under the immigration laws. The Commission believes its recommendations in connection with deportation hearings meet the substantive requirements for a fair hearing and comply fully with the spirit and purpose of the Administrative Procedure Act. The exclusion process seems to be governed by somewhat different considerations. It deals with an alien who is outside the United States and who is not in a position to claim procedural protections equal to those accorded to an alien who has established residence in the United States. The American Bar Association has not officially favored application of the Administrative Procedure Act to the exclusion process. Moreover, in the admission process at the numerous ports of entry along the seacoasts and land ports of the United States, there is special need for speed and flexibility in passing upon cases. The application of the Administrative Procedure Act to the exclusion process would seem to hamper effective administration, and the Commission does not recommend that course now. It believes it would be advisable to study the results of experience under the proposals it has made before reaching a decision as to the need for additional measures. In the meantime, under the plan recommended by the Commission, the hearing officers who consider applications for admission would be responsible to the Board of Immigration Appeals and not to the enforcement officers. In addition to the other reasons against the application at this time of the Administrative Procedure Act to exclusion, the Commission believes that it would be inappropriate to attempt to use that act to control the procedure of visa-issuing officers stationed overseas. The proceedings before such visa officers should be free from unnecessary complications. Generally, their determinations would be made on a written record, consisting of an application and supporting documents. Unless extended inquiry is found necessary, there would be no need for any formal hearing in such cases. The visa-issuing officer's determinations would be subject to review by the proposed Board of Immigration and Visa Appeals. This procedure would provide appreciably greater assurances of fair play to the applicant for a visa than is available under present law. Improvement in caliber of examiners. Such improvement will follow to some extent from the severance of adjudication from administration. Freedom from ties with enforcement doubtless will tend to alter the outlook of the hearing officers, but changed organizational management will not in itself meet the need to which many of the studies called attention for improvement in the caliber and the competence of some of the hearing examiners. End of section 19. Recording by Maria Kasper.
Section 20 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information, or to volunteer, please visit LibriVox.org. Recording by Andy Glover. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization, Part 4, Chapter 11D. Judicial Review. With the growing complexity of modern life, it has been necessary to develop specialized administrative agencies of government, many of which take on quasi-judicial functions, which previously were conceived of as being wholly within the area of court action. This development of administrative justice has raised the important problem of the relationship of such quasi-judicial administrative agencies and the normal court system. There has been some uncertainty as to the precise extent to which the courts would, or even should, inquire into the merits of issues which have been resolved by the quasi-judicial administrative process. This same uncertainty has been present in immigration. The legal scholars in general seem to agree that in the area of administrative law, including immigration, there has been a steadily widening zone of intervention by the courts. The issues are twofold. First, whether there should be any judicial review of the action of immigration officials. Second, whether such judicial review should be limited to a determination of the reasonableness of executive action, or should re-examine the merits. These issues arise in different phases of the immigration process. Deportation orders. The statutes never have directly sanctioned judicial examination of deportation orders. On the contrary, they always have confided to administrative officers the function of determining whether an alien should be deported, and have provided that the determination shall be final. Such is still the provision of the 1952 Act. The courts have supported this grant of authority to administrative officers. The Supreme Court has stated that they are authorized to function without judicial intervention. Although the immigration law lacks a specific statutory authorization for judicial review of deportation, the courts have held that an alien could question a deportation order through a writ of habeas corpus. The proceeding affords to each person deprived of his liberty a speedy and effective means of testing the legality of his detention, but it is not a full judicial review of the issue. It only enables the courts to ascertain whether the deportation order was supported by substantial evidence, was issued on the basis of legal authority, and after a fair hearing. The courts have not attempted to decide in habeas corpus proceedings whether the administrative findings were wrong, but rather have determined whether the proceedings were fairly and legally conducted. Until the enactment of the Administrative Procedure Act in 1946, the courts uniformly held that the writ of habeas corpus was the exclusive method of contesting a deportation order. Since then, the legal situation has been somewhat confused. Efforts have been made to invoke court remedies under the Administrative Procedure Act and under the previously enacted Declaratory Judgment Act, and both forms of proceedings have been sanctioned in some of the lower federal courts. Perhaps by the time this report is completed, the Supreme Court will have ruled on the matter. The 1952 Act contains no specific provision concerning judicial review of deportation orders. The Congressional Conference report on that bill stated that the safeguard of judicial procedure is afforded the alien in both exclusion and deportation proceedings, but it does not explain or indicate just how. The attempts to enlarge the remedies that might be pursued to question orders of deportation doubtless have been engendered in large measure by a conviction that the relief afforded through the writ of habeas corpus is inadequate. No one would dispute that the writ of habeas corpus has furnished sturdy protection to individual rights in deportation cases. However, that writ can be obtained only by a person who is actually in physical custody. The alien, therefore, is unable to bring court proceedings until an attempt is made to enforce the order of deportation. This has meant that he was obliged to undergo detention before he could obtain a court ruling. The Commission requested the advice of the United States Solicitor General's Office concerning the possibility of improving and clarifying the avenues for judicial review of deportation orders. The views expressed in the Acting Solicitor General's response were formulated with the concurrence of the Immigration and Naturalization Service of the Department of Justice. The Acting Solicitor General stated, "I am strongly of the opinion that the form and other incidents of the judicial review of deportation orders should be clarified by legislation." He recommended clarification of the existing uncertain situation by a statutory substitute of a single, fair, and expeditious review for the habeas corpus proceeding. He observed, "It is inconvenient to the alien and of no corresponding benefit to the government that he cannot challenge a deportation order, which is otherwise final, until he has been taken into at least nominal custody." He also suggested that the statute include assurances for speedy consideration of such cases and reasonable safeguards against dilatory and multiple litigation. The Commission agrees with these views and recommends the creation of a statutory form of judicial review of orders of deportation. Just how this should be developed is a matter for legislative draftsmanship. The Commission is not wedded to any particular means of providing a clear and precise procedure for judicial review of orders of deportation. However, as some indication of what such proposal might involve, the following is suggested as one means of accomplishing this recommendation. A. The immigration statute should include specific authorization for judicial review of deportation orders after the administrative decision has become final. Although the precise designation of such a court proceeding is unimportant, this remedy could appropriately be called a petition for judicial review. B. Enforcement of the order of deportation should be subject to the right to file a proceeding for judicial review within a period of 60 days. C. Although there is a logical justification for channeling review proceedings directly to the United States Courts of Appeals, the heavy volume of such cases might overburden those courts. On balance, therefore, it might be preferable that the petitions for review be brought in the United States District Courts. If this view be taken, such suits should be maintained in the district of the plaintiff's residence, rather than in the District of Columbia, in order to avoid a concentration of cases in one court. D. Because of protracted calendar delays in the trial of civil actions in some federal courts, the statute should make provision for simplified pleadings and expedited consideration in the same manner as habeas corpus proceedings are now expedited. Moreover, the statute should preclude multiple attacks upon deportation orders by providing that this special review proceeding shall be the exclusive remedy. Such procedure will give the alien respondent in deportation proceedings a prompt and effective remedy, but will restrict him, in common with all other litigants, to a single mode of review. Because deportation will continue to be an administrative rather than a judicial function, court review should be restricted to an appraisal of the legality and fairness of the decision, and should not reconsider the merits of the controversy. Therefore, the scope of review of deportation orders could continue to be governed by provisions of the Administrative Procedure Act, which substantially conforms with the scope of judicial inquiry fashioned by the courts themselves in deportation cases. Exclusion orders. Under present law and court rulings, the alien applying for admission to the United States, who is stopped at the port of entry, does not have status or legal protections equivalent to those granted to an alien already admitted into the United States. However, the Supreme Court long ago decided that an alien so barred from the United States had the right to institute habeas corpus proceedings to determine whether the exclusion was ordered on grounds prescribed by Congress. The availability of habeas corpus has been an important privilege to aliens whose exclusion has been ordered. The excluded alien ordinarily remains in confinement at the port of entry, and the writ of habeas corpus seems a suitable vehicle for obtaining a court ruling. Moreover, the Commission is not aware that the form of the remedy has caused any real difficulty. Consequently, the Commission recommends that there be no change in existing formulas for review of exclusion orders after final administrative review by the proposed Board of Immigration and Visa Appeals. This would mean that the writ of habeas corpus will continue to be the appropriate remedy open to an alien excluded at a port of entry who wishes to challenge a final order of exclusion. Denial of visa. Although the precedents are meager, it seems doubtful whether under present law a rejected applicant for a visa can bring court proceedings to question the adverse determination. Elsewhere, the Commission recommends that the proposed Board of Immigration and Visa Appeals review determinations denying visas. One of the objections to granting such administrative review has been the apprehension by some that it might invite further review in the courts. Although the purpose to be served by such review is an old and cherished one, protection against arbitrary or illegal official action, the legal right recommended is a new one. The Commission believes it is desirable to await experience with its proposed administrative review of visa actions before consideration of judicial review. Therefore, the Commission recommends that at this time the review by the proposed Board of Immigration and Visa Appeals of a decision denying a visa should not be subject to judicial review. Bail. The immigration laws do not recognize an absolute right to release on bail for an alien against whom deportation proceedings are pending. Although the privilege of bail has been granted almost universally, there have been some instances in which bail has been denied. The legal authority to refuse bail prior to a determination of deportability was challenged in the courts and eventually was supported by the United States Supreme Court in Carlson v. Landon, 342 U.S. 524, 1952. The Supreme Court was closely divided on this issue, but the majority sustained the denial as a necessary administrative weapon to be used against aliens who are active adherents of the World Communist Movement, and declared that the aid of the courts could be invoked to determine whether this power was being arbitrarily or illegally exercised. The Act of 1952, Section 242, provides that courts shall have authority to review determinations denying bail in deportation proceedings only upon a conclusive showing that the Attorney General is not proceeding with reasonable dispatch. This provision apparently attempts to preclude the courts from considering whether denials of bail have been arbitrary or illegal. The Commission recommends that the courts be given specific authority to decide whether denials of bail, pending hearings, and determinations in deportation cases are arbitrary or illegal. In summary, apart from bail cases, no additional substantive judicial review is recommended by the Commission. The procedure and form of judicial review in deportation cases should be clarified, but no new or additional judicial review or court procedures are recommended in exclusion or visa denials. Here, the Commission believes that experience with the proposed new rights and procedures set up in connection with the proposed Board of Immigration and Visa Appeals should determine what, if any, further steps should be taken. End of Section 20.
Section 21 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5. Other Major Aspects. Chapter 12a. The Admission of Aliens. The immigration law incorporates two different selective devices, group selection and individual selection. The unified quota system and the national origin system both deal with immigrants by group characteristics. Once a group is selected, either in the non-discriminatory manner of the unified quota system or by the discriminatory method of the national origin system, there still remains the problem of deciding whether a particular individual from that group is desirable and should be admitted. The President's directive to the Commission required that particular consideration be given to the requirements and administration of our immigration laws with respect to the admission, naturalization, and denaturalization of aliens, and their exclusion and deportation. As a sovereign nation, the United States has full power to decide which aliens it will admit and which it will permit to remain. These questions are resolved by Congress. The Commission's discussions of what should be done, therefore, are concerned not with the power of Congress under the Constitution, but with the nature of the provisions appearing in the law. A primary function of the restrictions in our immigration law is to protect the United States against aliens who are actually or potentially undesirable. But it is difficult to reconcile this sound and important aim with the excessive punishments contained in our immigration laws, or with the attitudes of suspicion and distrust which seem to motivate them. Any objective study of the present grounds for exclusion of aliens makes it obvious that hostility to the alien is a major characteristic of our immigration statutes. The Immigration and Nationality Act of 1952 is unbelievably obscure, complex, and permeated with burdensome and unnecessary detail. Opinions may differ concerning some of the substantive requirements of the Act of 1952, but there is a virtual unanimity of opinion to the effect that its draftsmanship leaves much to be desired. Although to some extent this may be attributed to poor technical arrangement, the major cause seems to be the attempt, through excessive technicalities, to minimize any opportunity for humane interpretations, and to increase the opportunity for harsh results. The Act of 1952 consists, in an official edition, of 119 closely printed pages. There are 7 pages of definitions of words and phrases. The statute has 143 separate sections, some of which have dozens of subdivisions, provisos, and exceptions. One of the justifications given for enactment of the 1952 law was that it would clarify and simplify the previous law. However, former immigration laws, although not always models of clarity, were far more intelligible. Some of the formidable difficulties of interpretation and administration posed by the statute were described by the Attorney General of the United States in his testimony before the Commission, in which he observed, "It is my opinion that the new Act does not achieve the simplicity of arrangement to be expected of an exhaustive codification. It may even bring about further complications of administration." Even immigration experts are appalled at the complexities of the Act of 1952, but to the non-expert this legislation is all but incomprehensible. A professor of law at one of the leading universities testified before the Commission that he was compelled to read one of the sections 13 times before he thought he understood it. The Commission's objections to the law are much more fundamental. The Commission believes that aliens have a right to expect fair and just treatment by our laws and in their administration. Although it is true that the alien cannot claim as a matter of right the protections of our Constitution when knocking at the gates of entry into the United States, nevertheless, our immigration laws and administration must be governed by a high sense of decency, tolerance, and respect for the individual human being. In many of the present statutory grounds for exclusion of aliens, these qualities are now absent. The development of qualitative exclusions. The immigration laws have never directly described the type of individual who may enter the United States. Instead, our early immigration policies were founded on the premise that all immigrants were acceptable. The first century of free immigration was followed by the introduction of gradually increasing restrictions, which described only the unwelcome groups. Thus, our immigration law today does not describe whom we shall welcome, but rather whom we shall reject. The tabulation of categories of unwanted aliens has grown through the years, as more were added to the rolls. In 1862, the first approach to federal regulation penalized traffic in coolie labor. In 1875, the importation of prostitutes and convicts was prohibited. The first general legislation of 1882 added bans upon paupers, lunatics, idiots, and persons likely to become public charges. Chinese were barred the same year, in legislation substantially retained in effect until 1943. Legislation after 1882 expanded the prohibited lists to include contract laborers, insane persons, paupers, and persons suffering from loathsome and contagious disease, epileptics, imbeciles, professional beggars, and persons suffering from tuberculosis, feeble-minded, physical defectives, and persons admitting commission of crimes involving moral turpitude. The codification of 1917 added to the excluded classes illiterates, psychopaths, alcoholics, stowaways, vagrants, persons suffering a previous attack of insanity, and natives of a geographical area commonly known as the Asiatic Barred Zone. Outstanding among subsequent enactments were the laws aimed at subversives. In the historic development of the immigration laws, there was bound to be an accumulation of legislative provisions that had become archaic and had proved to be unnecessary or inequitable. Consequently, a recodification of our immigration laws could have been especially useful in correcting manifest inequities and in bringing the law into line with modern needs. But the Act of 1952 failed almost entirely to achieve these salutary goals. Although it did effect one major improvement in terminating the complete exclusion of Orientals, the new law overlooked or deliberately rejected the opportunity to strike out many obsolete and excessively severe survivals from the past. General criticisms. The Commission recommends that the provisions of the Act of 1952 relating to the exclusion of immigrants should be revised so as to eliminate the unwise, the unfair, and the obsolete grounds now contained in the law. The Commission believes that the Act of 1952 has failed as a purported codification and modernization of the immigration laws. Some of the reasons for these statements are excessive or irrational penalties. Shutting off the opportunity to come to the United States actually is a crushing deprivation to many prospective immigrants. Very often it destroys the hopes and aspirations of a lifetime, and it frequently operates not only against the individual immediately affected, but also bears heavily upon his family in and out of the United States. The United States should protect itself against the entry of aliens who are dangerous, diseased, or otherwise undesirable to the good order and welfare of our country. The immigration statutes necessarily must exclude those aliens who are subversive, criminal, or suffering from serious mental or physical disabilities. But no rational purpose is served by excluding aliens forever for mistakes of the past, if they now are respected members of society. These are broad generalizations, but they describe situations unfortunately too prevalent in our immigration statutes. For example, an alien is permanently barred from entering the United States if, 20 years ago, he stole a loaf of bread to feed his hungry family and was convicted for that offense. The fact of an exemplary life since has no bearing upon his admissibility. Excessively broad catch-alls. Throughout the exclusionary provisions of the immigration laws, there are vague restrictions, which may result in undue penalties in barring aliens. Examples of this type of restrictive discretion include a. The authority granted to the President for such period as he shall deem necessary to suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Section 212E. B. The exclusion of aliens who, in the opinion of the consular officer or the Attorney General, are likely at any time to become public charges. Section 212A, 15. And C. The barring of aliens who the consular officer or the Attorney General has reason to believe are seeking to enter the United States to engage in prejudicial activities. Section 212A, 27 and 29. The Commission believes that latitude in administrative action is frequently a desirable objective. However, such discretionary authority should not be limited to permitting flexibility only for the purpose of imposing additional restrictions. Moreover, such discretionary authority should not be nebulous and undefined, but rather should contain some standards controlling the administrative action. Lack of sufficient discretion to cope with hardships. The Act of 1952 has either deleted or severely curtailed discretionary authority to alleviate hardships, although it is written in such a way as inevitably to produce situations of great inequity. The Commission recommends that the head of the agency administering the immigration laws be authorized, in individual cases, subject to certain exceptions, to exercise discretion to admit otherwise inadmissible aliens, upon a finding that the case is a meritorious one, and that the alien's admission would not be detrimental to the United States. In relation to new immigrants seeking permanent residence, this would not include authority to waive inadmissibility in cases involving present subversive activity or affiliation, serious medical, or other named reasons. It is intended that such discretionary authority would be subject to adequate safeguards and would be exercised in relatively few cases. The Commission's proposal has precedent in the immigration law which now sanctions waivers of the documentary requirements on a limited basis, and, prior to the 1952 Act, authorized waivers of inadmissibility under certain circumstances. The expansion of administrative authority to ameliorate hardships in exceptional cases would introduce into the law a highly desirable element of flexibility. Such provisions have abundant precedent in the immigration processes of Great Britain, Canada, Australia, and of most other countries, which confer upon immigration officers the power to waive any immigration requirements in individual cases. The grant of limited discretionary authority to immigration officers in the United States would be a desirable step in the direction of an enlightened immigration policy. Returning lawful residents. Under present law, every time an alien living in the United States leaves the country, no matter how brief his absence, his legal immigration status on return is as if he had never been in the United States. Under this so-called re-entry doctrine, an alien residing in the United States for 25 years who crosses the border to view Niagara Falls, to shop or visit in Windsor, or to take a short excursion to Cuba or business trip to Europe, is subject to the same exclusionary injunctions as an alien coming to the United States for the first time. These identical restrictions apply even to an alien who has obtained from the immigration authorities an official re-entry permit before leaving the United States. Thus, if a lawfully resident alien becomes afflicted with tuberculosis in the United States, he is not deportable for that reason. But if he happens to cross the frontier, he is regarded as inadmissible on his return, perhaps a few hours later, because as an immigrant suffering from tuberculosis he must be barred, even though he may have resided lawfully in the United States for many years, and contracted the disease here. Similarly, if a lawfully admitted alien is convicted of theft 10 years after he entered, but has a good record otherwise, he is not deportable, and may in fact be eligible for naturalization. Yet, if he leaves the United States on a short visit, he is deemed inadmissible on his return, as an immigrant who has previously committed a crime involving moral turpitude. He is consequently precluded from re-entry, even though he has a re-entry permit, has resided in the United States for many years, may have a family, home, and job here, and may be conceitedly a person of good character. The grounds for exclusion in the immigration laws were designed to bar newcomers whose entry would be harmful to the United States. Aliens who are admitted lawfully are permitted to remain unless an offense committed in the United States renders them deportable. The Commission cannot find any reasonable justification for the use of immigration laws to entrap residents of the United States who were not amenable to deportation so long as they continued to be physically in the United States, but who happened briefly to cross the international boundary line. The Commission recommends that the provisions directing the exclusion of aliens shall not be applicable to aliens who have established lawful permanent residence in the United States, and who are returning from a brief absence. If there are causes which would warrant the deportation of such aliens, had they continued to remain in the United States, these causes should be the basis for deportation proceedings. If these causes would not have made them aliens subject to deportation had they remained in the United States, their brief absence should not create basis for exclusion. A re-entry permit issued by the appropriate federal official should assure a resident alien the privilege of return to the United States. Aliens returning to irregular domicile in the United States. The re-entry doctrine has been applied to aliens lawfully in the United States who seek to return following temporary absence. However, another situation concerns aliens whose original entry was irregular, but who may have resided in the United States for many years, and who may have established a home and close family ties here. Recognizing the important humanitarian considerations involved in such cases, the so-called Seventh Proviso in the Immigration Act of 1917 authorized the waiver of grounds for inadmissibility in the cases of aliens returning to a domicile in the United States which had been maintained for a period of 7 years. It has been held by the immigration authorities that such relief was available to an alien whose original entry was irregular. This ruling has made possible the alleviation of many hardships. The 1952 Act has sharply reduced the opportunity to grant such relief. The statute permits amelioration only when the departure abroad was not under an order of deportation, and when the alien is returning to a lawful domicile. These restrictions foreclose any opportunity for relief to many aliens who may have resided in the United States for many years, and who may have their homes and families here. Examples of cases that have arisen in the past will illustrate the effect of the law. Case 1. The alien, a native and subject of England, was 40 years of age. He had resided in the United States continuously, with the exception of visits to Canada, since the age of 18, when he had entered illegally. He was the father of 5 native-born children. His family was totally dependent upon him for support. He had been employed in Detroit, Michigan, for about 14 years, and was earning $75 a week. He was buying his own home and had war bonds. 20 years ago, on a plea of not guilty, he had been convicted on a charge of simple larceny for the theft of a newspaper valued at 3 cents. He had no other arrest record. The record reveals the alien has led an exemplary life in the United States. He could readily obtain an immigration visa if the crime, the ground of inadmissibility, were waived under the Seventh Proviso. He was granted such waiver, which also permitted him to re-enter the United States to join his wife and family when in possession of the visa. Under the Act of 1952, no relief would be available to the alien in either exclusion or deportation proceedings. Case 2. The alien was a 41-year-old married woman, a native of Ireland, and last a subject of Great Britain. 24 years before, at the age of 17, she was convicted in Toronto, Canada, for stealing various articles of apparel, and was sentenced to a prison term, of which she served about 1 year. She entered the United States unlawfully in 1924 or 1925, and resided in the United States except for short visits to Canada. She last re-entered in 1937. Since 1926, she has been entirely dependent upon her husband, a legally resident alien who was then an applicant for naturalization. She had no arrest record other than the one concerning the conviction in 1922. This ground of inadmissibility was waived under the authority of the law, and the alien was admitted into the United States. Under the Act of 1952, the alien would be inadmissible. No discretionary authority is allowed to admit her. The 1951 Annual Report of the Immigration and Naturalization Service reveals that from 1947 to 1951, inclusive, a total of 1,162 applications for exercise of Seventh Proviso relief were received. 1,028 applications were granted, and 134 denied. In 1951, 140 applications were received, 121 were granted, and 19 denied. Of those granted, 22 cases involved physical or mental defects, 86 cases involved the commission of crime, 9 cases involved illiterates, and in 4 the grounds were not shown. The average length of residence in the United States where favorable action was taken was 23 years. In the explanation of this new provision of the Act of 1952, it is argued that the previous authority to ameliorate hardships only encouraged efforts at illegal entry. On the other hand, an illegal entry, which under the 1952 Act would bar such ameliorative relief, could result from the purely clerical error of a consul in assigning an incorrect quota nationality to the alien. The heaviest impact of such provisions in the Act of 1952 falls on the wives and children of those aliens who cannot now be readmitted to rejoin them in the United States. The Commission recommends that the 1952 Act's restrictions upon the exercise of Seventh Proviso authority be repealed. Temporary visitors. The law makes no significant distinction between exclusionary grounds applicable to aliens entering the United States for permanent residence and those who are temporary visitors. The prospective visitor to the United States, no matter how brief his intended stay, is subject to exclusion, in the same manner as an immigrant seeking to come to the United States to spend the rest of his life. The general effect of this situation was called to the Commission's attention in the hearings in connection with temporary and short-time visits of scientists, scholars, artists, and businessmen. It impedes the free movement of aliens who desire to enter the United States temporarily for legitimate purposes. Its impact has been unfortunate along the Canadian border, where residents of Canada often are required to pass briefly through the United States en route from one point in Canada to another. It has caused embarrassments and annoyances to distinguished scientists, scholars, and others who have wished to visit the United States for brief attendance at professional meetings. It is desirable to permit an alien to pass through the United States from one part of Canada to another in order to avoid a difficult, and in some cases non-existent, passage through the neighboring regions of Canada. It likewise is desirable to encourage visits by aliens to the United States for business, study, or pleasure. The entry of such persons should not require the same standards that govern the admittance of persons who intend to take up permanent residence in the United States. The Air Transport Association of America testified before the Commission, "The encouragement of business and pleasure travel favors not only the carriers, but promotes national interests of far-reaching importance. The consuls can call for vast data from each alien, whether good or bad, and can make every requirement a reason for delay. Too many aliens already feel that this is the policy followed today. On the other hand, they can recognize that just as there are aliens who are obviously inadmissible, so there are also many more who are legitimate travelers whose visits should be encouraged. For those in this class, the application should be received immediately, and the visa issued promptly." Many of the exclusionary provisions of the immigration laws are concerned with long-term political, moral, and economic risks. Manifestly, such long-term considerations aimed at the prospective permanent resident often are not relevant in dealing with an alien who seeks to come for a short stay. The Attorney General has had authority, under the so-called Ninth Proviso, to permit the temporary entry of otherwise inadmissible aliens. Similar authority, hedged in with considerable language and many restrictions, is continued in the Act of 1952. But the exercise of this discretion generally entails long delay, usually for a determination by an official in Washington, D.C. Such delays often cause cancellation of the visit. The Commission recommends that the law ordinarily should apply to non-immigrants or temporary visitors only such exclusionary grounds as are directly concerned with the health, safety, and security of the United States. The otherwise applicable provisions for waiver would be available to visitors and non-immigrants. Aliens from United States possessions. Alaska, Hawaii, Puerto Rico, the Virgin Islands, and Guam are regarded as part of the United States for the purpose of the immigration laws. This means that no alien can enter those territories until he has been thoroughly screened under the immigration laws and has satisfied every requirement for entry into the United States. In addition, since 1917, the immigration laws required that aliens coming from our insular possessions be subjected to the same restrictions as if they were coming from a foreign country. The 1952 Act continued this policy and extended it to Alaska, which was not previously included. In his testimony before the Commission, the Director of the Office of Territories of the Department of the Interior stated, "We believe that no useful purpose can be served by requiring such a second examination. The requirement appears to us to be burdensome, valueless, and discriminatory. An alien residing in Alaska, which is a part of the United States as defined in the immigration law, should be as free to travel to Seattle as an alien residing in Seattle is now free to travel to Spokane. Each is traveling from and to points within the United States. There should be no greater burden upon one than upon the other. Introducing such complications to travel between the territories and the continental United States can produce no salutary consequences. Normal intercourse with the territories will be hindered, and this in turn may be expected to have an adverse effect on the rapidity of territorial development. Although the legislative history of Section 212(d)(7) is not revealing, we surmise that the drafters were motivated by a belief that it would advance the security interests of the United States. We submit that security considerations are no less important in the territories than they are within the continental United States. This is surely particularly true of such strategic areas as Alaska, Hawaii, and Guam. A person who cannot enter the continental United States for security reasons should not be allowed to enter the territories. We would hope and anticipate that immigration officers would be as conscientious in the performance of their duties in the territories as they are in the continental United States, and that a second examination of the same alien would be mere duplication. Officials and others from Alaska pointed out to the Commission that these new provisions would require an examination of United States citizens as well as aliens traveling between continental United States and Alaska, would impede travel and commerce between those two areas, and had already aroused strong resentments. The Department of the Interior emphasized that like difficulties exist in other principal possessions, Hawaii, Puerto Rico, the Virgin Islands, and Guam. This discrimination against inhabitants of the possessions of the United States seems to be unsound. In view of the critical importance to the security of the United States, of Alaska, Hawaii, Puerto Rico, the Virgin Islands, and Guam, the sowing of distrust and resentment in those areas by the imposition of unwarranted discriminations seems directly opposed to the national interest in security. The greatest vigilance should be, and, the Commission is informed, is exercised to prevent the admittance of undesirables into our territories. The Commission recommends that an alien lawfully admitted to permanent residence in any part of the United States, including Alaska, Hawaii, Puerto Rico, the Virgin Islands, and Guam, should not be again subjected to the requirements of the immigration laws when he travels to the mainland or to any other part of the United States. Obsolete requirements. In many instances, the immigration statute retains archaic language that no longer has any clear meaning. This failing appears in the medical exclusions, which the United States Public Health Service has described as outmoded and often meaningless. That service pointed out that the 1952 Act made little change in the medical criteria included in earlier legislation, and recommended that the obsolete language of the statute be conformed to modern medical knowledge. Specifically, the Public Health Service has stated that the terminology insane, feeble-minded, and mental defect have no exact medical significance for modern diagnosis, and may result in inequities. The Public Health Service has recommended that the terms idiot, imbecile, moron, and mental disease be substituted as more consonant with contemporary medical concepts. The Commission approves these recommendations of the Public Health Service. Other examples of obsolete requirements continued in the statute could be cited. Thus, for example, the statute purports to bar paupers, professional beggars, and vagrants, groups now obviously comprehended within the general exclusion of persons likely to become public charges. The Commission recommends that unnecessary duplication and obsolete requirements be eliminated from the law. End of section 21. Section 22 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5, Chapter 12b. Specific Categories. Subversives. Because of the paramount importance of security protections during the present critical period, the provisions of immigration laws dealing with subversives are discussed separately in Chapter 15. Criminals and other groups. The interest of our society in rejecting the criminal elements of other nations has always been an important factor in our immigration policy. The earliest federal statutes barred the entry of convicts, and a similar policy has been reflected in every subsequent federal enactment. The developing federal legislative design gradually has enlarged the restrictions aimed at criminals. An Act of 1891 prohibited the entry of aliens convicted of a crime involving moral turpitude, and an Act of 1907 introduced a prohibition against immigrants who admitted the commission of such crimes. In the 1952 Act, these prohibitions are amplified, and in addition, exclusion is ordered in cases of aliens convicted of 2 offenses without regard to moral turpitude, where aggregate sentences of 5 years or more were imposed. Permanent bar for single crime. The conviction of a single crime involving moral turpitude, regardless of the circumstances under which conviction occurred, and regardless of the length of the intervening period, forever precludes an alien from admission to the United States. This law ignores the vast differences between kinds of offenses. It fails to recognize the possibility of redemption or reformation. It disregards the intervening family ties and neglects the effect of arbitrary action on the alien's family. It overlooks the fact that the most important asset an immigrant brings to us is his future, not his past. While the 1952 law grants some power to forgive youthful indiscretions, this authority is hedged in with so many limitations that it is virtually valueless. The Commission recommends that the law provide administrative discretion to waive the ground for exclusion of an alien who has been convicted of a single crime involving moral turpitude, where it is determined that the alien has been a person of good moral character for a given period of time such as, for example, 5 years, and that he is not a person of criminal tendencies. This proposal would make possible an assessment of whether his life evidences that he will be a decent, useful member of American society. In exercising such discretion, the administrative officers would be required to take into account the gravity of the crime, the genuineness of the reformation, the alien's family ties, and other considerations. The Commission does not recommend that there be any discretion to permit permanent entry where the alien has been convicted for 2 or more crimes involving moral turpitude, arising out of separate criminal transactions. Such a history seems sufficient to demonstrate the criminal disposition of the applicant and to warrant his exclusion. At the same time, the administration of the statute should take into account the irrationalities of criminal penalties in totalitarian countries. Although the statute excludes convictions for political offenses, it is well known that totalitarian countries often make political punishments under the guise of prosecutions for ordinary criminal violations, such as frauds against the state and larceny. Our immigration laws should not be used to enforce totalitarian justice. Therefore, the Commission recommends that where the conviction for a crime or crimes involving moral turpitude was rendered by a court in a totalitarian country, the administrative officers should be authorized to inquire into the circumstances of the crime, in order to determine whether the conviction actually was for a crime or crimes involving moral turpitude under American standards. Although the designation of crimes involving moral turpitude has not been entirely satisfactory, it has not caused excessive difficulties. The principal problem in this connection is its indiscriminate application to both major and minor offenses. A youthful indiscretion in stealing 7 shoelaces, or a frantic father's theft of food to feed a hungry family, are crimes involving moral turpitude. The Commission recommends that the statutes specify that minor infractions are not within the contemplation of crimes involving moral turpitude, so as to bar entry. The immigration law should also permit consideration, which it does not, of any pardon or other form of clemency that may have been granted by the foreign government under whose laws a crime was committed. Conviction for 2 offenses. A new provision in the Act of 1952 prohibits the entry of aliens who have been convicted of 2 or more offenses, regardless of whether they involve moral turpitude, where aggregate sentences of more than 5 years were imposed. Despite the reservation in the Congressional Conference report, the Commission believes that this new provision in effect would penalize aliens who were subjected to false or trumped-up charges in totalitarian countries. In his testimony before the Commission, the Attorney General of the United States urged amendment of this provision. He said, "Practical difficulties of enforcement result from this provision when it is realized that totalitarian countries consistently mask religious, racial, and political persecutions as criminal prosecutions. The practical problem of enforcement is that many aliens from the Iron Curtain countries undoubtedly contend that they were convicted of crimes when no crime has been committed, and their sole offense was being politically opposed to those in power. It will be impossible to determine the truth or falsity of such claims. Trustworthy investigations to establish the truth or falsity cannot be made in the countries involved. Hence, I believe, there should be some clarification by statute of the nebulous middle ground between crimes and political offenses." Boris Shishkin, speaking in behalf of the American Federation of Labor, observed, "A realistic distinction should be made between the justice meted out by totalitarian courts and those which accord with the basic criteria of the law of our own land. In a totalitarian country, such as Communist Russia or Nazi Germany, individuals are arrested and jailed every day for all types of minor violations of the existing laws, or for no violation at all, even though such persons, even under the totalitarian law, are guilty of no political offenses. A worker who is late to work in the Soviet Union may be thrown into jail. This is no political offense, and should obviously be no grounds for exclusion from admission to this country. There are many other similar examples. The 1952 law, in effect, accepts Nazi and Communist laws and the decision of Nazi and Communist police officials and courts as the basis for excluding refugees from totalitarian countries from admission to this country. There can be no justification for such a provision. The law should be changed so that the principles of our own law and our own system of government should be the criteria used for determining whether to admit or exclude aliens." Walter Reuther, recently elected president of the CIO, commented, "Workers who protest speed-ups behind the Iron Curtain, who sabotage red war production, who organize free trade unions such as our own, are criminals in the lands under red domination. If caught in these acts, they become criminals in the eyes of the United States and are forever unable to come to our shores." The Commission finds these objections valid. There are also further reasons why this new provision of the Act of 1952 is objectionable. 1. It reiterates the philosophy that there can be no rehabilitation where an alien has once erred. 2. It does not require an alien to be convicted of what are regarded as crimes, as distinguished from minor infractions. Conviction for any offense or violation of law is sufficient: walking on the grass, smoking in an unauthorized place, acts of juvenile delinquency, providing religious education to children in Iron Curtain countries, listening to the Voice of America. Convictions for these offenses would be sufficient to bar the alien. 3. It does not require actual imprisonment for any period. Convictions where the sentence was suspended would suffice. 4. It makes foreign governments the final arbiters of American law. Where exclusions are based on the commission of crimes involving moral turpitude, the determinations are made by using standards applied in the United States. No such American standard is relevant in the provision requiring exclusions for the conviction of two offenses. Conviction and sentence are sufficient, regardless of the nature of the offenses. 5. Just as there are varying systems of justice in all countries, there are different standards controlling the sentencing of persons convicted of offenses. Courts in some countries may impose long terms of imprisonment and then suspend sentence, or grant liberal parole. In other countries, the courts may impose short sentences, but require them to be served. Thus, two aliens from different countries, although convicted of similar offenses, in one case may be barred from entering the United States, while in the other would be admitted. Yet the alien barred might be as desirable as the other, in terms of American interests and welfare. The Commission recommends that this provision be repealed. Admissions of crime. Since 1917, the law has contained the authority to exclude aliens on the basis of an admission of crime involving moral turpitude. The Act of 1952 goes further than the previous law and authorizes exclusion when an alien admits acts constituting the essential elements of such crime. Thus, an alien may now be barred for a supposed infraction of the criminal laws of another country for which he has not been convicted, and which he does not admit committing. The finding should be based upon admissions of acts constituting essential elements, whatever that means. The statute places upon the administrative officers an obligation to determine whether a crime has been committed, a function customarily performed by the criminal courts. Furthermore, the issue may involve a crime under foreign law. This adjudication will be made by immigration or consular officers, who ordinarily have no legal training. They will not be bound by constitutional protections surrounding criminal proceedings. Immigration or consular officers will act as prosecutors, juries, and judges. The finding that an alien is guilty of committing a crime for which he was never convicted need not be made upon proof beyond a reasonable doubt, or even upon a preponderance of the evidence. Copies of foreign laws are not ordinarily available to immigration officials. In such cases, the presumption is that the foreign law is the same as that prevailing in the United States. Thus, an alien may be excluded on the basis of events occurring in a foreign country, which would not necessarily be a crime in that country. Indeed, he may be deemed guilty of a crime even where the foreign criminal authorities have not seen fit to institute prosecution, or perhaps even where the courts of such foreign country have acquitted the alien. Immigration officials should not be given the function of balancing facts and deciding whether the facts established guilt of crime under foreign laws. The provision of the 1952 Act places an excessive burden on administrative authorities and lends itself to abuses in exacting admissions. The Commission recommends that the revisions made by the Act of 1952 be eliminated, and that an alien be subject to exclusion if he admits the commission of a crime or crimes involving moral turpitude. conditions for waiver of inadmissibility should be the same for aliens who admit as for those convicted of a crime involving moral turpitude, except that the discretion to waive in cases of admission should not be limited to a single offense. False representations in applying for entry. The Act of 1952 includes a new provision which forever bars an alien who has sought to enter the United States through fraud or willful misrepresentation. This statute continues and expands a similar provision of the Displaced Persons Act, which perpetually barred displaced persons who had made willful misrepresentations when applying for entry into the United States. Of course, fraud and willful misrepresentation of material information should be grounds for exclusion. The Act of 1952, however, introduced the principle of perpetual exclusion. The Act of 1952 makes no provision for those cases in which misrepresentations may be prompted by fear or by an understandable effort to escape suffering and misery. The Commission has been informed that refugees and displaced persons who, facing the possibility of being forced back behind the Iron Curtain, or of reprisals against their loved ones who still lived there, may have made false statements concerning their places of origin, or former residence, or other facts in their personal history. The report of the Congressional Conference Committee suggested that this provision be administered humanely, and that its mandate should not serve to exclude or deport certain bona fide refugees who, in fear of being forcibly repatriated to their former homelands, misrepresented their place of birth when applying for a visa, and such misrepresentation did not have as its basis the desire to evade the quota provisions of the law, or an investigation in the place of their former residence. But the language of the law remains an open invitation to the perpetration of injustices. In its present form, the statute imposes a penalty not reasonably related to any sound national interest. If the fact concealed affects the alien's admissibility, it would in itself be a ground for excluding him. Thus, it would appear that the statute penalizes the concealment of facts which in themselves are not material to the alien's admissibility. In the present state of the world, with so many persons seeking to escape the oppressions and persecutions of communist dictatorships, many have felt obliged, so the Commission is informed, to resort to misstatements concerning their antecedents and identity. It does not seem reasonable to bar from the United States forever those who have made such misstatements. Even a former member of the Communist Party is not permanently barred under the Act of 1952. The Commission recommends that the bar against entry of those who have sought to enter on the basis of fraud or willful misrepresentation be retained, but that the administrative authorities be given discretion to waive this ground of inadmissibility in meritorious cases. This would alleviate the inflexible rigor of the present requirement, and would permit taking into account the circumstances of the case, the length of time that has elapsed, and the present worth of the applicant for entry. Economic qualifications. Although the best evidence available to the Commission indicates that limited immigration does not increase or aggravate unemployment, particular prospective aliens may be undesirable in that they may become economic liabilities upon the community. Therefore, the exclusion of aliens likely to become a public charge is a reasonable and necessary element of our immigration policy. However, the 1952 Act permits this finding to be made on solely the basis of the opinion of the Attorney General or the consular officers. Apparently it was designed to substitute subjective opinion for demonstrated fact, and to lessen the opportunity for judicial inquiry. The statute allows much room for prejudice and for arbitrary action. Present practice in applying the public charge provision relies principally on evidence of the wealth of the sponsor. On September 8, 1930, the President instructed the Department of State to adopt a strict interpretation of the public charge requirement. That course was said to have been dictated by the rise of unemployment in the United States. In complying with this directive, the consular officers required strong proof of economic reliability on the part of applicants for entry. This policy has never been published in any regulation, but has continued to govern consular consideration of visa applications. Because of the absence of any published regulation, there is no uniformity in current consular practices. Each consul establishes his own requirements for evidence of financial reliability. In the absence of personal means in his own right, the prospective immigrant usually is required to submit to the consul the affidavit of at least one responsible person in the United States, stating that the immigrant will not become a public charge. The sponsor customarily is required also to attach to the affidavit supporting evidence of his financial responsibility, such as letters from his bank and his employer. Since the affidavit is not directly sanctioned by any statute or regulation, it is quite doubtful whether it creates a legally enforceable obligation. So far as the Commission is aware, no attempt has ever been made to bring suit against a person who has signed such a sponsoring affidavit, in cases where the immigrant actually became a public charge. Apparently, the sponsoring affidavit has been regarded as useful for its moral persuasion and for establishing some tie with a responsible individual in the United States. The Displaced Persons Act of 1948, as amended, developed a new approach to the question of protecting the United States against public charges. There, in practice, the public charge provision was regarded as complied with when an alien had an assurance of a job and home which would not displace another person. The testimony before the Commission indicated that this system worked well for the some 400,000 people admitted under that law. The Commission believes that the law could be improved by adding affirmative criteria to guide administrative action. The Commission recommends that the immigration law provide that no alien should be deemed likely to become a public charge who 1. has a firm assurance of employment in the United States, and 2. has assurances furnished on his behalf by a responsible individual or organization in the United States that the alien will not become a burden in the community. In making this suggestion, the Commission expresses no judgment on the merit of two features of the Act of 1952, owing to the fact that additional study of each subject is necessary. These subjects are the Contract Labor Clause. Since 1885 and until the 1952 Act, the immigration law excluded contract laborers from entry for permanent residence, with certain exceptions and waiver provisions. This has always been regarded as one of the most important features of immigration restriction. The Displaced Persons Act waived this provision in the light of the job and housing assurances. The 1952 law eliminates the contract labor provision, but authorizes exclusionary action upon a finding by the Secretary of Labor in connection with aliens seeking to enter to obtain employment. Concern was expressed by the Secretary of Labor that the elimination of the contract labor provision may put us in a position of acting too late to prevent unwarranted and economically harmful entry of foreign workers. Similar uneasiness was expressed by the American Federation of Labor, whose spokesman urged the Commission to recommend restoration of the contract labor provision. Further study of the problem is desirable. Affidavits of support. Although the Commission believes that it is desirable and necessary to retain in the law a provision excluding aliens who are likely to become a public charge, time has not permitted adequate study of the present method of administering this provision. Affidavits of support are the principal method used to determine whether an alien is likely to become a public charge. Whether this is a satisfactory device to implement the public charge requirement is a matter which should be given further study. However, the Commission believes that a satisfactory procedure should be adopted and codified in an appropriate regulation, so that the administration may be uniform. End of section 22. Section 23 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5. Chapter 13a. The Deportation of Aliens. The United States has the legal right to expel any alien at any time. In practice, every alien admitted in accordance with law is permitted to remain so long as he observes the conditions laid down by Congress. If he elects to become a citizen and successfully meets the required qualifications, he acquires a new status, with immunities, privileges, and rights not vested in an alien. Here, as with other discussions of complaints against the immigration laws, it is well to remember that it is for Congress to establish the terms and conditions under which aliens are permitted to enter and remain in the United States. It is for Congress to determine what measures affecting aliens are best suited to meet the needs and promote the security of the nation. The position of the resident alien has been fruitful of much controversy through the years, in this and other countries. Most immigrants, except visitors and non-immigrant laborers, enter the United States with the intention of remaining permanently and becoming citizens, and most of them do become citizens. Others remain indefinitely, some for life, but never renounce allegiance to their native countries, and never become citizens. Congress could require all aliens, after a specified length of time, to become naturalized citizens or to leave the country. But Congress has not seen fit to enact such a requirement, and the Commission makes no such recommendation. Congress has chosen to allow aliens, legally admitted, to remain, and has even made provisions at times for permanent residence by those who are here illegally. It will be agreed, so long as the law permits aliens to remain in this country without time limit, that a moral, if not a legal, obligation exists to treat such people fairly. Especially where, as in this country, the alien is permitted to become a full-fledged member of the community in which he lives, to be employed, to own property, to marry and raise a family, to pay taxes, to serve in the armed forces, and otherwise to participate in all activities, save those reserved for citizens, such as voting. It is clear, therefore, that to aliens who have lived in the United States for many years, who have become integrated into its community life, and whose ties to their mother country may have become remote and purely technical, a deportation order becomes the most severe and cruel penalty imaginable. It may be the equivalent of banishment or exile, and the Supreme Court has pointed out that deportation may result in the loss of both property and life, of all that makes life worth living. A few examples illustrate types of hardships resulting from our immigration laws with respect to deportation. Case 1. The alien came to the United States in 1921, at the age of 16. Within 5 years after his entry, he was involved in an automobile accident, which resulted in the death of a child. He was convicted of manslaughter, served a sentence, and was paroled. More than 5 years later, he was ordered deported. Case 2. The alien entered the United States with his grandparents in 1916, at the age of 13. In 1922, he married a native-born American, and they had 2 sons. During World War II, his son served honorably in the armed forces of the United States. He was a good worker and family man, and never had been arrested for any offense. In applying for naturalization in 1949, he voluntarily disclosed that he had been a member of the Communist Party for a few months in 1934 or 1935, had paid about 90 cents to that organization, had dropped out of it, and had had nothing to do with it since. His deportation was ordered. Case 3. The alien entered the United States with his parents in 1913, at the age of 3 months. His 3 brothers and 2 sisters were born in the United States. In 1930, when 17 years of age, he was convicted of attempted larceny and in 1932 was convicted of robbery. He was ordered deported. Case 4. The alien came to the United States in 1913 and left in 1921, returning again in 1925 without a visa. For failing to disclose his absence from the United States between 1921 and 1925, he was convicted of perjury. He has been steadily employed in steel mills since 1933, and his conduct in other respects has not been questioned. His family is in the United States, and his 2 sons are American citizens. Many years after his conviction for perjury, his deportation was ordered. These random examples could be multiplied indefinitely. In each of these instances, courts publicly criticized the unreasonable harshness of the deportation statute, but they were powerless to mitigate its effect. A substantial number of responsible organizations and individuals urged the Commission to recommend abolition of all deportation except where entry into the United States had been obtained by fraud. They pointed out that Australia grants complete immunity from deportation, in peacetime, to aliens with 3 years' residence. In other countries, such as Belgium and Brazil, certain groups of aliens are exempt, especially where they have tied their future to the country by residence or marriage. The Commission believes that the suggested abolition of all deportation is much broader than necessary to accomplish its purpose. The suggestion really aims at 2 grievances. 1. Some of our present substantive legal requirements for deportation are unreasonable. 2. Some of our present procedures for administrative and judicial review of deportation orders and for the exercise of discretionary relief are inadequate. The Commission believes that appropriate changes to remedy these wrongs, rather than the total abolition of deportation, is the desirable solution. The first of these grievances, relating to the substantive provisions of law on deportation, is discussed in this chapter. The second is covered by the Commission's recommendation for the establishment of a statutory board of immigration and visa appeals, Chapter 10, and the recommendation for a statutory method of appealing from such boards' decisions to the courts, Chapter 11. These recommendations, and the additional recommendations made in this chapter, the Commission is convinced would meet most of the complaints against the injustices of our present deportation system, and still retain necessary and adequate provisions for protection of the United States. The following table indicates the operation of the deportation process for the last 3 years for which figures are presently available. Table 14. Deportations, 1949, 1950, and 1951. Aliens deported from the United States by country or region to which deported. Years ended June 30th, 1949, 1950, and 1951. Country or region to which deported. All countries, 1949, 20,040, 1950, 6,628, 1951, 13,544. Europe, 1949, 983, 1950, 947, 1951, 1,537. Asia, 1949, 225, 1950, 244, 1951, 238. Canada, 1949, 869, 1950, 737, 1951, 1,100. Mexico, 1949, 16,903, 1950, 3,319, 1951, 8,928. West Indies, 1949, 346, 1950, 722, 1951, 1,071. Central America, 1949, 152, 1950, 144, 1951, 163. South America, 1949, 149, 1950, 160, 1951, 269. Africa, 1949, 39, 1950, 47, 1951, 46. Other countries: 1949, 374, 1950, 308, 1951, 192. Table 14, Deportations, 1949, 1950, and 1951, continued. Aliens deported from the United States by cause. Years ended June 30th, 1949, 1950, and 1951. Cause. All causes. 1949, 20,040. 1950, 6,628. 1951, 13,544. Criminals. 1949, 1,024. 1950, 790. 1951, 1,036. Immoral classes. 1949, 76. 1950, 53. 1951, 67. Violators of narcotic laws. 1949, 70. 1950, 55. 1951, 62. Mental or physical defectives. 1949, 82. 1950, 53. 1951, 45. Previously excluded or deported. 1949, 3,815. 1950, 553. 1951, 940. Remained longer than authorized. 1949, 1,379. 1950, 1,661. 1951, 3,289. Entered without proper documents. 1949, 998. 1950, 1,352. 1951, 5,322. Entered without inspection or by false statements. 1949, 12,094. 1950, 1,734. 1951, 2,293. Likely to become public charges. 1949, 20. 1950, 38. 1951, 14. Subversive or anarchistic. 1949, 4. 1950, 6. 1951, 18. Miscellaneous. 1949, 149. 1950, 109. 1951, 160. Source: Immigration and Naturalization Service, Annual Report for 1951, page 61. These figures do not include a large volume of illegal entrants, principally from Mexico, who depart voluntarily in lieu of deportation. The Commission has been informed that a substantial proportion of deportations are based on technical violations of the laws which prescribe the formal procedures that must be followed in entering the United States. Deportation is an aspect of exclusion. The deportation power complements the power to exclude. When an alien enters or remains in the United States in violation of immigration laws, the statute should enable him to be deported within a reasonable period. However, certain revisions of existing law should be made. Technical violations. Our immigration statutes contain many complex prerequisites for admission to the United States. By the same token, an alien who has entered may be deported at any subsequent time if it is discovered that his entry was irregular in any particular. This may be true under the present situation, even though the alien was entirely blameless. Many of the immigration requirements are highly technical. Thus, the law requires, for example, a correct determination of nationality for quota purposes, the issue of particular types of entry documents, and the execution of appropriate agreements by transportation lines which bring aliens to contiguous territory. In many such cases, the alien himself has nothing to do with the actual compliance with the technicalities of law. A failure to observe these, or a multitude of other technical requirements, makes the alien's entry irregular, and therefore, under present law, renders him subject to expulsion. The Commission believes that if the alien acts in good faith and is passed by immigration officers, there is no substantial reason why his status in the United States should continue to be insecure because of the error of the administrative officials. The Commission recommends that when an alien is admitted for permanent residence in the United States by immigration officers, he should not, in the absence of any fraud or other illegality for which he is to blame, be subject to deportation for technical defects in connection with his entry or status. Statute of Limitations. That it is wrong to keep the threat of punishment indefinitely over the head of one who breaks the law is a principle deeply rooted in the ancient traditions of our legal system. The law requires that criminal prosecutions, except for capital offenses such as murder and treason, be brought within a fixed period of time or not at all. A similar dispensation governs the enforcement of civil liabilities. Prosecutions for many serious crimes under federal law generally are precluded unless brought within 3 years after the crimes were committed. The 3-year statute of limitations applies to bribery, counterfeiting, forgery, extortion, mail fraud, perjury, and robbery. Prosecutions for frauds against the United States generally are governed by a 6-year statute of limitations. Under the Immigration Act of 1917, aliens who entered in violation of law were subject to deportation only if expulsion proceedings were commenced against them within 5 years after the improper entry. In connection with the grounds for deportation specified in the 1924 Act, no statute of limitations applied. The Act of 1952 eliminated the provision of the 1917 Act, and therefore an alien now is subject to deportation at any time for even minor technical violations. The statement in the Congressional Conference Report that the conferees have provided for a statute of limitations, as contained in the House version, in accord with humanitarian principles, refers only to the exceedingly narrow provision that mental disease or economic distress after entry will justify deportation at any subsequent time, only if it occurred within 5 years after entry. Under the Act of 1952, deportation proceedings for any cause specified in the statute can be brought at any time after entry, and are not subject to any statute of limitations. Indeed, the 1952 statute retroactively rescinded the limited statute of limitations fixed by previous law. An alien who entered the United States 25 years ago, and whose entry involved a purely technical violation, enjoyed immunity from deportation for the last 20 years. Under the 1952 Act, he is now again subject to deportation. That act threatens the security of many aliens and their families. Their immunities have been removed, and they may be torn out of their accustomed places in the communities in which they live, no matter how exemplary their conduct over a long period of years. Instead of being a humanitarian measure, as the congressional conferees on the Act of 1952 characterized it, the new act actually restores the threat of cruel and inhuman punishment for offenses long since forgiven. This undue severity is underscored by the fact that although prosecutions for aggravated criminal violations of the immigration laws are subject to a 3-year statute of limitations, deportation proceedings for such violations, as well as for infractions which offend no criminal law, are governed by no statute of limitations, and may be brought, more than say 20 or 40 years after an alien entered the United States. No one has suggested any sound reason why the purpose of limitations, recognition of the unfairness involved in requiring a person to make a defense long after the event, when it is difficult or impossible to assemble witnesses and evidence, does not apply to immigration matters, at least with equal force as to prosecutions for serious crimes. It is said that the existence of a statute of limitations would encourage aliens to enter the United States in violation of the immigration laws. A person who enters or remains in the United States in violation of the immigration laws should be subject to deportation from the United States. But the consequences of such a violation should be enforced against him within a reasonable time. There is a fundamental public purpose which is served by statutes of limitations for crimes and in civil actions. This is just as important an objective of law enforcement as the avoidance of violation of law. A statute of limitations on deportations has been part of our laws for 65 years. The 5-year period of limitations was in our immigration laws since 1917 and until removed by the Act of 1952. The Commission believes that a period of 10 years within which proceedings must be brought after the commission of an act for which deportation is provided is ample for the government to ascertain that a violation had occurred and to take action against the offender. The Commission recommends that the immigration statute should provide that a deportation proceeding may not be commenced against any alien more than 10 years after the violation occurred. Deportation for reasons of security is discussed in Chapter 15. Residents who have been temporarily absent abroad, the re-entry doctrine. Chapter 12 discusses the re-entry doctrine, which holds that the excluding provisions of the immigration laws apply fully to an alien resident of the United States who returns from a temporary visit abroad, however brief. The unreasonableness of this rule is illustrated most graphically in deportation cases. The facts often come to light in naturalization proceedings. Questioning sometimes reveals that the applicant once committed a minor offense or suffered a disability from which he has completely recovered. Although these circumstances do not in themselves make the alien deportable, if he ever went on a trip to Havana, Montreal, or Tijuana, for example, he becomes subject to deportation as an alien who was excludable when he re-entered the United States. Legally, every return of an alien to the United States is regarded as if he were coming to the United States for the first time. The impact of the re-entry doctrine on resident aliens of the United States is illustrated by the following 2 cases, which are typical of hundreds of others. Case 1. The alien was lawfully admitted to the United States for permanent residence in 1932. In 1939, on a plea of not guilty, she was convicted of a theft charge. She was fined $1 and costs. This conviction did not make her deportable. In December 1939, she re-entered the United States after a short visit to Mexico. An alien who committed the crime of theft before entering the United States is inadmissible to the United States. By departing from the United States and then re-entering, the alien was herself in the position of a person who committed theft before entry and was deportable. In 1940, she was arrested in deportation proceedings on the ground that she had committed theft, a crime involving moral turpitude, prior to her last entry in December 1939. The alien's husband and her 3 native-born children reside in the United States with her. She had no other police record. She was found deportable, but the Attorney General ordered cancellation of the proceedings under discretionary authority. Case 2. The alien, a native of Yugoslavia, was 55 years old. He first came to the United States in 1909, but there was no record of his entry. Through administrative process, his entry was registered as 1939, and his status as a lawfully resident alien confirmed. In 1924, he had been convicted of larceny and placed on a year's probation. This matter was considered when his status was adjusted to that of a lawfully permanent resident alien, and found not to be a bar to that action. In 1939, he left the United States for the purpose of settling an estate in Yugoslavia. He was readmitted in the same year. In the same year, a warrant of arrest was issued, charging him with being deportable as one convicted of a crime prior to entry. The alien was found deportable, but he was permitted to remain in the United States under discretionary authority. In the past, the law has permitted relief in such cases through the so-called Seventh Proviso, which authorizes the administrative authorities to waive grounds of inadmissibility, and thus deportability, for aliens who have been 7 years residents in the United States. Relief under the Seventh Proviso was granted to the majority of qualified aliens who applied for it. Although it accomplished a desirable purpose, this process has generally caused needless trouble and expense to the government and to the alien. The Commission recommends that the re-entry of an alien returning to a lawful permanent residence in the United States following a brief absence shall not be regarded as a new entry under the immigration laws. Such brief absence should not be a factor in the determination as to whether he is subject to deportation. The re-entry doctrine produces many shocking results. Until a contrary opinion was obtained from the courts, the administrative authorities ruled that where an alien unknowingly passed over Canadian territory on a train trip between 2 points in the United States, he had left the country and made a new entry when the train again reached the United States. In another case, the same situation occurred when a sailor was taken to a nearby foreign port by a ship which rescued him as a survivor of a torpedoed American vessel during World War II. The Supreme Court said that these interpretations were capricious, and that the right to reside in the United States should not become the sport of chance. The Act of 1952 wrote into law provisions which, except for aliens who are lawful permanent residents, will produce the results denounced by the Supreme Court. The Commission recommends that the law in effect prior to 1952 be restored, so that a return following an involuntary absence, even in the case of an alien not lawfully admitted for permanent residence, should not be deemed an entry under the immigration laws. End of section 23. Section 24 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5. Chapter 13b. Deportation as Punishment. In 1910, a statute was passed sanctioning expulsion at any time of an alien found identified with the business of prostitution. Eventually, the concept of deportation as punishment for misconduct spread rapidly. Today, it is predominant in the deportation statute. In 1917, deportation for criminal violations in the United States was authorized. The deportation of subversives was the subject of legislation in 1918 and 1920, as well as of the Alien Registration Act of 1940 and the Internal Security Act of 1950. The Act of 1952 codified and considerably enlarged the grounds for deportation as punishment for misconduct in the United States. Difference in treatment of aliens and citizens. If a citizen violates a law of the United States, he may be imprisoned for a specific period of time. If an alien violates the identical law, he likewise may be imprisoned, but in addition he may be banished from the United States. Judge Augustus Hand has observed that for an alien, however serious his crimes, deportation is to him exile, a dreadful punishment, abandoned by the common consent of all civilized people. Such indeed it would be to anyone. Subject to conditions discussed elsewhere, there does not seem to be any sound basis, especially after the lapse of many years, for adding deportation as punishment for an alien to the penalties provided by the criminal laws. Wrongdoers produced by our society. Alien children of tender years come to the United States with their parents, often as babes in arms. In some instances, they grow to maturity here and then turn out badly. Because of the punitive provisions in our immigration statutes, the wrongdoing of such individuals makes them subject to deportation, in addition to any other penalties the criminal laws may impose. The following are illustrative cases among many that could be cited. Case 1. The alien, a native of Canada, was brought to the United States as an infant in 1913. In 1931, he was convicted of breaking and entering and stealing an automobile. He was placed on probation for 2 years. About a month later, he committed a robbery and was sentenced to a reformatory for 7 years. He was found deportable on the ground that he had been sentenced more than once for crimes involving moral turpitude. He was ordered deported in 1941. He left behind him a United States citizen wife and 2 citizen children, all of whom were dependent upon him. Case 2. The alien, a native of Ayr, was brought to the United States by his parents in 1909 at the age of 5 years. His entry was lawful, and he has since lived in the United States continuously. Until 1935, he had believed that he had acquired citizenship through the naturalization of his father. In that year, he learned he was an alien. He is single. He has no relatives or friends in Ayr. His mother, 2 brothers, and a sister reside in the United States. In 1922, when about 18 years of age, he was convicted and sentenced on a charge of larceny of property of the value of $152. In 1927, he was convicted of larceny of property of the value of $200 and of larceny of property of the value of $83. He served a sentence of 4 years for these convictions. In 1935, he was sentenced to serve 2 years for stealing mail matter. Since then, he has had a good record. In 1942, deportation proceedings were brought on the ground that he had been sentenced to imprisonment more than once for a term of 1 year or more for the commission, subsequent to entry, of a crime involving moral turpitude. His deportation to Ayr was ordered. Case 3. The alien came to the United States in 1913, when he was 3 months old, and has lived there since that time. In 1930, when 17 years of age, he was convicted of attempted larceny, and in 1932 was convicted of robbery. His 3 brothers and 2 sisters were born in the United States. An order for deportation was entered and was challenged in court in 1935. The court observed, "His deportation will be tantamount to exile from a country in which he has always lived to a country in which he will be a stranger. These are circumstances, however, which cannot be considered by this court." Each of these aliens is the product of our society. Their formative years were spent in the United States, which is the only home they have ever known. The countries of their origin which they left, in 2 cases during infancy, in another at the age of 5 years, certainly are not responsible for their criminal ways. Their criminal careers are American, not foreign, products. If such a person offends against our laws, he should be punished in the same manner as other citizens and residents of the United States, and should not be subject to banishment from this country. We cannot expect other countries to take, and continue to take, undesirable people who have no real tie with them. The Commission recommends that no alien shall be subject to deportation if he was lawfully admitted to the United States for permanent residence before reaching the age of 16 years, or if he was lawfully admitted for permanent residence and has resided in the United States for 20 years. Excessive penalties. Some offenses for which deportation may be ordered under the law do not warrant such an excessive punishment. Deportation may result from trivial offenses, for misbehavior many years after entry into the United States without any limitation of time, and for wrongful conduct of the remote past, without any consideration as to whether there has been reformation or expiation. Retroactive penalties. The Act of 1952 retroactively makes aliens deportable for specified causes, involving conduct that violated no law and warranted no punishment when it was committed. For example, The Act of 1952 subjects to deportation an alien who entered the United States without proper inspection in 1918, in whose case the statute of limitations 20 years ago forbade deportation, and who also could have been naturalized before December 24, 1952, after his original entry had been legalized by an administrative registry process. An alien may engage in an activity which is perfectly lawful today, and yet may be deported 20 years hence, because a statute passed in 1970 may declare the act he performs today to be criminal. Witnesses in the Commission's hearings objected to this retroactive provision as a form of ex post facto law, forbidden by the Constitution of the United States. The Supreme Court has decided that deportation is not criminal punishment, and that the constitutional prohibition against ex post facto laws does not invalidate retroactive deportation requirements. Nevertheless, such retroactivity has no place in the laws of the United States. The Commission recommends that the blanket retroactive provision in Section 241D of the 1952 Act be repealed. Specific categories. Subversives. Deportation for reasons of security is discussed in Chapter 15. Violators of criminal statutes. The provisions dealing with violators of the criminal laws are among the principal punitive features of the deportation statutes. Before 1917, there was no statute authorizing deportation for conviction of crime in the United States. As a result of recommendations made by the Immigration Commission in 1911, the Act of 1917 authorized expulsion following convictions under certain conditions for crimes involving moral turpitude. The Act of 1952 increased the application of these penalties. Criminal offenders before entry. The Commission believes that the laws providing for the deportation of aliens who enter the United States in violation of the provisions excluding criminals should relate to original entries, and not to re-entries after brief absences. And further, that deportation for such offenses should be subject to limitations of 10 years, as discussed elsewhere. Conviction of one crime after entry. The Immigration Act of 1917 provided for the deportation of aliens convicted of a crime involving moral turpitude committed within 5 years after entry, where such conviction was followed by a sentence to imprisonment for 1 year or more. However, if the court suspended sentence on the belief that the crime was committed under circumstances which did not warrant imprisonment, the alien was not subject to deportation. Under the Act of 1952, however, such an alien would be deportable. A recommendation to continue the provisions of the 1917 Act was made in the report of the Senate Judiciary Committee. This recommendation was not adopted. The Commission recommends restoration of the provision of the Act of 1917. Unlike the previous law, the Act of 1952 makes confinement in a corrective institution a ground for deportation. So, where a person sentenced is a minor who is confined principally for educational and corrective purposes, he becomes subject to deportation. A person under 21 who commits a criminal offense and who is placed upon probation, parole, or in a correctional institution primarily for corrective and educational purposes should not be subject to deportation solely for that reason. The Commission recommends that an alien convicted for one crime involving moral turpitude should be subject to deportation only if the offense was committed within 5 years after the alien's original entry into the United States for permanent residence, and resulted in a sentence to a penal institution for 1 year or more. Although the designation of crimes involving moral turpitude is not completely satisfactory, the Commission believes, as previously stated in Chapter 12, that this descriptive term has not caused too much difficulty, and that it should be retained. Where there has been a conviction for a crime involving moral turpitude, deportation does not result if there has been a pardon, or if the court recommends against deportation. However, the Act of 1952 lists an additional number of crimes for which deportation may be ordered without regard to whether they involve moral turpitude. In connection with such crimes, no provision is made for clemency in worthy cases, as is done with crimes involving moral turpitude, as a result of pardons or court recommendations against deportation. In one instance, involving activities by aliens in aiding other aliens to enter unlawfully, no court conviction is necessary, and the administrative officers are required to determine whether a crime has been committed. The Commission recommends that wherever the statute requires deportation for criminal offenses, deportation shall not be ordered where there has been a pardon or a recommendation by the court against deportation. The Commission recommends further that even where an alien is subject to deportation because of a conviction and sentence for one offense, deportation should be ordered only if the head of the agency administering the immigration law also finds the alien to be an undesirable resident of the United States. Conviction for more than one crime. The Act of 1917 required deportation at any time after entry of an alien convicted and sentenced more than once for crimes involving moral turpitude. This provision was intended to reach confirmed criminals. It applied to aliens who resided in the United States for 5 or more years. Under that act, as construed by the Supreme Court, such an alien was deportable if at any time after entry he committed a crime involving moral turpitude for which he was sentenced to imprisonment and confined, and then, after serving the first sentence, committed another crime involving moral turpitude for which he was convicted, sentenced, and confined. The Act of 1952 changes the prior law and eliminates 1. The necessity for imprisonment, and 2. The necessity that the second conviction take place after the alien had been subjected to punishment. Thus, an alien who has been found guilty under an indictment containing several counts arising out of one transaction is now subject to deportation, even though the offense may have occurred many years after his entry into the United States, and the court did not regard it as sufficiently serious to require a prison sentence. The Commission recommends that the provisions authorizing deportation for 2 or more crimes involving moral turpitude be retained substantially as in effect prior to the Act of 1952, provided that deportation in such cases shall be directed only if the head of the agency administering the immigration law finds that the alien is an undesirable resident of the United States, and provided that no alien should be subject to deportation who entered the United States for permanent residence before reaching the age of 16 years, or who was lawfully admitted for permanent residence and has resided in the United States for 20 years. Violation of registration requirements. A new provision, originating in the Act of 1952, makes an alien subject to deportation for failure to report his present address, as required by law, but permits relief from deportation upon a showing that the omission was reasonably excusable or was not willful. Conviction of the offense is not required. The Act also requires deportation upon conviction for other infractions of the registration statute, regardless of whether the court imposed sentence. No provision is made for alleviation in the case of a pardon or a court recommendation against deportation. Convictions for infractions of the registration provisions carry substantial penalties. Sentences which may be imposed as a result of conviction should be an adequate deterrent without the additional penalty of deportation. Such additional punishment is entirely out of proportion to the nature of the offense. These provisions can have little effect upon aliens unlawfully in the United States, as such aliens are subject to deportation on other grounds. Their only effect is to impair the status of lawfully resident aliens. The Commission recommends that the provisions authorizing deportation for violations of the alien registration laws be eliminated as unnecessary and excessively severe. Narcotic drug addicts. The Act of 1952 requires, for the first time, deportation of any alien who is, or at any previous time has been, a narcotic drug addict. Previous legislation providing for the deportation of those convicted of violating the narcotic law had exempted from expulsion narcotic addicts who were not dealers in or peddlers of narcotic drugs. The statute makes no distinction between aliens who may be incurable, who may be curable, or who may have been fully cured. The 1952 Act makes no allowances for length of residence in the United States before addiction occurred. Nor does it make any difference whether the addicts or former addicts have violated any law or have become a problem to the community. There was the case of a much decorated hero of World War II who became a drug addict as a result of drugs prescribed to alleviate pain resulting from his wounds. If such a person were an alien, he would be subject to deportation. It is unjust to apply the same yardstick to persons engaged in drug traffic and to their unfortunate victims. The Commission recommends that applicable provisions for deportation be related solely to those engaged in the unlawful traffic in narcotic drugs, as provided by law prior to the 1952 Act. Aliens who become a charge on the community. Under the law in effect prior to the Act of 1952, an alien who became a public charge within 5 years after entry was subject to deportation, unless he could establish that the cause arose after arrival in the United States. Where such a cause occurred within the 5-year period, the law placed the burden on the alien to establish that his becoming a public charge was not the result of a condition which existed prior to entry. The 1952 law continues public charge as a ground of deportability, but makes the determination dependent on the opinion of the immigration officer. The Act permits a finding of deportability for public charge to be based not on facts but on opinion, whereas other grounds of deportability must be supported by substantial and probative evidence. The legislative history of the 1952 Act does not indicate that there was any administrative difficulty in enforcement of the prior law, nor does it disclose the reason for making the public charge finding dependent on the mere opinion of the administrative officials. The Commission recommends that a finding of deportability on the ground that the alien became a public charge within 5 years after entry for causes not affirmatively shown to have arisen subsequent to arrival in the United States be based upon fact and not upon opinion. End of section 24.
Section 25 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Patrick McHaffie, Evanston. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5. Chapter 14. Relief in Deportation Cases. Deportation orders frequently affect many people in addition to those against whom action is taken. The alien's spouse and children, often citizens, are linked with the destiny of the deportee. The hardships caused in many cases by such an order have prompted measures for discretionary relief, some by statute and some by administrative regulation or practice. The provisions for relief were well defined prior to the Immigration and Nationality Act of 1952. Although in many aspects they were not entirely adequate, in general they appeared to be reasonably satisfactory. The Act of 1952 restricted or eliminated practically every provision for discretionary relief. General deportation statutes cannot deal justly in every situation, and the Commission believes that a sound immigration law should continue to authorize the alleviation of excessive hardships in individual worthy cases. 3 principal discretionary remedies existed prior to the Act of 1952. 1. Voluntary departure. 2. Pre-examination. And 3. Suspension of deportation. In addition to these administrative remedies, there was a fourth one of a legislative character, the growing practice of introducing in Congress private relief bills to forestall deportation. Voluntary departure. In many instances, a person may be deportable for reasons which impute no personal blame. For instance, a temporary visitor may be prevented from or delayed in leaving the United States by causes beyond his control. A seaman discharged at an American port may be unable to find a new ship within the period of shore leave allotted to him. A student may be financially or physically unable to continue his studies. A diplomatic official may resign because his new home government is unfriendly to him and us. He may even be a defector from communism. In recent years, many persons in a temporary status in the United States have been unable to return to their home countries which have fallen under communist control. In other instances, personal fault is slight or difficult to assess. Some aliens who have come into the country for pleasure or business may have wittingly or unwittingly failed to comply with the laws pertaining to entry. In all such cases, the aliens are subject to deportation. Until 1940, there was no specific statutory authorization to do anything but to deport such people. However, deportation involves a personal stigma, and a person deported from the United States commits a crime if he reenters without the specific permission of the Attorney General. To avoid such situations to the extent desirable, and to save the government the trouble and expense of deportation, the discretionary remedy of voluntary departure was devised by administrative officials. The discretionary remedy of voluntary departure is merely permission to the deportable alien to leave the United States within an allotted time and without a deportation order. Voluntary departure serves the needs of the government and of the alien in meritorious cases. The Alien Registration Act of 1940 required an alien to prove that he was a person of good moral character for 5 years before he could be allowed voluntary departure. It precluded the granting of such relief to persons deportable for various violations of law relating to subversives, criminals, prostitutes, and narcotics. Although the Act of 1952 adopts the rule of the 1940 Act, it gives unrestricted administrative authority to grant voluntary departure before deportation proceedings have been started. However, the Act of 1952 in effect limits the opportunities for granting this relief through an unreal definition of good moral character, which is discussed more fully in relation to suspension of deportation and to deportation. The expedient of voluntary departure has been widely used. The large volume of illegal entries of Mexican agricultural laborers across the southern border of the United States has created a need for flexibility. It would be difficult and expensive to ascertain whether each such illegal entrant possessed particular qualifications before he could be permitted to depart from the United States. Deportation hearings are expensive for the government and burdensome upon the alien. Moreover, the expulsion of the alien entails large costs, which are avoided if the alien is permitted to depart at his own expense. The Commission recommends that administrative officials should have authority to permit aliens who are illegally in the United States to depart at their own expense. The conditions and circumstances under which that privilege is granted should be left to the sound discretion of the administrative officers without the unnecessary limitations now found in the statute. Pre-examination. In many instances, persons in a temporary or irregular status desire to establish permanent residence and are otherwise eligible to do so. Since under the immigration law, consuls are not authorized to issue immigration visas in the United States, an alien desiring adjustment of status to permanent residence was required to return to his country of origin for such visa. This was an expensive procedure which served no useful purpose either for the alien or for the United States. To meet this situation, the administrative authorities in 1935 devised a process known as pre-examination. An arrangement was made with Canada under which aliens who had been authorized such pre-examination in the United States could enter Canada to obtain an immigration visa at any American consulate in that country for the purpose of re-entering the United States immediately as an immigrant. The United States guaranteed to Canada that it would permit the immediate re-entry of such aliens. Pre-examination consisted merely in examining a prospective immigrant in the United States to determine his admissibility. Under this procedure, an alien took a short trip to Canada instead of a long and expensive trip to his home country. Pre-examination depended entirely on administrative regulations and practices. It was often coupled with an authorization for voluntary departure. Under the established procedure, an alien was not allowed pre-examination unless he demonstrated to the immigration authorities that an immigration visa was immediately available, which means that for a quota immigrant, a quota number must be currently available and that he was otherwise admissible under the immigration laws. An alien granted pre-examination could complete all his preliminary arrangements by mail. Usually, after receiving an appointment from a United States consul in Canada, he could enter Canada, apply for and secure his visa, and re-enter without being outside the United States for more than a day or two. Pre-examination did not eliminate the usual checks and procedures in issuing visas. No persuasive evidence seems to have been presented to justify a contrary view. In any event, any loopholes or other difficulties could have been remedied by the administrative authorities. The following are typical cases in which the privilege of pre-examination was authorized. Case 1. The alien, a Norwegian, was admitted to transit in 1942 with other survivors of a torpedoed vessel on which he had been chief engineer. Because of unfitness for sea duty, he remained ashore. He became the president of a ship cleaning company which performed war work. He was eligible to first priority for a non-preference quota visa because of his services at sea during the early days of the war. He was allowed voluntary departure and pre-examination so that he could go to Canada and apply for his visa instead of returning to Norway. Case 2. The alien became a citizen in 1926. He returned to Italy in 1930 and resided there until 1946, at which time he re-entered the United States as a citizen. Unknown to him, his naturalization had been canceled in 1935. It was concluded that he had obtained an American passport and re-entered the United States in good faith. Under the circumstances, the application was found exceptionally meritorious and pre-examination was authorized so that he could enter Canada and obtain his visa instead of returning to Italy to obtain it. Case 3. The alien, a 29-year-old native and citizen of the Republic of the Philippines, last entered the United States as a seaman on January 5, 1947. He intended to remain permanently, but had none of the necessary immigration documents. He had enlisted in the Army of the United States in Australia in 1942 and served until his honorable discharge in 1945. He is the holder of 5 decorations. His good moral character for a 5-year period was established by the record. He was eligible for the issuance of a first priority non-preference quota visa. By reason of his war service, his case was found to be exceptionally meritorious. He was granted the privilege of voluntary departure and pre-examination so that he could go to Canada to apply for his visa instead of returning to the Philippines. During 1951, out of a total of 1,945 new applications for pre-examination, which were filed by aliens not subject to deportation proceedings, 1,201 were approved and 156 denied. 30 pre-examinations were revoked. Effect of 1952 Act. Although the Act of 1952 did not in express terms abolish the practice of pre-examination, the Congressional Conference Committee stated that it contained a prohibition against pre-examination. The regulations issued by the Immigration and Naturalization Service adopt the conclusions suggested by the conferees and, in effect, abolish pre-examination. The theory of this action, as explained in the conference report, was, quote, that the pre-examination system was cumbersome, obsolete, and, as practiced, contained certain loopholes for the admission for permanent residence of undesirable aliens, end quote. The pre-examination procedure was generally believed to be reasonably adequate. It seems somewhat strange that criticism of the procedure of pre-examination should have been based, as the Commission is informed, on opinions expressed by the administrative officers who devised and operated it, and who had ample authority to plug any loopholes in it, and otherwise make it conform to proper practice. Congress, in eliminating pre-examination, did not supply a satisfactory substitute. It introduced a new procedure called Adjustment of Status of Non-Immigrant. In one important respect, this seems an improvement over former practices, since it allows adjustment of status in the United States without requiring a trip to Canada. But the Act of 1952 surrounds the new procedure with conditions and limitations which apparently permit only a few to qualify and which therefore may be self-defeating. For example, this new adjustment of status may be granted only to an alien lawfully admitted as a non-immigrant or temporary visitor and who is continuing to maintain that status. By denying adjustment to otherwise admissible aliens whose present status is irregular for one or another reason, the new procedure loses one of the major benefits in the old system of pre-examination. The only avenue provided for the great number who cannot meet such rigidly limited conditions is suspension of deportation. But this requires a finding that they are deportable and the procedure is slow, cumbersome, and expensive. In fact, in most such cases arising under the 1952 Act, an alien who resides in the United States and who would be qualified immediately to immigrate to the United States if he lived overseas must again make the long and expensive trip to his homeland in order to obtain a visa and return. The Commission recommends that an alien in the United States in a temporary or irregular status be given the privilege of having his status adjusted to that of a lawful permanent resident without being required to leave the United States if he is currently qualified to enter the United States under the immigration laws. This will entail mental and physical examination, security clearance, and satisfaction of all qualitative requirements, as well as the present availability of a quota number when it is required. The presence of such an alien in the United States should not give him any preference or advantage over prospective immigrants in foreign countries. Suspension of deportation. Congress has provided that hardships created by the inflexible provisions for deportation may be avoided through a procedure known as suspension of deportation. Most of the aliens who become legal residents follow the usual course of obtaining immigration visas abroad. For example, in the fiscal year 1951, 156,547 quota immigrants were admitted from abroad. Only 1,506 aliens became legal residents through suspension of deportation, and charges were made against the proper quotas. During 1950, the respective figures were 197,460 and 833. After thorough consideration of the problem during several sessions of Congress beginning in 1934, the discretionary power to suspend deportation was finally enacted in the Alien Registration Act of 1940. The Attorney General was authorized to suspend deportation of a deportable alien who had proved good moral character for the past 5 years if deportation would result in serious economic detriment to the alien's citizen or legally resident spouse, parent, or child. This consideration was denied to aliens deportable as subversives, criminals, prostitutes, the mentally and physically deficient, and aliens racially ineligible for naturalization. In each instance where deportation was suspended, a quota number was deducted from the current quota of the alien's home country. The Alien Registration Act of 1940 required that each case be reported to Congress, and suspension of deportation became final unless, by concurrent resolution, Congress disapproved. Amendments in 1948 enlarged the suspension authority, but also introduced some restrictive features. A deportable alien who had resided here for 7 years was made eligible, even though he did not have the specified family ties. But this provision was limited to aliens who were in the United States in 1948. The amendments also removed the previous bar on aliens racially ineligible for citizenship. But instead of the previous requirement that suspensions of deportation were final unless the Congress passed a concurrent disapproving resolution, the Act of 1948 made them final only if Congress passed a concurrent resolution affirmatively approving them. Effect of Act of 1952. The Act of 1952 severely limits the authority to grant suspensions of deportation, although it makes such relief available to groups previously ineligible for it. In place of the relatively simple previous procedure, the Act of 1952 substitutes an involved statutory scheme. In order to be eligible for suspension of deportation, prior to the Act of 1952, an alien had to show serious economic detriment to specified close relatives unless he had resided here for 7 years. The Act of 1952 requires that the alien must be, quote, a person whose deportation would, in the opinion of the Attorney General, result in exceptional and extremely unusual hardship, end quote, to the alien or to the specified relatives. The Senate committee report makes it clear that the remedy, quote, should be available only in the very limited category of cases in which the deportation of the alien would be unconscionable. Hardship or even unusual hardship to the alien or to his spouse, parent, or child is not sufficient to justify suspension of deportation, end quote. In commenting on this new language and the committee's explanation, one distinguished witness testifying at the Commission's hearing said, quote, rarely has there been a balder statement of a national purpose to be cruel, end quote. Even the technical experts have difficulty arriving at an understanding of the provisions of the Act of 1952 relating to suspension of deportation. The Act establishes 5 classes of aliens eligible for suspension of deportation and prescribes for each such class a continuous period of physical presence in the United States up to the date of application for suspension. The shortest period for which the alien must have continuously been physically present is 5 years. The longest is 10 years. The 10-year period indiscriminately covers subversives, criminals, and prostitutes on the one hand, and persons who merely violated purely technical provisions of the law on the other hand. Prior to the 1952 Act, an alien who supported his American citizen wife could have obtained suspension of deportation no matter how short his stay in this country had been. The new Act requires 5, 7, or 10 years of continuous, quote, physical presence, end quote. The alien must prove that he has been a person of good moral character during the entire period. The new law contains a highly restrictive definition of good moral character, creating many uncertainties. For example, the Immigration and Naturalization Service testified at the Commission's hearings that the crime of adultery was inadequately defined in the Act of 1952. Except for persons who came to the United States before June 27, 1950, an alien may not be granted suspension if a final order of deportation has been entered in his case. This subjects the alien to the arbitrary requirement that the date of an order of deportation controls his right to be considered for suspension of deportation. Often, an alien who does not qualify for suspension of deportation under the Act of 1952 will be able to return almost at once as a permanent legal resident of this country. Under other provisions of the law, he may be entitled to a preferred immigration status for visa consideration by reason of his citizen or legally resident wife or children. In other cases, for lack of the remedy of suspension, the alien may suffer the disruption of his family. Many witnesses criticized the restrictions on the authority to deal with hardships imposed by the Act of 1952 as being repugnant to American principles of justice and humanity. Among them was the late Philip Murray, representing the Congress of Industrial Organizations, CIO, who stated, quote, that the authorities administering the law should have sufficient discretion to enable them to take humanitarian considerations into account. These resident aliens about whom we are talking may have lived in this country for years, may have married spouses who are American citizens, and may have children who are American citizens. Deportation of the alien may mean intolerable hardship for the family. The officials enforcing the laws should therefore have authority to look at the whole picture and decide whether, in the light of all the circumstances, the national interest will or will not be served by deportation of an individual. The laws should be administered in a liberal and humanitarian rather than a technical and punitive spirit." End quote. The Commission believes that the statutory requirement for congressional approval of suspension of deportation actions is contrary to our fundamental constitutional doctrine of separation of legislative, executive, and judicial powers. The basic concept of our American system is that the Congress makes the laws, the executive administers them, and the judiciary interprets them. Our form of government is built upon a tripartite system of checks and balances, intended to assure that no one branch of government encroach upon any of the others. The failure of the Congress to follow the constitutional pattern is obstructive of good government and destructive of fundamental principles. In immigration matters, in particular, it frustrates proper administration and puts a premium on extraneous considerations in the determination of legal rights. The exercise of discretion according to standards fixed by Congress is peculiarly an executive function. The legislature is not equipped and not intended to be equipped to handle the details of administration. The provision for legislative approval of determinations in individual cases requires an administrative agency within the legislature itself attempting to redo what the administrative agency has already done, but without the safeguards which the Congress and the courts have insisted shall surround administrative action. This is wrong in principle and bad in practice. It is no more the function of Congress to pass upon individual cases involving suspension of deportation than it would be to pass upon the issuance of individual visas, or for that matter upon the custom inspection of an individual alien's baggage. One searches in vain for a comparable example of intermingling of executive and legislative authority. The determination of the existence and extent of tremendous human and property rights is confided to the discretion of executive officials. For example, the Selective Service System periodically drafts tens of thousands of the youth of America into the armed forces, including aliens, without submitting all the individual cases to Congress for its approval. The Atomic Energy Commission has virtually unlimited discretion in effecting a crucial program affecting our survival. The Interior Department has large discretion in regulating the affairs of Indians. The Veterans Administration functions in many fields affecting veterans. The Mutual Security Agency and the Reconstruction Financing Corporation are empowered to allocate billions of dollars. The Interstate Commerce Commission, Federal Communications Commission, Civil Aeronautics Board, and Federal Power Commission have power to grant invaluable franchises and to fix rates affecting millions of people. And even the immigration laws themselves grant broad discretion in some respects to administrative officers to enforce restrictive requirements. Yet the Attorney General cannot suspend the deportation of one alien without reporting the case to Congress and obtaining its approval. The Commission recommends that any alien in the United States in irregular status who does not qualify for adjustment of status, as above described, may be granted suspension of deportation in the discretion of the administrative officer upon a showing of good moral character for 5 years, and a serious economic detriment to the alien's citizen or legally resident spouse, parent, or minor child, or b. residence in the United States for 7 years. These recommendations would restore the provisions for suspension of deportation substantially to their position prior to the Act of 1952. The Act of 1952 authorizes suspension of deportation for former subversives, criminals, and other groups previously denied this remedy. This authority should be continued subject to a limitation that such aliens must have resided in the United States for 10 years. The Commission recommends that administrative officials be given authority to exercise reasonable discretion to suspend deportation without the necessity for congressional action in individual cases. Special legislation. Another consequence of the inflexibility of the immigration laws is the enactment by Congress of private relief bills, exempting named individuals from particular restrictive provisions. Until the past decade or so, private relief bills in immigration matters were virtually unknown. But during recent years, Congress has been deluged with an increasing flood of such bills. Thus, while only 163 private bills in immigration and nationality cases were introduced in the 78th Congress, there were 429 in the 79th Congress, 1,141 in the 80th Congress, 2,811 in the 81st Congress, and 3,669 in the 82nd Congress. The number of private bills has been a heavy burden on Congress. Moreover, it has added substantially to the problems of administration. In most instances, the introduction of such a bill has been followed by a request from a committee of Congress to the Department of Justice for an investigation of the facts and a report. Under arrangements between the Department of Justice and committees of Congress, deportation frequently has been withheld while a private bill is pending. The result is that the private bill device has afforded an opportunity to delay or defeat deportation, and has overburdened Congress and the administrative authorities. The sponsors of the Act of 1952 have stated that its enactment would substantially diminish the volume of such bills. But others predict a different result, in view of the many oppressive features of that legislation, including the severe limitations on the discretionary relief of adjustment of status and suspension of deportation. The increase in the number of private immigration bills introduced into and passed by the Congress is itself evidence that something is wrong with our immigration laws. The Commission believes that the unnecessary hardships which private bills seek to correct would better and more fairly be corrected by enactment of a reasonable immigration law, including adequate discretionary authority vested in responsible administrative officials. End of section 25. Recording by Patrick McHaffie, Evanston. Section 26 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Patrick McHaffie, Evanston. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Section 26. Part 5, Chapter 15a. Security Protections. Chapter 15. Security Protections. Since the earliest days of the Republic, Congress has expressed concern over the activities of subversive aliens in our midst. The Alien Act of 1798 authorized the President to order the departure of any alien whom he deemed dangerous to the United States. The Alien Enemy Act of 1798, passed 2 weeks later, permitted the apprehension, restraint, and removal of alien enemies, if deemed necessary for the public safety. The first law was so unpopular and violated such fundamental American principles that it was allowed to expire after 2 years. The second, limited in application to time of war or threatened invasion, is still in effect. It was not, however, until 1903 that the law barred the entry of aliens who were regarded as inimical to the safety and security of the country. By a 1903 statute, anarchists and those who believed in or advocated the forcible overthrow of the government of the United States, or of all forms of government, or the assassination of public officials, were denied admission to the United States. These provisions were continued and strengthened in 1907 and 1917. The Anarchist Act of 1918, as amended in 1920, enlarged the description of aliens classed as subversive. It barred from the United States aliens who write, publish, or cause to be written or published, or circulate, distribute, or display, or possess for such purposes any written or printed matter advising, advocating, or teaching opposition to organized forms of government, or the overthrow by force or violence of government, or the killing of officers generally, or unlawful damage to or destruction of property or sabotage. The Supreme Court in 1939 had occasion to interpret the laws which authorized the exclusion of aliens deemed subversive and the deportation of those in the United States who were members of or affiliated with subversive organizations. The Supreme Court's decision required a finding by the government of present membership or affiliation in order to support the exclusion or deportation of an alien. However, the Congress reversed this situation in the Alien Registration Act of 1940, which made such membership at any time a ground for exclusion and deportation. Other enactments between 1940 and 1950 generally strengthened and to some extent enlarged the description of classes to be excluded or deported from the United States as subversives, and authorized the denial of visas to and the exclusion of aliens seeking to enter the United States for the purpose of engaging in activities which would endanger public safety. In the years immediately following the close of hostilities of World War II, a growing awareness developed of the inadequacies of existing law to cope with communism's drive for world domination.
To meet this increasing threat, Congress enacted the Internal Security Act of 1950. This act greatly enlarged the proscribed classes of subversive aliens. For the first time, the Communist Party was mentioned by name. The terms communism, communist organization, communist front organization, totalitarianism, advocates, and doctrine were defined by statute. Moreover, the Act makes membership, association, or affiliation with an organization required to register as a subversive organization under the Subversive Activities Control Act of 1950, a ground for exclusion and deportation. In addition, the discretion of the Attorney General to admit subversive aliens under pre-existing legislation was completely eliminated with respect to aliens returning to the United States to resume a permanent residence after a temporary absence abroad. Subversive aliens seeking temporary admission could do so only under a severely curtailed discretion of the Attorney General, and where exercised, the Attorney General was required to make a detailed report to Congress. Many provisions of the Internal Security Act of 1950 were attacked at the time as being unnecessarily harsh, improper, and not in the best interests of the country. The provisions of the Internal Security Act of 1950 have been carried forward into the Immigration and Nationality Act of 1952 without substantial change. The only significant difference in the treatment of subversive aliens under the 1952 Act is that the definition of totalitarian party is limited to an organization which advocates the establishment of a totalitarian dictatorship or totalitarianism in the United States. This would bar admission of members of the Communist Party, but some have expressed concern that it would not bar from the United States members of the Nazi, fascist, or Phalange parties. Security screening process. The various administrative agencies have endeavored to establish effective processes to screen out and bar subversive people. The State Department has devised an elaborate screening process in an attempt to ascertain whether applicants for visas come within the statutory designations of subversives. The law requires each applicant for a visa to prepare a lengthy documented application. In addition, the consular officers usually require the alien to submit a questionnaire designed, when completed, to provide a basis for a background check of the alien from a security point of view. After an examination of the papers submitted by the alien, sources of information available in the local Foreign Service posts of the United States and so-called lookout notices from the Department of State and the Department of Justice are checked. American officers at the Foreign Service post, such as the military, naval, air, or economic attachés, are consulted to ascertain whether their respective spheres of operation have uncovered any information which might have a bearing on the alien's admissibility. Checks with other sources of information available abroad are utilized wherever practicable. The alien is invited to appear at the consular establishment to be examined under oath concerning his background and other factors bearing upon his eligibility for admission to the United States. If any derogatory information is uncovered, further action on the alien's application is suspended, pending additional examination or pending reference of the application to the Department of State. should the derogatory information indicate that the alien falls within one of the prescribed subversive classes, the interrogation is usually conducted more thoroughly in order firmly to establish the facts relating to the alien's admissibility. The alien may or may not be given an opportunity to rebut the derogatory information on file. The consular officer may, of course, refuse to issue a visa at any stage of the investigation, but if he entertains any doubt as to the alien's admissibility from a security standpoint, he is required by regulation to refer the case to the Department of State for an advisory opinion. For former voluntary members of proscribed organizations, no visa may be issued without an advisory opinion. If an advisory opinion from the Department of State is unfavorable, no visa may be issued. However, even if the Department of State renders a favorable advisory opinion, the consular officer may still refuse a visa as he sees fit. Wherever possible, the Department of State conducts an independent and supplemental security check utilizing various intelligence facilities of our government. Special provisions of law which relate to accredited officials of foreign governments or representatives of foreign governments to international organizations generally make impossible the application of normal screening processes to them. On the other hand, classes of aliens who, because of their profession, occupation, or previous status, present special problems, are subjected to even closer scrutiny and additional checks. Possession of a visa does not entitle an alien to enter the United States. A visa is, in effect, a permit to apply for admission. An alien with a visa who applies for admission to the United States is required to satisfy the Attorney General that he is eligible under the immigration laws for admission. The Immigration and Naturalization Service has authority to make a completely independent security check upon an alien presenting a visa. Immigration officials at this point have the benefit of advice and information from various intelligence sources in the United States and elsewhere. Once an alien is in the United States, he may be deported for subversive activities. The investigations preceding the arrest in deportation and the consequent hearing may have been made by one or more of the several intelligence agencies of the United States government, or may have been conducted by the Immigration and Naturalization Service. Thus, at each stage of the immigration process, the issuance of a visa, the admission at ports of entry, or deportation, the facilities for the detection or apprehension of the subversive alien represent the combined efforts of many intelligence and investigating agencies, in addition to the agencies administering the immigration law. The Commission made efforts to learn whether security agencies and those responsible for the administration of the immigration laws had any specific recommendations to make in order to strengthen the security provisions of such and related laws. At the time these efforts were made, the Act of 1952 had not become effective. However, the Commission is able to report that as of the time of its inquiry, the security measures in the laws and regulations were believed to be adequate. The sole exception was the suggestion that the Commission recommend provisions to enable immigration authorities to exclude applicants for visas who are active members of or believe in the principles advocated by Nazi, fascist, and other such totalitarian organizations. Generally speaking, the immigration laws deal with three groups of subversives. 1. Spies and saboteurs. 2. Present members and affiliates of subversive organizations. And 3. Former members or affiliates of subversive organizations. Spies and saboteurs. The Act of 1952 makes ineligible to receive a visa and requires the exclusion of, quote, aliens who the consular officer or the attorney general knows or has reason to believe seek to enter the United States solely, principally, or incidentally to engage in activities which would be prejudicial to the public interest or endanger the welfare, safety, or security of the United States. Aliens with respect to whom the consular officer or the attorney general knows or has reasonable ground to believe probably would, after entry, a. engage in activities which would be prohibited by the laws of the United States relating to espionage, sabotage, public disorder, or in other activity subversive to the national security. B. Engage in any activity a purpose of which is the opposition to or the control or overthrow of the government of the United States by force, violence, or other unconstitutional means. Or C. Join, affiliate with, or participate in the activities of any organization which is registered or required to be registered under Section 7 of the Subversive Activities Control Act of 1950. End quote. Such aliens, even if they are permanent residents, returning after a temporary absence abroad, are specifically denied the benefits of the exercise of discretion. Provisions relating to the parole of aliens into the United States or to the waiver of documents for non-immigrant aliens are not intended by Congress to include these subversive aliens, save for the possible purpose of prosecution for crime. Such aliens may be deported at any time without regard to when they entered the United States. Legislation which establishes an absolute bar against admission to the United States of those whose purpose in entering is to engage in activities which violate our laws relating to espionage, sabotage, public disorder, or national security must remain on our statute books and be strictly enforced. These statutory provisions give authority to deal with spies and saboteurs. However, the Act of 1952 gives a consular officer the absolute and unreviewable power to bar aliens whom he, quote, knows or has reason to believe seek to enter the United States solely, principally, or incidentally to engage in activities which would be prejudicial to the public interest, end quote, or with respect to whom the consular officer, quote, knows or has reasonable ground to believe probably would, after entry, end quote, engage in subversive activities. Elsewhere, Chapter 11, the Commission discusses unreviewable administrative action. The difficulties are here aggravated because the statutory language is so undefined. It is susceptible of as many different interpretations as there are men applying it. Such absolute and unreviewable discretion is not necessary for the protection of the security of the United States. The statute should, without doubt, leave ample room for the exercise of discretion for the protection of the national security, but it should contain definite standards to guide administrative action so as to guard against abuse. The vague language of the Act of 1952 does not meet this need, and it should be revised so as to specify that it applies to aliens who seek to enter or who are believed to be seeking to enter for the purpose of violating the criminal laws of the United States relating to espionage, sabotage, and public order, or violating the laws relating to the protection of the conduct of military and foreign affairs, and relating to the protection of other activities and functions of the government and other public agencies, national, state, and local, upon which the national security depends. The administrative review elsewhere recommended for visa denial, exclusion, and deportation actions should be applicable here. Chapter 11. Present members and affiliates of subversive organizations. The law forbids entry to aliens who are anarchists or who are members or affiliates of the Communist Party or other totalitarian organizations, or who advocate or teach opposition to or violent overthrow of all organized government, or who write, publish, display, or circulate, or who possess for circulation any written or printed matter which teaches or advocates world communism, opposition to or forceful overthrow of government, the killing of officers of government, the destruction of property, or sabotage. Subversive aliens barred from admission to the United States are not limited to those who are members of the proscribed organizations, but also includes those who are affiliated with such groups. With respect to all classes of subversive aliens, except anarchists, the law authorizes the issuance of a visa to such an alien if he establishes to the satisfaction of a consular officer, and the consular officer finds that the membership or affiliation of the alien in a subversive organization is involuntary or occurred when the alien was under 16 years of age. It is necessary, in addition, however, that at the time the alien applies for admission to the United States, the Attorney General must independently be satisfied and also find that the alien to whom a visa was so issued was involuntarily a member of or affiliated with any of the enumerated subversive classes. The law authorizes the deportation of any alien who at the time of entry was within any of the classes excluded by law. It also provides for the deportation of any member of each of the categories of subversive aliens who is, or at any time after entry has become, a member of any of the proscribed classes of subversive aliens. Discretionary relief in connection with deportation is denied to aliens who are present members of subversive groups. There can be no doubt that present members or affiliates of subversive organizations should be excluded from the United States. The issue is what is to be regarded as member, affiliate, or a subversive organization. In these respects, the Commission believes that our present laws are not adequate. In part, the difficulty is that the Act of 1952 is lengthy, complex, repetitive, and obscure. As to membership, the Commission believes that the provision of the present law exempting involuntary members is desirable and sound. The purpose of the immigration law should be to bar only those aliens who, by their membership or affiliation with subversive groups, have identified themselves with the aims and principles of those groups. These exemptions should be interpreted broadly, so that the statutory injunction will encompass only those who were subversives at heart, and will not reach those who were merely nominal members, or as a result of compulsion or mistake. such involuntary membership or affiliation merits the exception which the statute gives it. Affiliation is not fully defined in the 1952 Act, and the statute merely states, quote, "The giving, loaning, or promising of support or of money or any other thing of value for any purpose to any organization shall be presumed to constitute affiliation therewith, but nothing in this paragraph shall be construed as an exclusive definition of affiliation," end quote. This definition is an improvement over the similar one contained in the Internal Security Act of 1950, which made the giving, loaning, or promising of support or of money a conclusive presumption of affiliation. Nevertheless, even this improved definition should be read in the light of the congressional expression of need for legislation controlling subversive activities contained in the Internal Security Act of 1950. Quote, "In carrying on the activities referred to in paragraph 6, establishment of communist totalitarian dictatorship as part of the world communist movement, such communist organizations in various countries are organized on a secret conspiratorial basis and operate to a substantial extent through organizations commonly known as communist fronts, which in most instances are created and maintained or used in such manner as to conceal the facts as to their true character and purposes and their membership. One result of this method of operation is that such affiliated organizations are able to obtain financial and other support from persons who would not extend such support if they knew the true purposes of and the actual nature of the control and influence exerted upon such communist fronts." End quote. The security of the United States must be protected against aliens guilty of true affiliation with subversive organizations. However, the statutory definition of affiliation condemns those who give support to front organizations for any purpose, and thus may reach the innocent as well as the guilty. The definition of affiliation should make it clear that the law bars those aliens who, by their support or contribution or other form of affiliation, knowingly and willingly seek to further the subversive aims and principles of the organizations. This proposal is in keeping with the present law's provision authorizing the admission to the United States and the naturalization of aliens who became affiliated with a communist organization without knowledge of its character. In one respect, the Act of 1952 leaves a security loophole and so does not go far enough to protect the national security. Although the statute attempts to encompass every activity and belief that might be deemed subversive, it fails to ban members or affiliates of foreign totalitarian organizations other than communist. It bars admission to, quote, "aliens who are members of or affiliated with, for, the communist or any other totalitarian party of any state of the United States, of any foreign state, or of any political or geographical subdivision of any foreign state." End quote. Comprehensive though it sounds, this subsection may not bar Nazis, fascists, or other totalitarian groups who are not communists. This clause was carried forward verbatim from the Internal Security Act of 1950, but whereas the Internal Security Act defines the terms totalitarian dictatorship and totalitarianism as, quote, systems of government not representative in fact, characterized by a. the existence of a single political party organized on a dictatorial basis with as close an identity between such party and its policies and the governmental policies of the country in which it exists, that the party and the government constitute an indistinguishable unit, and b. the forcible suppression of opposition to such party." End quote. The Act of 1952 adds to the above definition the following, quote, "The term totalitarian party means an organization which advocates the establishment in the United States of a totalitarian dictatorship or totalitarianism." End quote. Both the Senate and House committee reports are silent on the significance of the definition limiting a totalitarian party to one which advocates the establishment of totalitarianism, quote, "in the United States," end quote. It would appear, however, that the new definition is intended to exclude from the ban of the immigration laws totalitarian parties such as the Nazis, fascists, and phalangists, who are believed not to advocate the establishment of a totalitarian dictatorship in the United States. No less than communism, other forms of totalitarianism degrade the dignity of man and deprive him of those rights which our Declaration of Independence holds to be unalienable. It is contended that the law should make a distinction between present membership in the Communist Party and present membership in other totalitarian parties, on the ground that communism is the only present menace. While such a distinction appears plausible in the light of the imminence of the communist peril, the resurgence of neo-Nazism and neo-fascism in Germany and Italy underlines the danger of treating such totalitarian movements too lightly. Nazi and fascists and other advocates of totalitarianism may not be developing plans today to overthrow the government of the United States or any other democratic government by force and violence. There was a period, however, when they did attempt to dominate the world. The cost of stopping that effort was the heaviest ever paid in the history of the world. The millions of graves of those who died that democracy might survive, or who perished as victims of mass murder, the hundreds of thousands who were maimed, the millions who were stripped of their possessions and forced to undergo undescribable suffering, privation, and misery, the destruction of the economic resources of once prosperous and happy peoples. These results of the evil ambitions, the cruelties of Nazism and fascism should keep the United States alert forevermore to the danger from that source. The communists and the Nazis pooled their ideologies and their plans for world conquest to begin World War II. The subsequent disintegration of that unholy partnership was fortunate for the democracies, but we shall be inviting disaster if we receive the disciples of one form of totalitarianism while arming for defense against the other. The Commission deems the present adherents of all forms of totalitarianism to be hostile to our way of life and believes they should be banned from the United States. A problem that has troubled the Commission has been the undesirable alien who is a product of our own society. Elsewhere, the Commission has urged that such aliens not be deported. Where such an alien is a present subversive, a special issue arises. Apart from the fact that such an alien is a product of our society, the difficulty, as pointed out to the Commission by the Immigration and Naturalization Service, is that deportation orders for subversives often prove futile. Mr. Justice Jackson succinctly stated the problem in his dissenting opinion in United States versus Spector, 343 U.S. 169 at pages 179 through 180. Quote, "A deportation policy can be successful only to the extent that some other state is willing to receive those we expel. But, except selected individuals who can do us more harm abroad than here, what communist power will cooperate with our deportation policy by receiving our expelled communist aliens? And what non-communist power feels such confidence in its own domestic security that it can risk taking in persons this stable and powerful republic finds dangerous to its security? World conditions seem to frustrate the policy of deportation of subversives. Once they gain admission here, they are our problem, and one that cannot be shipped off to some other part of the world." End quote. A law which cannot be enforced brings the entire administration of justice into disrepute. The Commission requested the Immigration and Naturalization Service for advice and recommendations to meet the problem of aliens who are under orders of deportation but cannot be deported because no country will accept them. The answer was that the Internal Security Act of 1950 had provided, and the Act of 1952 had contained, certain limited sanctions to aid in effectuating an order of deportation against persons in the subversive, criminal, and other undesirable groups, and that no other methods of dealing with this matter had been devised. Under such circumstances, therefore, the Commission believes that this country should accept as its own responsibility all those aliens who are the product of our own society. The Commission recommends that 1. Present members of subversive or totalitarian organizations, or persons who, by their present affiliation with such organizations, manifest their belief in or sympathy with the aims and principles of such organizations, should be denied visas and should be excluded from admission to the United States. Present membership or affiliation should create a presumption of such belief or sympathy, subject to countervailing evidence to prove that such membership or affiliation was involuntary. 2. The definition of totalitarian party, totalitarian dictatorship, and totalitarianism should be clarified so that it embraces all aliens in sympathy with the governmental theories and policies of totalitarianism as that word is defined in the Internal Security Act of 1950. 3. Affiliation, as used in the immigration laws, should be defined so that it embraces only those aliens who, by their action and conduct, have demonstrated an association with totalitarian groups because of sympathy for or agreement with the subversive aims and principles of such groups. 4. Alien members or affiliates of subversive organizations who were lawfully admitted to the United States for permanent residence prior to reaching the age of 16 years or who were lawfully admitted for permanent residence and have resided in the United States continuously for at least 20 years should not be subject to deportation, but should be dealt with in the same manner as subversive citizens. End of section 26. Recording by Patrick McHaffie, Evanston.
Section 27 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Andy Glover. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5. Chapter 15b. Former membership or affiliation with subversive organizations. At one time, as witness to the Alien Registration Act of 1940, present and former members of subversive organizations were treated alike. However, in the Act of 1952, Congress recognized that former membership in or affiliation with subversive groups or organizations should not be an absolute bar to admission or stay in this country. It made two exceptions. The first is where such membership or affiliation was involuntary or occurred when the alien was under 16 years of age. The second is where membership or affiliation has been terminated for 5 years, and for that period the alien has been actively opposed to such subversive ideologies, and where the admission of the alien would be in the public interest. Each case in this last category must be reported to the Congress. The deportation of former members or affiliates of subversive classes is, as in the case of present members, provided for by the law. However, unlike present members, former members or affiliates of subversive groups are eligible, under severely limited conditions, to receive discretionary relief by way of suspension of deportation. The problem of past membership or affiliation is obviously a difficult one. If there is merely a severance of formal bonds of association without a corresponding repudiation of sympathetic belief in the aims and principles of the subversive group, such aliens continue to be threats to our security. A former member who has made a genuine break with subversive ideology offers no threat to our security. Indeed, experience has shown that such converts may represent very stable adherents to the principles of democracy, because they are less likely again to succumb to the false blandishments of totalitarianism. The removal of the absolute bar against former and now reformed subversive aliens strengthens our own internal and external security and advances our foreign policy. However, the Act of 1952 contains other important defects. For example, the requirement of 5-year active opposition to a formerly held totalitarian ideology may defeat important objectives of our intelligence and foreign policy agencies. Escapees who come out from behind the Iron Curtain, or defectors from communism elsewhere, may be of vital and immediate importance to our security and defense, as well as to our foreign policy. And yet they must wait 5 years, although there may be conclusive proof of complete reformation in a shorter period of time. Indeed, retention of an inflexible 5-year bar against former subversives might seriously impair the Commission's proposals to grant priority to refugees from communism. Chapter 9. The requirement of active opposition to former doctrines misses the point. Most people who have genuinely renounced subversive ideas do not become active pamphleteers, speakers, or professional anti-totalitarians. The genuineness of their opposition to totalitarianism cannot be measured by the loudness of their disclaimers. There is an inconsistency in our laws relating to former membership or affiliation in subversive organizations. The Act of 1952 carries forward the previous law's failure to coordinate the naturalization and deportation directives aimed at former members of subversive organizations. The naturalization law permits the admission to citizenship of former subversives whose membership in the prescribed organization ended more than 10 years earlier. But the deportation statute apparently permits the expulsion of such former subversives at any time, even after 10 years has expired since the membership or association with the subversive group terminated. It would seem reasonable to suppose that if a former member of a subversive group is eligible for naturalization after 10 years, he should, by the same token, be able to avoid deportation. There are also the grossly inconsistent provisions to the effect that a former member of a subversive organization who actively opposed that subversive organization for a period of 5 years may now be admitted into the United States, although he was never here before, while a long-time resident alien who 30 years ago resigned from membership in a subversive organization, left it, and has since actively opposed it, must be deported. The Commission believes that the provisions of the Act of 1952, to the effect that membership in or affiliation with subversive organizations should not necessarily be a bar to entry into the United States, are sound, and the Commission recommends that these same provisions be extended to cover deportation procedures, so that former membership in or affiliation with subversive organizations, genuinely repudiated over a period of at least 5 years, should not be a ground for deportation. The Commission recommends that the requirement of active opposition should be amended by deleting the word active, thus making its benefits available to all opponents of totalitarianism. The Commission recommends that the requirement of 5 years opposition should be subject to waiver in appropriate cases, after thorough screening and approval by the appropriate security agencies of the United States. This would make possible the admission of bona fide escapees and defectors. The Commission recommends that the immigration law apply the same conditions to former members and affiliates of all totalitarian parties, whether they were communist, Nazi, fascist, or other such parties. It should be noted, too, that the law requires a finding by both the consular officer and the Attorney General that the admission of the alien would be in the public interest, without criteria under which in the public interest may be measured. The phrase seems too vague for effective administration. It is quite conceivable that administrative officers might seldom, if ever, find that the admission of a former communist, Nazi, or fascist would affirmatively be in the public interest. The Commission recommends that the law should require a finding that the admission of a former subversive would not be contrary to the public interest. Exclusion without hearing. Security considerations sometimes create special problems in connection with otherwise normal immigration procedures. At least for the past 60 years, an alien has been entitled to a hearing before he can be excluded at a port of entry. However, when the ground for his exclusion involves confidential information, the disclosure of which would be detrimental to the best interests of the United States, there is a conflict between two important values. On the one side is the security of the United States. On the other is the fundamental concept of American law that a person is entitled to a fair hearing before the government takes action affecting him. From at least 1893 until 1941, no alien, not even a subversive, could be excluded without a hearing, In 1941, such provision was made. The Passport Act of 1918 authorized the President in time of war or national emergency to impose additional restrictions and prohibitions on entry into and departure from the United States, upon a finding that the interests of the United States so required. The President issued a proclamation on November 14, 1941, reciting the existence of a national emergency and declaring that no alien should be permitted to enter the United States if it appears to the satisfaction of the Secretary of State that such entry would be prejudicial to the interests of the United States. As provided in regulations issued by the Secretary of State with the concurrence of the Attorney General, these regulations authorized the Attorney General to deny hearings when a person is excludable, on the basis of information of a confidential nature, the disclosure of which would be prejudicial to the public interest. From the evidence before the Commission, including testimony before congressional committees and various United States government briefs in the Supreme Court, this measure was intended to have only limited application. It seems that this procedure was designed to provide a legal sanction for denying access to the United States during war or national emergency only in those special cases where disclosure of the information or the source of the information on the basis of which the exclusion is ordered for security reasons would be contrary to the national interest. During the war years, this new procedure was sparingly used. The Immigration and Naturalization Service reports that only a negligible number of aliens were excluded without a hearing. However, with the end of hostilities, immigration to the United States was resumed on a larger scale. In addition, the nation became increasingly aware of the threat to its security by world communism. These two circumstances resulted in an enlarged application of the hitherto limited measure of denying entry without a hearing, because of confidential information. Aliens who had been or were associated with communist activities, and those suspected of such affiliation, were excluded without hearing in substantial numbers at seaports, and to a much larger extent at land ports of entry. From December 1948 to July 1, 1952, approximately 2,000 aliens, other than seamen, were temporarily excluded without a hearing, and in about 500 cases, the exclusion without hearing was made permanent. The constitutionality of exclusions of aliens without hearing was upheld by the Supreme Court. The Internal Security Act of 1950 provided the first express statutory authority for excluding an alien without a hearing in security cases. Unlike the Passport Act, however, the Internal Security Act of 1950 does not limit the exercise of the power to exclude without hearing to time of war or national emergency. These provisions of the Internal Security Act of 1950 are carried forward into the Act of 1952. The consideration of exclusions without hearing cannot be isolated from the larger problems created by the efforts of the United States to safeguard its security during the current era of international tensions. At many levels in our national life, we have been confronted with the dilemma of attempting to resolve apparent conflicts between our national safety and traditional concepts of freedom. The attempt to discover a precise line of demarcation is a quest that has led us in many directions and has not yet resulted in any satisfactory solution. The Commission believes that the present situation in connection with exclusions without hearing is unsatisfactory. The protection of the right to a fair hearing is essential to a democracy. Any legal process which affects people's rights without giving them a chance to be heard is ordinarily regarded as being repugnant to the American sense of fair play. It denies a person the opportunity to defend himself against what may be false accusations. It encourages slanders by people whose stories may be generated by malice, misinformation, or the desire for self-advancement. However, in time of crisis, there may be need for extreme measures to protect the national security and even perhaps for some relaxation of our traditional safeguards for individual rights. Under present world circumstances, it may be necessary for the United States government to have authority to bar, without a hearing, aliens whose admission would directly menace the national safety. However, such a power should not be exercised except in the extreme and unusual case where the national security or the lives, welfare, or continued usefulness of our intelligence agents and informants are immediately affected by the fact that the very holding of a hearing will cause disclosure of highly secret information. The officials who have exercised the extraordinary power to exclude aliens from the United States without hearing have been motivated, the Commission believes, by a sincere desire to protect the nation. However, there is some public belief that this unusual power has been or may be used to excess and without adequate safeguards. And there is some evidence, including testimony of a responsible immigration official before a congressional committee, to substantiate this belief. The law should provide measures to avoid abuse of this extraordinary power, and to limit its exercise to those few and rare cases in which the security of the United States is actually involved. The Commission recommends that determination as to whether an alien should be excluded without a hearing on the basis of confidential information should be made by the proposed Board of Immigration and Visa Appeals, recommended in Chapter 10. Each alien affected should, unless the proposed Board of Immigration and Visa Appeals decides to the contrary, receive notice of the nature of the charges against him, and such other information as the Board may determine, after consultation with intelligence agencies, will not prejudice the public interest. Any such alien should have the opportunity, before any such determination is made, to testify and to present in person or by counsel any information or evidence or argument he may desire to submit on his own behalf. These procedural safeguards should be incorporated into the statute or in regulations issued thereunder. A determination to exclude without a hearing should be supported by strong and convincing evidence, not mere rumor or unsustained suspicion. It should be reached only after every effort is made to investigate the charges and evaluate the confidential information. It should never be used because evidence is not easily obtainable. In this way, the Commission believes that the security of the United States would be protected and a procedure established to preserve the American concept of fair dealing, non-immigrants. During its hearings, the Commission was advised of the serious problems raised by denial or delays in the granting of visitors' visas to distinguished scientists, scholars, and other leaders in the arts, professions, and business. The Commission believes that no special rule should be made for visitors or non-immigrants who are present members or affiliates of subversive organizations. However, the problem seems to have arisen because of former association with such organizations. In discussing the subject of visas for immigrants who wish to come for permanent residence and who were former members of subversive organizations, the Commission expressed doubt as to the wisdom of a rule in the Act of 1952, which set an inflexible 5-year period between renunciation of such membership and eligibility for such visas. There seems to be no necessity for applying such a 5-year rule to temporary visitors. If the visa-issuing officers have authority to issue a non-immigrant or visitor's visa to a former member of a subversive organization, without regard to a 5-year period of renunciation. Their decisions can be made on the basis of the facts in each particular case. The length of time since repudiation of the subversive ideology, the nature of subsequent opposition to such views, the purpose and length of the proposed visit to the United States, the alien's field of activity and background, and the character of his sponsorship are all factors relevant in such considerations. Some of the complaints during the Commission's hearings concerning non-immigrant visas relate to administration. It was said that the consular offices are understaffed and cannot act rapidly enough to serve the needs of American universities and other institutions which sponsor and invite distinguished visitors for symposia, conferences, or other meetings. Another suggestion arose out of the embarrassment suffered by leading American institutions which invite foreign guests and make preparations for their reception, only to find that they are refused visas. The Commission was requested to recommend that the law provide a pre-clearance system for professional and scientific persons invited to the United States by universities and scientific or other institutions. The purpose of this suggestion is to obtain a binding commitment in advance from the Department of State that a particular scientist or professor would be issued a visa upon application. In this way, invitations would be extended only to those whose admissibility to the United States was assured, and the embarrassments of the present situations could be eliminated. The Commission believes that this suggestion should be given a trial, unless some more effective procedure is devised. A matter of great importance to the United States is the status of defectors. These generally are official representatives of a totalitarian government, who, while officially in the United States, defect and request asylum here. Such persons normally were admitted only because of their diplomatic status. Having lost such status, the law requires that, as former subversives, they be deported. Temporary arrangements now are made to bridge the gap. If the defection of such former official is genuine, his contribution to the cause of democracy in combating the ideologies which he formerly embraced is usually invaluable according to the highly reliable advice given to the Commission. The law should permit adjustment of the status of such a person so that he may remain in this country and aid in the cause of democracy. The Commission recommends that arrangements be made to expedite the granting of visas to distinguished scientists, scholars, and other leaders in the arts, professions, and business invited to the United States for temporary visits by responsible institutions, and that consideration be given to the inauguration of a pre-clearance system, so that it could be determined in advance whether particular individuals would be admitted as temporary visitors. The Commission recommends that aliens should be permitted to enter the United States for temporary visits, regardless of former membership or affiliation with subversive organizations, if the purpose of their visit is legitimate, and if there is no reason to believe that they will engage in activities inimical to the United States. The Commission recommends that bona fide official defectors from totalitarianism be permitted to adjust their status to permit them to remain in the United States. End of section 27.
Section 28 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Patrick McHaffie, Merritt Island. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5, Chapter 16A. Citizenship. Chapter 16. Citizenship. American citizenship is one of the most valuable rights in the world today. The manner in which it can be acquired or lost is a matter of deep concern to all Americans. It is important that the establishment of such a basic right shall be clearly defined, and that unreasonable conditions shall not defeat the creation and maintenance of citizenship status. American citizenship may be acquired through birth or naturalization. All persons born in continental United States, Alaska, Hawaii, Puerto Rico, Virgin Islands, and Guam, with a few exceptions, are citizens of the United States at birth. Persons born abroad to American citizen parents derive citizenship through their parents. If only one parent is a citizen of the United States, citizenship may, subject to certain limitations, be transmitted to the child at birth. The privilege of naturalization is open to all resident aliens who can prove 5 years lawful residence, good moral character, and attachment to the principles of the Constitution of the United States. By law, special benefits, such as waiver of some of the residence requirements, are provided to certain groups. Among these special groups are spouses and children of citizens and aliens with military and maritime service. The Immigration and Naturalization Service exercises administrative supervision over the naturalization process, but naturalization can be granted only by a naturalization court. Citizenship can be lost in two ways. The first is denaturalization, which applies only to naturalized citizens and subjects them to revocation of citizenship by court order. The second is called expatriation and applies to all citizens, native-born and naturalized, making them subject to loss of citizenship for certain acts deemed inconsistent with the duties and obligations of citizenship. There are 10 such types of conduct now specified by statute which cause expatriation, including obtaining naturalization in a foreign state, taking a foreign oath of allegiance, renunciation of American citizenship, serving in a foreign army, and voting in a foreign election. In certain respects, the Act of 1952 made significant improvements in the nationality laws. Among these were the complete abolition of the racial disqualifications, confirmation of the right to naturalization of conscientious objectors on religious scruples, elimination of the formal declaration of intention as a prerequisite for citizenship, and removal of the literacy requirement for older people. However, there are some undesirable substantive and procedural provisions in the Act of 1952 relating to nationality problems. It is in the national interest to encourage qualified aliens to become American citizens. Naturalization requirements or procedures which unreasonably restrict the full integration of qualified aliens into the American community are unwise. Obviously, provisions which unreasonably subject American citizens to loss of their citizenship, or which discriminate among American citizens by failing to treat them all equally, are not in our country's best interest. Second-class citizenship. Many witnesses before the Commission were critical of what they characterized as second-class citizenship. The complaint concerned provisions of the Act of 1952, which give naturalized citizens an inferior status to native-born citizens. This situation arises in relation to the status of naturalized Americans and the rights of Native Americans who have acquired dual nationality at birth. Conduct subsequent to naturalization. Since 1906, the naturalization laws have authorized revocation of naturalization after it has become final and fully effective. Denaturalization has no counterpart in the status of the native-born American. Naturalization is a judicial function. In passing upon an application for citizenship, the naturalization court must determine whether the applicant has met qualifications prescribed by Congress. If the applicant has deceived the court, it seems entirely appropriate that the benefits he has improperly obtained should be taken away. A safeguard against hasty or ill-advised action is the requirement that denaturalization can be accomplished only upon order of a naturalization court. Fraud or illegality in the naturalization proceeding directly affects the propriety of the naturalization itself and justifies its cancellation. However, what happens after the court has granted naturalization is another matter. The Act of 1952 has introduced new provisions which have gone beyond the protection of the naturalization process and have created the possibility of denaturalization on the basis of conduct occurring after naturalization. These innovations in the Act of 1952 were deplored in testimony during the Commission's hearings. They were characterized as devices which, if extended, would jeopardize the status of millions of naturalized citizens. It was pointed out that since native-born citizens were not subject to such penalties, the statute tended to make the naturalized American a second-class citizen. There are several examples of this type of provision in the statutes. An illustration is the statutory presumption of fraud, which authorizes denaturalization in the absence of countervailing evidence because of a naturalized citizen's residence in a foreign country. Such residence, subject to naturalization, is related back to the naturalization itself. This category of presumptive fraud applies to naturalized citizens who, within 5 years after naturalization, establish residence in a foreign country. In applying for citizenship, an applicant must swear that he intends to reside permanently in the United States. Since 1906, the naturalization statute has designated as presumptively fraudulent the naturalizations of persons who establish residence in a foreign state within 5 years after naturalization, and has made their naturalizations subject to revocation in the absence of other evidence. Approximately 95% of revocations of naturalization have been on this ground. In 1951, out of an aggregate of 403 denaturalizations, 384 were for presumptive fraud in establishing residence abroad within 5 years after naturalization, and the remaining 19 were for actual fraud or illegality. The Act of 1952 introduces a new ground for denaturalization for presumptive fraud, specifying that if within 5 years after naturalization a naturalized citizen joins or affiliates with a subversive organization, membership in which would have barred the grant of citizenship, his naturalization is subject to revocation as presumptively fraudulent. In such cases, it is presumed, in the absence of contrary evidence, that the naturalized person was not attached to the principles of the Constitution of the United States or well disposed to the good order and happiness of the United States. Another example of such a provision is the new one in the Act of 1952, which subjects to denaturalization an alien who is convicted of contempt of Congress for refusing, within 10 years after his naturalization, to testify before a congressional committee concerning his subversive activities. These three illustrations differ in one important respect. The former two are presumptions which relate to whether the original naturalization was obtained by fraud through concealment of material facts. Both relate to the naturalized person's intentions at the time of applying for naturalization, and thus present formidable difficulties of proof. In the two presumptions mentioned in the statute, the conduct which follows after the naturalization appears to negate the declarations as to intention and belief made by the naturalized person when he sought citizenship. Although the loss of citizenship through presumption is undesirable, it seems reasonable to assume, until further proof is presented, that a naturalized person swore falsely in stating that he intended to reside permanently in the United States when he actually became a permanent resident of a foreign country soon after his naturalization. This presumption can be rebutted, and often is, by evidence submitted to consular officers or to a naturalization court indicating that the representations in the naturalization application were bona fide. So, too, it does not appear unreasonable to assume that a naturalized person sworn falsely in declaring that he was attached to the principles of the Constitution when he joined a subversive organization within a short period after his naturalization. Here, too, the opportunity is offered to the naturalized person to prove that he is not guilty of deception in connection with his naturalization. Although these two directives for loss of citizenship through presumptive fraud are aimed only at naturalized citizens, the Commission concludes that they relate to the propriety of the naturalization itself and represent a reasonable measure of control against fraudulent naturalizations. The provision relating to contempt of Congress is of another character. As undesirable as the conduct may be, it does not necessarily relate to the legality of the original naturalization. The punishment of proved subversives is necessary to our national security. But where there is no evidence of fraud in the original naturalization, the use of denaturalization as such a punishment is dangerous to our welfare as a nation, because such legislation is a disturbing step in the direction of insecure citizenship status. The threat today to the citizenship of naturalized citizens who defy Congress may tomorrow menace the status of all naturalized Americans. The naturalized citizen who violates the law should be punished, but his punishment should be no different from that applicable to a native-born citizen. Denaturalization should not be used as an additional penalty for discrimination between native and naturalized citizens. The Commission recommends that a naturalized citizen should not be subject to denaturalization for conduct subsequent to his naturalization, unless such subsequent conduct proves that he obtained his citizenship by fraud or illegality. Residence in a foreign country. In 1907, Congress provided that any naturalized citizen who resides for 2 years in the foreign state from which he came, or 5 years in any foreign state, shall be presumed to have lost American citizenship. The 1907 Act was designed to deal with the difficulty experienced by the State Department in affording protection to American citizens resident in foreign lands, particularly naturalized citizens who returned to their countries of origin. The presumption was used only to relieve the State Department of the obligation to extend diplomatic protection to those naturalized citizens who remained abroad for the prescribed period of time. Citizenship was not lost thereunder, however, since the courts construed the presumption of loss of nationality as one easy to overcome, for example, by returning to the United States, regardless of the length or cause of absence. In 1940, Congress abolished the presumption and provided for the absolute loss of citizenship by a naturalized citizen by reason of mere residence abroad, residing for 2 years in the country of birth or former nationality, if by such residence he acquires nationality of such state, residing for 3 years in the country of birth or former nationality, or residing 5 years in any foreign country. The Act of 1952 retains the 3- and 5-year residence periods for loss of nationality. These provisions for loss of nationality, limited to naturalized citizens, create a second-class citizenship status. Native-born citizens have an unrestricted right to travel and remain abroad as long as they please. A naturalized citizen may remain abroad no longer than 5 years. The loss of citizenship under this law is now automatic. It is no longer a mere presumption subject to rebuttal. It has been urged upon Congress that naturalized citizens who return to their countries of origin or former nationality are apt to renew old associations and ways of living, and thus lose to a large degree, if not completely, their American ties. Furthermore, it is objected such naturalized citizens, although wholly divorced from American life by reason of resumption of former residence and ways, transmit their American citizenship to their foreign-born and reared children. This argument, however, does not apply to the provision for loss of nationality by naturalized citizens who go to a third country. In this respect, the situation posed by protracted foreign residence is the same for the native-born as it is for the naturalized citizen. Neither goes back to a former culture or way of life. The foreign-born children of both are equally removed from American customs, traditions, and ways of life. There is no reasonable distinction between native and foreign-born citizens under such circumstances. These provisions are detrimental for several reasons. By attaching strings to a naturalization order, they create a body of citizens unable to do, except on penalty, what other citizens may do. Secondly, they undo a judicial determination without the benefit and protection of court action. Naturalization is obtained through a formal judicial proceeding, determined by the entry of a formal judgment. All judgments should be clothed with that degree of finality necessary to the orderly process of judicial administration. Judgments in naturalization should similarly be vested with finality. If fraud in obtaining naturalization is suspected, a judicial proceeding to set aside the judgment is necessary. The loss of naturalized citizenship by reason of mere residence abroad should not result from legislative fiat. The Commission recommends that a naturalized citizen may lose citizenship by 3 years' residence in a foreign country only if the country be the one of his birth or former nationality, and that in such case the foreign residence should create a presumption of the loss of citizenship which, unless rebutted in an appropriate judicial proceeding, may result in the entry of a judgment terminating his citizenship. Dual nationality at birth. Under the laws of some countries, the nationality of parents is vested in the children, no matter where they are born. Consequently, if born in the United States of aliens who are citizens of such a country, children would have citizenship in the United States and also in the country of their parents. Likewise, if they were born in a country where their parents, native or naturalized citizens of the United States, maintained residence, they would be citizens of the country of their birth and also of the United States.
Such persons are known as dual nationals. The Act of 1952 incorporates a new provision, the purpose of which is to cause the loss of nationality of a native-born citizen who at birth also acquired a foreign citizenship, if he should reside for 3 years in the state of his foreign citizenship at any time after attaining the age of 22 years, and seek or claim the benefits of such foreign nationality. The full force of this provision is lessened by exempting from its operation those dual nationals who are abroad for certain specified purposes, and who, prior to the expiration of the 3-year period of residence, take an oath of allegiance to the United States before an American diplomatic or consular officer. Witnesses at the Commission's hearing criticized this provision, stating that it improperly curtailed the rights of native-born Americans and that such dual nationals should be subject to loss of their citizenship only for the same causes that apply to other native citizens. The purpose of this statutory provision is to eliminate a status of dual nationality in which a person who resides in a foreign country and is not, in fact, identified with the United States uses his American citizenship only when it suits his purposes. It is not in the national interest to permit retention of dual nationality by a person to whom American citizenship is only a matter of convenience and who has no real tie with the United States. Consequently, there is merit in the principle which requires the dual national, under certain circumstances, to make an election between his nationalities. However, the Commission believes the present statute should be revised in several respects. The statute does not distinguish between dual nationals who were born in the United States to American parents, who live in this country virtually their entire lives, and dual nationals who were born abroad to American citizens and have never been in the United States. Americans born here or abroad who have spent their formative years in the United States and who reside in this country when they reach the age of 21 should be deemed to have elected American citizenship and should not be treated differently than any other citizens. There should be no limitation on the purposes for which Native Americans can reside in a foreign country, provided they have elected to retain their American citizenship. The statute should provide greater assurance against retention of two citizenships by dual nationals residing abroad by requiring them to renounce their foreign nationality when they take an oath of allegiance to the United States. Birth in territories or possessions. All persons now born in Alaska, Hawaii, Puerto Rico, Virgin Islands, and Guam, subject to the jurisdiction of the United States, acquire United States citizenship at birth. However, the status of persons previously born in those possessions is not clear. Former statutes wove a patchwork pattern which left obscure and uncertain the status of many inhabitants of such territories, particularly Puerto Rico. The Act of 1952 did not clarify these obscurities. The Commission recommends that the citizenship status of persons born in the territories and possessions of the United States be clarified by explicit statutory provisions. The Commission recommends also that legislation be enacted to confer citizenship benefits upon the indigenous inhabitants of American Samoa, the last major possession of the United States to which the protections of American citizenship have not been extended.
statelessness. It is commonly accepted that every person should have a nationality, and that statelessness should be avoided. Yet our laws today contain many grounds for the loss of American citizenship, which have no relationship to the acquisition of another nationality. One informed witness before the commission stated that, quote, "We have more grounds for revoking citizenship through expatriation than any other country," end quote. Under our laws, a person may lose his American citizenship although he has no wish to give it up, and although he does not at the same time acquire citizenship in another country. As a result, he becomes a stateless person. There is a valid and important difference between giving up one's nationality by voluntary expatriation and becoming stateless by virtue of legislative mandate. In the early days of the country, the United States was the international champion of every individual's right to expatriate himself. In 1868, Congress declared by statute that the right of expatriation is a natural and inherent right of all people. We were then welcoming and seeking immigrants from the Old World, and the refusal of European rulers to recognize American naturalization of its former subjects was a matter of concern to us. But although the United States recognized and espoused the inherent right of all persons to expatriate themselves, our own laws were silent as to what actions by our citizenry would result in voluntary expatriation or involuntary forfeiture of citizenship. The courts and administrative officers solved such issues as they arose. In 1907, Congress declared that any American citizen shall be deemed to have expatriated himself when he has been naturalized in a foreign state or has taken an oath of allegiance to any foreign state. Except for statutes providing for loss of the rights of citizenship in time of war by deserters or draft evaders, the law remained unchanged until enactment of the Nationality Act of 1940. This greatly increased the kinds of actions and conduct on the part of American citizens which would affect their expatriation or loss of nationality. The Act of 1952 continued in the framework of the Nationality Act of 1940 with some modifications. The 1952 Act lists 10 grounds upon which both a native-born or naturalized citizen may lose his nationality, in addition to the provisions that deal especially with naturalized citizens and dual nationals. Experience under the 1940 Act, according to informed observers, has shown that some of the grounds of expatriation have deprived American citizens of citizenship as a result of acts committed under circumstances which do not warrant such a loss. Perhaps the most serious objection to the inclusion of so many grounds for expatriation is that the law thus enlarges the class of stateless people. Some of the many examples which illustrate this characteristic of the law are as follows. Service in foreign armed forces. Prior to 1952, service in the armed forces of a foreign state, without express authorization by the laws of the United States, caused expatriation and loss of American citizenship only if the person had or acquired the nationality of such foreign state. The Act of 1952 makes mere service itself an act of expatriation, without regard to whether it involved an oath of allegiance to such foreign state or any act or course of conduct inconsistent with the duties and obligations of American citizenship, unless, prior to entry into such armed forces, such service has been officially authorized in writing by the Secretary of State and Defense. Service in foreign armies by American citizens can be motivated by many purposes entirely consistent with allegiance to the United States. Thus, before entry of the United States into World War II, many Americans volunteered for service in the armies of Canada, Great Britain, and other nations later allied with the United States. Other young Americans serving in foreign armies because of a spirit of adventure. Still others may serve as technicians. No sound national purpose is served by imposing the loss of citizenship unless the service is accompanied by an oath of allegiance or is undertaken by one who has or acquires the citizenship of the foreign nation in whose army he serves. The Commission recommends that the law, in this respect, be restored to what it was prior to the Act of 1952. Voting in foreign political election. The Act of 1952 continues without change the provision of the Nationality Act of 1940 that voting in a political election of a foreign state is a ground for expatriation. Although exercise of the franchise in a foreign country ordinarily denotes allegiance to that country, experience with this provision has proved troublesome. Congress has found it necessary to pass legislation excusing such voting in certain elections in Italy. The fact is that voting in political elections is not always restricted by the laws of foreign countries to their own citizens. In the Italian elections a few years ago, for example, a campaign was waged from the United States to urge all qualified persons to vote. A similar situation occurred in occupied Japan and Germany. Furthermore, both the courts and administrative officials of the government have had difficulty in determining what is a political election. This cause for expatriation also creates or may create a group of stateless persons. In such cases where eligibility to vote in a foreign state, even in political elections, is dependent only upon the ownership of property in the foreign jurisdiction, the act of voting is not inconsistent with allegiance to the United States. The Commission recommends that citizenship be lost by virtue of voting in the political elections of a foreign state only where eligibility to participate in such elections is by the laws of such foreign state restricted to its own citizens, and where the person who so voted had or acquired the nationality of such foreign state. End of section 28. Recording by Patrick McHaffie, Merritt Island. Section 29 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Patrick McHaffie, Merritt Island. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5, Chapter 16b. Disruption of family unity. Our nationality policy has always sought to foster the unity of families among American citizens. However, in some important respects, the law today disrupts such family unity by its action in connection with citizenship. Birth outside the United States to American citizen parents. Since 1790, the laws of the United States have provided for acquisition of United States citizenship by children born abroad to parents who were American citizens. The obvious purpose was to maintain unity of citizenship between American parents and their children. For many years, only the father could transmit United States citizenship, but since 1934, citizenship may be derived through either parent. When both parents are citizens, the statute plainly sanctions transmission of citizenship to their child at birth abroad. However, when only one parent is a citizen, the statutory conditions have become increasingly restrictive. The Act of 1952 requires actual physical presence in the United States for 10 years by the citizen parent prior to the child's birth, at least 5 years of which were after attaining the age of 14. The purpose of requiring prior residence of the parent to ensure identification with the United States appears sound, but the requirement of physical presence apparently would exclude a parent who had been out of the United States temporarily, even for a few days. The Act of 1952 also continues the provision of the 1940 Act, which precludes transmission of citizenship by a Native American parent under 19 years of age who has lived in the United States his entire life, but whose child happened to be born outside the United States. Thus, the statute does not confer American citizenship upon the child born outside the United States to an 18-year-old Native American soldier stationed overseas or to an 18-year-old Native American girl temporarily in an adjacent foreign country. The Commission recommends that the crucial factor in transmitting citizenship to a child born outside the United States should be the American citizen parent's previous residence rather than continuous physical presence in the United States. The Commission recommends that a child born abroad to a Native American parent should acquire United States citizenship at birth without regard to the age of the parent or the length of time such parent has resided in the United States. Alien spouses of citizens. Until 1922, the naturalization laws of the United States provided for the citizenship unity of husband and wife. An alien woman who married an American thereby became an American citizen. An American woman who married an alien lost her American citizenship. Since September 22, 1922, the citizenship status of husband and wife have been independent of each other. At the same time, our national policy has continued to take into account the need for promoting unity in family citizenship status on a voluntary basis. This has been done by granting liberal benefits under the nationality laws to the spouses of American citizens. The Act of 1952 has continued this policy, but has introduced undesirable limitations. For example, it increases the requirements for naturalization of spouses of American citizens, many of whom may be the brides of American servicemen. The required probationary period is lengthened to 3 years, and additional residence requirements, including one of physical presence, are imposed. These added restrictions were criticized by witnesses at the Commission's hearings. The Commission recommends that the spouse of an American citizen should be eligible to become naturalized upon completing 1 year of residence in the United States in marital union with the citizen spouse, following lawful admission for permanent residence. Alien children of citizens. The same considerations of family unity underlie the derivation of citizenship by children of naturalized citizens. It is desirable that a minor child living with his parents in the United States should acquire American citizenship with his parents. The law always has provided for such derivation of citizenship by minor children automatically upon the naturalization of their parents. In 1940, the maximum age at which such a child could derive such citizenship was lowered from 21 to 18 years, and derivation occurred only when both parents or the sole parent were naturalized. The Act of 1952 lowered the maximum age of derivation to 16 years. There seems to be no valid reason for such curtailment of the rights of children. The child cannot himself apply for naturalization until he reaches the age of 18, and it seems entirely proper that until then his citizenship status should be governed by that of his parents. The Commission recommends that the maximum age for acquiring derivative citizenship through the naturalization of alien parents be restored to the age of 18 years. Handicaps to acquiring and maintaining citizenship. Other unreasonable provisions for the acquisition and loss of citizenship are prescribed in the Act of 1952. Definition of good moral character. The requirement that naturalization applicants must show good moral character during the required probationary period of residence has been part of our naturalization laws since 1795. Until 1952, however, the statute did not define good moral character, but left the definition to the courts to interpret. It was ruled that the statute did not insist on moral excellence, but required conduct that measured up to the prevailing standard of behavior in the community. Although opinions differed on some issues, this formula was a flexible one, which on the whole seemed satisfactory in operation. Although the statutory qualifications for citizenship have undergone relatively few changes for nearly 150 years, the interpretations placed upon the statute by the courts have been subjected to many changes. Long-established precedents have been discarded in favor of newer concepts generally more liberal to the applicant for citizenship. During the last decade, the courts increasingly have seemed to interpret the statutes in the light of moral trends as conceived by them. The result has been a gradual relaxation of earlier, more rigorous standards. The Act of 1952 does not undertake a full definition of good moral character, but the statute attempts to describe certain patterns of conduct that are not to be regarded as fulfilling the requirement of good moral character. In each instance, the new law usually attempts to negate a specific court decision. Thus, for example, the statute provides that a person who has committed adultery during the prescribed period of good behavior cannot establish good moral character. In testimony before the Commission, the Immigration and Naturalization Service urged amendment of this provision for the reason that the variations among different states in defining adultery would make this provision difficult to administer. Experience in administration has revealed matrimonial relationships of long stability and respectability, entered into in complete good faith, which are irregular only because of some technical defect. The declaration by law that innocent participants affected are not persons of good moral character may be contrary to the facts. This is merely one illustration of the results of the narrow definition of moral character in the Act of 1952. The Commission recommends that the statute continue to require applicants for naturalization to establish good moral character, without defining that term. The interpretation of this requirement should be left to the courts, as it was before the the Act of 1952. Requirement of continuous residence. In requiring specified periods of continuous residence by applicants for naturalization, the statute always has taken into account the needs of aliens whose homes were in the United States, but who were necessarily absent from time to time. The Act of 1952 made some improvements in the provisions affecting such aliens, but in other respects the statutory benefits seem unnecessarily curtailed. The principal objection seems to be to the requirement for periods of physical presence in the United States aggregating at least 2½ years as a prerequisite to eligibility for citizenship. Representatives of Coca-Cola Export Corporation and International General Electric have pointed out to the Commission that this limitation reduces the value of the statute. In their overseas operations, American institutions of research and business concerns frequently employ aliens who reside in the United States. It is to the advantage of such organizations, to the aliens, and to the government of the United States to permit such aliens to become citizens. But the nature of their employment often requires such aliens to remain away from the United States for long periods of time. The restrictive provisions of the Act of 1952, in effect, would deny them the benefits of American citizenship. The Commission recommends that the requirement of the Act of 1952 for continuous physical presence be eliminated in the cases of aliens necessarily absent from the United States in the employment of an American research or business organization. Naturalization of aliens with military service. For many years, the naturalization laws awarded citizenship benefits to aliens who served in the armed forces of the United States. The benefits varied for different periods of service, and the statutes were confused and obscure. The Act of 1952 introduced conditions of increased severity. Among these are the new requirements that the veteran must prove lawful admission to the United States for permanent residence and 5 years good moral character. A separate section benefits veterans of World War I and World War II, but carries forward an earlier requirement that they must have been lawfully admitted for permanent residence if they were not enlisted or inducted in the United States. No special benefits have as yet been extended to the veterans of the conflict in Korea. The Commission recommends that the following group of alien veterans be permitted to become American citizens without being subjected to any additional requirements other than current proof of good moral character and attachment to the principles of the Constitution of the United States. 1. Aliens who have served honorably for 3 years in the armed forces of the United States at any time, or 2. Aliens who served honorably in the armed forces of the United States during World War I or World War II, or 3. Aliens who have served honorably in the armed forces of the United States in the military operations in Korea. Denaturalization for concealment or misrepresentation. The Naturalization Act of 1906 provided that naturalization could be revoked on the ground that it was fraudulently or illegally procured. These grounds for revocation were retained in the law until 1952. In the report of the Senate Judiciary Committee, which preceded the Act of 1952, it was stated that there was confusion in the court decisions on what constituted fraud, and the committee therefore recommended that the statute authorize revocation for concealment of a material fact or willful misrepresentation. That formula was adopted in the Act of 1952. Fraud is a term found in many statutes. The courts have ruled that a naturalization is illegally procured when one of the essential statutory requirements for naturalization is lacking. The administration of the prior law seems to have presented no real difficulty, and there was no suggestion from any administrative source that the statute's language needed revision. Moreover, for 46 years, the Department of Justice had followed a policy of not instituting denaturalization proceedings where the violations were minor, and where it would not be to the interest of the United States to revoke citizenship. Consequently, denaturalization for fraud or illegality has been sought in comparatively few cases in recent years. In 1950 and 1951, a total of only 42 naturalizations were canceled for fraud or illegality. The following table from the annual report of the Immigration and Naturalization Service for 1951 lists the causes for such revocations during that year. Table 15. Naturalizations revoked during 1951 for fraud or illegality. Failed to meet residence requirements, false allegations, 5. Bad moral character, fraud involved, 1. Misrepresentations and concealments relating to marital and family status, 3. Bad moral character, no fraud involved, 2. Dishonorable discharge following naturalization based on military service during World War II. 2. Unwilling to bear arms, oath taken with mental reservation. 1. Naturalization fraudulently or illegally procured. 2. Other grounds. 3. Instead of eliminating supposed confusion, the requirements of the Act of 1952 are likely to result in confusion. In place of a definite, widely understood formula, it substitutes a new one: concealment of a material fact and willful misrepresentation, which is bound to engender uncertainty and provoke litigation. In eliminating illegality as a ground for denaturalization, the new act may make it possible for aliens who actually were subversives or criminals at the time of their naturalization to escape denaturalization on a claim that they were not asked about their subversive or criminal activities and consequently made no misrepresentation. The Commission recommends that the previous grounds for denaturalization be restored so that naturalization obtained by fraud or illegality be subject to cancellation. Absence of statute of limitations. The Act of 1952, like previous naturalization laws, provides no statute of limitations restricting the time during which action may be brought to revoke naturalization. There have been instances in which denaturalization suits have been brought 20 or 30 years after the granting of naturalization. Elsewhere, Chapter 13, the Commission recommends that a 10-year statute of limitations be established for the commencement of deportation proceedings against aliens who enter the United States illegally. The same considerations are controlling in relation to denaturalization. A person who obtains citizenship wrongfully should be subject to revocation of his citizenship. The possibility that naturalization may be revoked at any time is a threat against the stability of status of all naturalized citizens. Obviously, too, the lapse of time may cause significant changes in circumstances, as a result of which the rights of innocent third persons may become involved. The Commission recommends that no proceedings for denaturalization be instituted after the expiration of 10 years following the date of naturalization. Loss of derivative rights. The naturalization of an alien may result in the automatic vesting of citizenship rights in such alien's spouse and children. The revocation of the naturalization of the person through whom such citizenship was derived may have a decisive effect on their claim to derivative citizenship. The law in effect prior to 1940 made no mention of the effect of a denaturalization proceeding upon derivative rights. However, the courts generally ruled that if the basic right was found to have been improperly obtained, the derivative rights likewise were expunged, regardless of the number of years during which the derivative citizen had innocently continued to exercise the rights of American citizenship. The stringency of this rule was modified by the Nationality Act of 1940, which provided that the citizenship of the derivative citizen was extinguished only upon a denaturalization for actual fraud, and that the derivative rights were not affected when the naturalization was revoked for illegality or presumptive fraud. The Act of 1952 modified the rule of the 1940 Act. Hereafter, derivative rights will fall whenever naturalization is canceled on the ground that it was procured by concealment of a material fact or by willful misrepresentation. When citizenship is canceled for presumptive fraud, all derivative rights will be extinguished, except where the derivative citizen is residing in the United States at the time the naturalization was revoked. No public interest seems to be served by withdrawing citizenship of a derivative citizen where he himself is free from fault. The rule of the 1940 Act was sound and workable, and sought to avoid excessive disturbance of the status of persons whose American citizenship had become vested and often had endured for many years. The Commission recommends that the rule of the law prior to the Act of 1952 be restored, and that derivative rights of citizenship shall be extinguished only when the naturalization from which they are derived is revoked on the ground of actual fraud. Naturalization procedures. Although the witnesses at the Commission's hearings did not refer as often to problems of naturalization as to immigration, there was evidence of a belief that the last decade marked a steady improvement in the procedures of naturalization cases, in the cooperation maintained with schools and social agencies aiding the applicant for naturalization, and in the attitude of the administrative officers in dealing with naturalization applicants. Satisfaction has been expressed with the efforts of the Immigration and Naturalization Service in the promotion of education and training for American citizenship, and for encouraging aliens who seek to qualify for naturalization. However, the procedure for naturalization written into law still seems open to objection. Procedure in court. Since 1926, provision has been made by statute for appointment of naturalization examiners, known as designated examiners, to conduct preliminary examinations of naturalization applications and to make formal recommendations to the naturalization courts. Originally, such designations were made by the courts themselves. Since 1940, the designations have been made by the naturalization officials. The designated examiner system proved a great convenience to the courts, the applicants, and the Immigration and Naturalization Service. Where the examiner's recommendation is favorable, the applicant is usually admitted to citizenship without any further inquiry. In questionable cases, or in cases where the examiner's recommendation is adverse, the facts are fully presented to the court. In 1943, the Immigration and Naturalization Service instituted centralized review of the recommendations of the designated naturalization examiners. The purpose was to produce uniformity and improvement in such recommendations. The Act of 1952 continues a requirement introduced by the Internal Security Act of 1950 that where the Attorney General's recommendation to the court disagreed with that of the designated examiner, both recommendations should be submitted to the court. Vesting such authority in the examiner in opposition to the views of his department head results in conflicting recommendations to the court and in unsound administration. The Commission recommends that the only recommendation on naturalization made to the court should be the one approved by the head of the agency administering the naturalization law, or by an officer designated to make recommendations on his behalf. Neighborhood investigation. Another new provision introduced in the Internal Security Act of 1950 and continued in the Act of 1952 requires a personal investigation of each naturalization applicant in the neighborhood of his residence and employment during the past 5 years. The Attorney General may waive such investigation in any case or class of cases. In the past, such investigations have been conducted in particular cases when preliminary examination has indicated the need for further inquiry. The new requirement that there be such investigation in every case places a tremendous burden on naturalization officials. Moreover, experience has demonstrated that such investigations achieve little or no results to justify the effort and cost, and cause unnecessary delays in considering the naturalization petition. The Commission recommends the elimination of the requirement that a neighborhood investigation be conducted as a matter of routine in every naturalization case. The naturalization officers should be authorized to conduct such investigations whenever they deem them necessary on the basis of information developed in individual cases. Judicial proceedings to establish citizenship. The immigration laws of the United States deal only with aliens, and a person who establishes that he is a citizen of the United States is removed from their sphere of operation. But the claim to American citizenship by an applicant for entry into the United States does not preclude examination by immigration officers in conducting what the Supreme Court called, quote, the preliminary sifting process, end quote, to determine whether a citizenship claim is properly substantiated. Upon an adverse determination, the claimant is barred from the United States. The decision of the immigration officers is subject only to the same limited court review as to legality and fairness of the hearing that prevails in regard to other immigration determinations. Persons whose claim to American citizenship were rejected in deportation proceedings were held entitled to an independent judicial determination of their citizenship status. The Nationality Act of 1940 established a new right to bring an action for a declaratory judgment determining a claim to American citizenship. It provided that a person outside the United States whose application for a passport was rejected could obtain a certificate of identity upon showing that he had a bona fide claim which would enable him to come to the United States for the purpose of prosecuting his action for a declaratory judgment. He also was given a right to appeal to the Secretary of State if he were refused a certificate of identity. See Chapter 11. The Passport Division of the Department of State has supplied the information that since 1945 and through September 1952, a total of 1,346 suits for such declaratory judgment were instituted against the Secretary of State. Of these, 855 claimants came from China, generally involving claims to citizenship derived through American parents, and 491 from other countries, preponderantly involving questions of whether American citizens had lost United States citizenship through expatriation. The administrative authorities have stated that many persons were using the declaratory judgment device as a means of improperly obtaining entry into the United States. However, in such proceedings, courts have often considered only the evidence of the claimant and not the countervailing evidence compiled by administrative officers both here and abroad. The Act of 1952 made substantial revisions in the declaratory judgment procedure in the Nationality Act of 1940. Persons who are within the United States may still maintain an action for a judgment declaring them to be nationals of the United States, except that such suits may not be maintained when the citizenship claim previously was adjudicated in an exclusion proceeding. Persons whose claim to American citizenship is denied by an agency of the United States government, but who are not within the United States, may apply for a certificate of identity to come to the United States to attempt to establish their claim. Such a certificate of identity may be issued upon a finding that the application is made in good faith and is made on a substantial basis. The applicant is entitled to an appeal to the Secretary of State from a denial of application for a certificate of identity. However, a certificate of identity may be granted only to a person who previously has been physically present in the United States, or to a person under 16 years of age who was born abroad to a United States citizen parent. A person who receives a certificate of identity may proceed to the United States and apply for admission at a port of entry, where his status is determined by immigration officers. If such officers rule against his claim to American citizenship, he is entitled to judicial review only in habeas corpus proceedings and not through any other form of action. The fact that some claimants have abused their privileges does not seem to warrant a blanket deprivation of protection to an American citizen who happens to be outside the United States. If there are abuses, such abuses should be corrected. No American citizen should be deprived of his day in court to support his claim against unjustified challenge. The limitations of the 1952 Act will shut off from many American citizens the opportunity to invoke the aid of the courts in resisting erroneous denials of their rights of citizenship. The Commission believes, that there should be opportunity for a full court review on issues of United States citizenship, even where the citizenship claim is made by a person seeking entry to the United States. On such review, the court should consider the evidence available to the administrative officers. End of section 29. Recording by Patrick McHaffie, Merritt Island.
Section 30. Of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information, or to volunteer, please visit LibriVox.org. Recording by Andy Glover. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Part 5, Chapter 17. Additional Matters for Consideration. The brief time at the Commission's disposal made it impossible to give detailed study to many matters brought to its attention during the course of the hearings, and subsequently in oral or written communications. The Commission's primary concern was with broad questions of policy affecting the more important phases of immigration and naturalization. The Commission has made an effort to discuss such other problems as in its judgment warranted treatment in this report. It has collected a wealth of information, most of which is incorporated in the printed record of its hearings. If the Commission's recommendations should be favorably received, the next step will be the preparation of a bill to carry them into effect. The draftsman must then assume the task of designing the legislative details of the recommendations and of determining what, if anything, should be done about the matters which the Commission was unable to reach. The Commission hopes that the President or the appropriate committees of Congress, or perhaps by a joint arrangement, will form a group to draft a bill for early consideration by Congress. The Commission suggests that additional consideration should be given, among others, to the following matters. The role of the voluntary agencies. The great American voluntary agencies have played an important and increasing role in immigration matters. Non-governmental organizations representing the principal faiths in the United States, nationality groups, social service, and civic agencies, and others are taking part in the process of identifying and selecting aliens overseas for immigration to the United States, and obtaining sponsorships and resettlement opportunities for them in the United States. Their activities touch upon immigration at all stages and involve close cooperation with consular officers overseas, immigration and customs officials at the ports of entry, and public and private agencies seeking to aid the effective integration of the new American to his new life. During the past several decades, the American voluntary agencies have been particularly concerned with the problems caused by war. The conclusion of World War II left a vast homeless mass of refugees and displaced persons in Europe. The United States made an important contribution to the solution of this unfinished business of World War II by helping to form the International Refugee Organization, and by accepting a share of such refugees and displaced persons under the Displaced Persons Act. The American voluntary agencies took an active part in providing supplementary food and clothing and other necessities of life for refugees, displaced persons, expellees, escapees, and other victims of the war and post-war upheavals. From this, their interests expanded to the attempt to help with a permanent solution of the problem, both in integration of such persons into the local economies of the countries where they resided, and by immigration elsewhere for a new start in life. Perhaps the greatest flowering of this new and important activity took place in the Displaced Persons Program. In its final report, The DP Story, the Displaced Persons Commission says, "The American voluntary agencies played an indispensable part in the success of the DP program. Without their continuous and active participation, the program would never have been able to succeed. The voluntary agencies were one of the main ways in which recent immigration programs to the United States became instruments of positive, constructive, and humanitarian national policy. In the kind of an immigration policy envisaged by the Commission, the American voluntary agencies must continue to play an increasing role. The precise form of the relationship between the government in administering the immigration law and the American voluntary agencies in providing supplementary and complementary services needs to be developed more fully. The part to be played by the voluntary agencies in connection with overseas selection of prospective immigrants, their transportation, reception, distribution, and resettlement, and the subsequent responsibility within the United States are all important factors for determination. Until some of the issues raised by the Commission's recommendations are resolved, it may not be fruitful to attempt a final determination of these other issues. However, the Commission believes that they are of utmost importance and should be reached as soon as possible. The Commission suggests that in the determination of such questions, the fundamental objective should be the most effective joint utilization of public and private efforts and resources in developing and administering our immigration laws. Investigations. The suggestion has been made to the Commission that the investigating responsibilities of the Immigration and Naturalization Service, particularly insofar as they deal with subversive activities, be transferred to the Federal Bureau of Investigation. As of October 15, 1952, the Immigration and Naturalization Service had an authorized force of 7,204, of whom 907 were assigned to investigations. The Federal Bureau of Investigation has responsibility for the protection of the international security of the United States, except where the entry or deportation of aliens is involved, in which case the Immigration and Naturalization Service has the responsibility. The advisability of placing all such investigative functions in one agency has been discussed frequently. There should be a review of the question of responsibility for immigration investigations, especially in view of the Commission's proposal for a consolidated immigration agency. Migrant labor. One of the most troublesome problems arising out of the administration of the immigration laws concerns the hundreds of thousands of wetbacks who illegally cross the border from Mexico each year. Because of the recent survey by the President's Commission on Migratory Labor, this problem was not studied by the Commission, although some of the witnesses at the Commission's hearings addressed themselves to this question and urged that adequate appropriations be provided by Congress to ensure maximum effectiveness in administering the immigration laws. Procedural problems. Witnesses during the Commission's hearings called attention to particular procedures or requirements, which would seem to be worthy of further study. A few examples are: 1. The requirement that the Immigration and Naturalization Service establish a centralized list of all aliens admitted to the United States. The Attorney General of the United States testified that this requirement would place a heavy burden on enforcement officials. 2. The apparent error pointed out in the testimony of the Immigration and Naturalization Service, by which the Act of 1952 in effect eliminates the proceedings for registry of lawful entry of aliens who entered the United States prior to July 1, 1924, although the new Act continues to provide for such proceedings. This occurred through the enactment of the provision of the Act of 1952, which retroactively made all such aliens subject to deportation, and thus automatically disqualified them from the benefits provided by the registry statute. This error should be corrected. 3. The procedure for selecting persons with special skills in granting preferred status under the established quotas. It was said that this procedure is dilatory and ineffective, and may defeat the purpose for which it is established. The regulations issued by the Immigration and Naturalization Service confirm the prediction of that service to the Commission that this provision would be troublesome and difficult. In this connection, as elsewhere indicated, Chapter 12, the Commission suggests that study be given to the proposals to restore the contract labor prohibition eliminated by the Act of 1952. 4. The provision of the law for rescission, without a hearing, of suspension of deportation previously granted upon a finding that it was improperly granted. 5. The adequacy of notice by publication in proceedings to revoke naturalization or to cancel citizenship documents. 6. The problem of travel documents. The Office of the United Nations High Commissioner for Refugees called attention to the difficulties encountered by stateless refugees or displaced persons who are unable to obtain official travel documents. It was suggested that the United States issue a travel document to such lawfully resident aliens. Legal problems. Certain difficulties may involve constitutional issues. 1. The Attorney General of the United States called attention to the reenactment in the Act of 1952 of a criminal provision relating to transporting into or harboring within the United States of certain aliens, which a United States District Court had declared void for vagueness. He urged that this provision be clarified. 2. The failure to grant a hearing when a deportable alien claims he will be subjected to physical persecution in the country to which he was being deported. It was said that the failure to grant a formal hearing is unfair. 3. The authorization for conducting a deportation hearing in the absence of the alien, if it is found that he unreasonably fails or refuses to attend or remain in attendance at the hearing. Business problems. Various representatives of important business enterprises criticized provisions of the Act of 1952 as being contrary to national commercial objectives in the interest of the United States. 1. Representatives of maritime and airlines brought to the Commission's attention various alleged inequities of the immigration laws in imposing on them obligations for detention and deportation costs, and in subjecting them to penalties for violations of the immigration laws by their passengers. They also called attention to other provisions which they regard as being detrimental to the proper flow of international trade and commerce. 2. Shipping representatives protested the procedure for individual examination of alien seamen under the new law. It was said that this would create additional financial burdens and would unnecessarily hamper maritime operations. The governments of Great Britain and France formally objected to the Department of State that this requirement would cause serious delay in the operation of ocean liners, great expense and deterioration of service to passengers. 3. A new requirement in the 1952 Act apparently requires a $10 fee for each worker who is permitted to enter for temporary work. The Immigration and Naturalization Service pointed out to the Commission that this provision would put a heavy and apparently unintended burden upon employers who import thousands of temporary seasonal workers for timber cutting, fruit and vegetable harvesting, processing, and canning. End of section 30.
Section 31, Of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Larry Wilson. Whom We Shall Welcome. Report of the President's Commission on Immigration and Naturalization. Conclusions and Recommendations. Chapter 18. Conclusions. The Immigration and Nationality Law embodies policies and principles that are unwise and injurious to the nation. It rests upon an attitude of hostility and distrust against all aliens. It applies discriminations against human beings on account of national origin, race, creed, and color. It ignores the needs of the United States in domestic affairs and foreign policies. It contains unnecessary and unreasonable restrictions and penalties against individuals. It is badly drafted, confusing, and in some respects unworkable. It should be reconsidered and revised from beginning to end. Recommendations. Throughout this report are various recommendations appearing in the chapters in which particular subjects are discussed. The more important ones are briefly restated here, without reference to the order in which they appear elsewhere. The Quota System. 1. The national origins quota system should be abolished. 2. There should be a unified quota system which would allocate visas without regard to national origin, race, creed, or color. 3. The maximum annual quota immigration should be 1/6 of 1% of the population of the United States, as determined by the most recent census. Under the 1950 census, quota immigration would be open to 251,162 immigrants annually, instead of the 154,657 now authorized. All immigration and naturalization functions now in the Department of State and the Department of Justice should be consolidated into a new agency, to be headed by a Commission on Immigration and Naturalization, whose members should be appointed by the President and confirmed by the Senate. 5. The maximum annual quota of visas should be distributed as determined by the proposed Commission on Immigration and Naturalization on the basis of the following 5 categories: the right of asylum, reunion of families, needs in the United States, special needs in the free world, general immigration. 6. For the next 3 years within the maximum annual quota, there should be a statutory priority implementing the right of asylum for the admission annually of 100,000 refugees, expellees, escapees, and remaining displaced persons. 7. The allocation of visas within the maximum annual quota should be determined once every 3 years by the proposed Commission on Immigration and Naturalization, subject to review by the President and the Congress. Fair hearing and procedure. 8. Enforcement functions should be exercised under the Commission's supervision and control by an administrator. Quasi-judicial functions should be exercised under the Commission's supervision by a statutory Board of Immigration and Visa Appeals. 9. The same officials should not be permitted to exercise both enforcement and judicial functions. Aliens should be accorded a fair hearing and procedure in exclusion and deportation cases. Hearings in deportation cases should conform with the requirements of the Administrative Procedure Act. Hearing officers should be responsible only to the proposed Board of Immigration and Visa Appeals, which should have authority to exercise final administrative review of their decisions, subject to further review in limited cases by the Commission. Aliens should have the right of administrative review before the Board of Immigration and Visa Appeals from denials of visas, and have a clearly defined method of seeking court review of orders of deportation. Admissions and deportations. 10. The conditions for admission of aliens into the United States should bear a reasonable relationship to the national welfare and security, be definite in their meaning and application, include discretionary authority to waive specified grounds of inadmissibility in meritorious cases, provide for exclusions without hearing for reasons of security only upon direction of the Board of Immigration and Visa Appeals, and not be based on the so-called criminal judgments of totalitarian states. 11. The grounds for deportation of aliens already in the United States should bear a reasonable relationship to the national welfare and security, not be technical or excessive, not be retroactive so as to penalize aliens for acts which were not prohibited when committed, and not require the deportation of aliens who entered the country at an early age, or those who have been residents for such a long period as to become the responsibility of the United States. 12. In connection with the deportation of aliens, there should be discretionary authority to allow them to depart voluntarily instead of deportation, adjust their status within the United States if they are currently qualified to re-enter, suspend deportation under reasonable conditions, and adjust the status of bona fide official defectors from totalitarianism. 13. A resident alien who is not otherwise deportable should not, by reason of a brief absence from the United States, be subject to exclusion or deportation. 14. Unless proceedings for deportation and denaturalization are brought within 10 years, they should be barred. 15. Arrangements should be made to expedite the processing of visas for temporary visitors, including leaders in art, scientific, and business fields. And the law should apply to such non-immigrant aliens only such restrictions as are directly concerned with the health, safety, and security of the United States. Security. 16. The security of the United States should be protected by continuing to bar the entry of spies and saboteurs. Aliens who are present members or affiliates of any totalitarian party, including communists, Nazis, and fascists, should be denied admission into the United States except where their membership is involuntary, or affiliation is not knowingly or willingly to further the aims and principles of such parties. They should be deported except where they entered the United States at an early age or have been residents for such a long period of time as to have become the responsibility of the United States. Aliens who are former members or affiliates of any totalitarian party may be admitted provided they have repudiated and are now opposed to such totalitarian ideologies, and the responsible administrative officers make a finding that the admission of such aliens would not be contrary to the public interest. They should be deported unless they have repudiated such doctrines for at least 5 years. Citizenship. 17. The law should not discriminate against naturalized citizens, but should place them in the same status as native-born citizens, except where citizenship was procured by fraud or illegality. The law should minimize or remove restrictions which create statelessness, disrupt family unity, or impose unreasonable conditions or procedures upon the acquisition or retention of citizenship. End of section 31. Section 32 of Whom We Shall Welcome. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Larry Wilson. Whom we shall welcome. Report of the President's Commission on Immigration and Naturalization. Appendix 1 and 2. Additional views of Adrian S. Fisher. Order creating the Commission. Additional views of Adrian S. Fisher. I concur wholeheartedly in the policy recommendations in the report of the President's Commission on Immigration and Naturalization. I believe that their prompt adoption would be in the interest of the United States, both in the conduct of its foreign relations and in the continued vigorous growth and development of its economy and its society. However, in only one small aspect of the report, that dealing with the administrative arrangements for the issuance of visas overseas, I cannot see eye to eye with my colleagues. The report proposes to set up, in effect, another separate foreign service by authorizing the Administrator of Immigration and Naturalization to set up visa offices overseas as part of the unified program. In view of the importance which the report places on the foreign policy of the United States, a view in which I wholly concur, I cannot see what is to be gained by separating the administration of the proposed program from the agency which is charged with the administration of the foreign policy of the United States. It may well be that the Department of State is subject to legitimate criticism in its activities under the present system for not having paid enough attention to the foreign policy aspects of the administration of the visa issuing function. But in my judgment, the remedy for that defect is not to be found in divorcing it entirely from this function. It may well be true that in its administration of the visa function overseas, the Department of State has relied excessively upon experts, that is, persons who spend a large proportion of their time doing nothing but visa work. If the Department, however, has erred in this respect, this tendency should be corrected, not accentuated, and the participation in the visa function of officers who have an overall responsibility for the conduct of foreign relations should be encouraged, not made impossible. The same can be said with reference to the problem of placing an additional group of United States officials in foreign countries to represent the United States of America. I am aware that my colleagues are led to their concept of administration by the view that a visa, once issued, should be final and not subject to review at the port of entry except for identity, physical condition, and security status. From this they deduce the maxim of no responsibility without authority, the conclusion that the visa issuing function must in turn be under the proposed commission. I wholly agree that a visa once issued should be final and not subject to review at the port of entry except for identity, physical condition, and security status. I wholly agree also that there should be an independent commission on immigration and naturalization. I am completely in accord with the recommendation that there should be a formal procedure for review of consular decisions with respect to visas. However, I do not agree that these desirable ends require that persons other than consular officers should issue the visas. I am reinforced in this view by the fact that in over 200 Foreign Service posts there is not an adequate workload of visa cases to justify the establishment of a separate visa office. My examination of the statistics show that almost 50% of all visas are issued in posts of this kind. The proposed solution, that is to have the consul, in effect, act as a hearing officer but without any power of decision, even in a clear case, does not seem to me to be a satisfactory one. Certainly it does not seem to be satisfactory to have two separate systems, one disposing of 53% of the visas and the other disposing of 47%. I believe the proposed commission should avail itself of the very real advantages of using the Foreign Service to accomplish its requirements abroad, as do some 45 United States government agencies at the present time. The proposed commission would thus have a widespread, flexible operating service with the particular advantage of utilizing its broad experience in foreign affairs. This experience will be invaluable in evaluating the intent of the alien and his social, economic, and political background, and in estimating the effect of the alien's admission to the United States upon our foreign relations and domestic security and development. The proposed commission would have the same responsibility and authority, the same freedom in the issuance of subjective guidance and direction as it would enjoy with its own employees. It could now participate with other government agencies under procedures now established under the Foreign Service Act of 1946, in the selection, training, assignment, and promotion of foreign service personnel, and could participate in the day-to-day administration of the service by the Department of State to the extent necessary to meet its requirements. Except for this single administrative detail, I am in complete accord with the Commission's conclusions and recommendations. Order creating the Commission. Executive Order 10392, establishing the President's Commission on Immigration and Naturalization. By virtue of the authority vested in me as President of the United States, it is hereby ordered as follows. Section 1. There is hereby established in the Executive Office of the President a commission to be known as the President's Commission on Immigration and Naturalization, which shall be composed of a chairman, a vice chairman, and 5 other members, all of whom shall be designated by the President. Section 2. The Commission is authorized and directed to make a survey and evaluation of the immigration and naturalization policies of the United States, and shall make recommendations to the President for such legislative, administrative, or other action as in its opinion may be desirable in the interests of the economy, security, and responsibilities of this country. The Commission shall give particular consideration to a. The requirements and administration of our immigration laws with respect to the admission, naturalization, and denaturalization of aliens and their exclusion and deportation. b. The admission of immigrants into this country in the light of our present and prospective economic and social conditions and of other pertinent considerations. And c. The effect of our immigration laws and their administration, including the national origin quota system, on the conduct of foreign policies of the United States, and the need for authority to meet emergency conditions such as the present overpopulation of parts of Western Europe and the serious refugee and escapee problems in such areas. Section 3. In performing its functions under this order, the Commission may prescribe such rules of procedure and may hold such public hearings and hear such witnesses as it may deem appropriate. Section 4. All executive departments and agencies of the federal government are authorized and directed to cooperate with the Commission in its work and to furnish the Commission such assistance, not inconsistent with law, as it may require in the performance of its functions. Section 5. The expenditures of the Commission shall be paid out of an allotment made by the President from the appropriation entitled Emergency Fund for the President, National Defense, in Title I of the Independent Offices Appropriation Act 1953, Public Law 455, 82nd Congress, approved July 5, 1952. Such payments shall be made without regard to the provisions of a. Section 3681 of the Revised Statutes, 31 U.S.C. 672, b. Section 9 of the Act March 4, 1909, 35 Statute 1027, 31 U.S.C. 673, and c. Such other laws as the President may hereafter specify. The members of the Commission shall receive such compensation and expense allowances, payable out of the said allotment, as the President shall hereafter fix, except that no compensation shall be so fixed with respect to any persons while receiving other compensation from the United States. Section 6. The Commission shall make a final written report to the President not later than January 1, 1953, including its recommendations for legislative, administrative, or other action. The Commission may also make such earlier reports to the President as it may deem appropriate. The Commission shall cease to exist 30 days after rendition of its final report to the President. Harry S. Truman, The White House, September 4, 1952. Statement by the President. I have today established a special commission on immigration and naturalization to study and evaluate the immigration and naturalization policies of the United States. Our immigration and naturalization policies are of major importance to our own security and to the defense of the free world. Immediately after the war ended, we recognized the plight of the displaced persons. We acted to cooperate with other nations and to admit a share of these victims of war and tyranny into our own country. The Displaced Person Program has now been successfully concluded, but the free world faces equally grave and equally heart-rending problems in the continual stream of refugees and escapees from the Iron Curtain countries into Western Europe. These peoples add to the pressures of overpopulation in certain countries. Overseas migration from Europe has been dammed up by years of war and international economic disorder. While we have joined with other nations to meet such problems as these, our own immigration laws, based on conditions and assumptions that have long ceased to exist, present serious obstacles in reaching a satisfactory solution. Humanitarian considerations, as well as the national interests, require that we reassess our immigration policies in the light of these facts. The United States must remain true to its great traditions and have an immigration policy that strengthens our nation at home and furthers our world leadership. The 82nd Congress devoted much time and effort to this problem, but the bill which it passed was so defective in many important provisions that I could not give my approval. In my veto message, I expressed the hope that the Congress would agree to a careful re-examination of the entire matter. I suggested that the Congress create a representative commission of outstanding Americans to make a study of the basic assumptions of our immigration policy, the quota system, and all that goes into it, the effect of our immigration and nationality laws, and the ways in which they can be brought into line with our national ideals and our foreign policy. The Congress did not act upon these suggestions. I do not believe that the matter should remain where the Congress left it. The problems of immigration policy grow more pressing, and the inequities fostered by the new law require careful examination. I am therefore appointing this commission in the belief that its recommendations will enable the next Congress to consider the subject promptly and intelligently. The commission will have the benefit of much information already drawn together in the field of immigration, including that developed by the committees of Congress in their long study of the problem. It should therefore be in a position to complete its study before the reconvening of the next Congress. I have directed the Commission to give particular consideration to a. The requirements and administration of our immigration laws with respect to admission, naturalization, and denaturalization of aliens, and their exclusion and deportation. b. The admission of immigrants into this country in the light of our present and prospective economic and social conditions and of other pertinent considerations. And c. The effect of our immigration laws in their administration, including the national origin quota system, on the conduct of foreign policies of the United States, and the need for authority to meet emergency conditions such as the present overpopulation of parts of Western Europe and the serious refugee and escapee problems in such areas. The members of the Commission are as follows: Philip B. Perlman of Maryland, Chairman, formerly Solicitor General of the United States, formerly City Solicitor of Baltimore, Secretary of the State of Maryland, Assistant Attorney General of Maryland. Earl G. Harrison of Pennsylvania, Vice Chairman, Attorney, formerly United States Commissioner of Immigration and Naturalization, and formerly Dean of the Law School of the University of Pennsylvania. Monsignor John O'Grady of Washington, D.C., Secretary, National Conference of Catholic Charities. Reverend Thaddeus F. Gillickson of Minnesota, President, Lutheran Theological Seminary of St. Paul, Minnesota, Chairman, Minnesota State Displaced Persons Commission. Clarence E. Pickett of Pennsylvania, Honorary Secretary, American Friends Service Committee. Adrian S. Fisher of Tennessee, Legal Advisor to State Department, formerly General Counsel of Atomic Energy Commission, and Solicitor of the Department of Commerce. Thomas G. Finucane of Maryland, Chairman, Board of Immigration Appeals, Department of Justice. End of section 32.